Well, good morning. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for 2022-23 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Home Affairs and Attorney-General's portfolios. The committee has set Friday the 20th of May 2022 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday the 15th of April 2022. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of giving evidence to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement which meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest which could result from the disclosure of the information or the document. Mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the budget estimates 2022-23 hearings are conducted in a COVID-safe way. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with COVID safety requirements, senators and the Secretariat may use their electronic devices to communicate with one another during the hearing. We ask witnesses forbearance to do so and apologise in advance for any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I would like to welcome Senator the Honourable Amanda Stoker, representing the Minister for Home Affairs, Minister for Emergency Management and National Recovery and Resilience, and Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs. Welcome.
Thank you.
I now call officers from the Department of Home Affairs in relation to Outcome 2, which is in continuance from our hearing on Thursday. Mr Bozzolo, a very good morning to you.
Madam Chair, good morning.
We will now move to questions from senators, and I give the call to Senator Keneally.
Thank you, Chair.
Kicks off, can I just confirm which outcome are we working on at this point?
Outcome 2.
Outcome 2. Thank you.
We
Very
are
good.
in continuance from Thursday.
That's wonderful.
Thank you.
Thank you. And thank you, Senator Keneally, for your patience there.
Thank you, Chair. Thank you, Mr. Pizzullo and the department. Chair, I do flag I have a few quick questions that I can anticipate may well fall more properly under a cross-portfolio, but given they relate to a story that broke on Friday night, and given the seriousness of the story, I would ask for some indulgence to at least ask the questions to the witness, who I think may be placed to answer them.
What's the nature of the question, Senator Keneally?
There was a story on Thursday night of a public servant accused of child sex offences given a secret security clearance to work in Indonesia, and this person was a employee of the Department of Home Affairs. And I just have a few straightforward questions in relation to that.
I think that seems reasonable. Mr. Pizzullo, you've got no issue with that?
I'm entirely agreeable.
No.
I think it's important that the record is set straight.
Yeah, thank you. Just to remind all senators that we are going to be operating in blocks of 10 minutes. We need to stick strictly to those 10-minute blocks, and we are moving to Attorney Generals after lunch, so we do need to stay to our program. Thank you very much, Senator.
Thank you, Chair. So, as I've said, Mr. Pizzullo, there was a story on ABC News, no doubt you're aware of, that said an Australian public servant had been investigated for child sex offences who was given a high-level security clearance before working for the government overseas. If you need a copy of the article, I can provide it. But can you confirm this person was or is a Home Affairs staff member?
The person in question is an employer of the department.
And was anyone in the department aware of the allegations when he joined the Department of Home Affairs?
I'm quite confident the answer is no, but the Chief Operating Officer, who also is responsible for issues around misconduct and related matters, Ms Saunders, I'd ask her to join me at the table and she can give you a more definitive answer. Ms Saunders.
Madam Secretary, morning to Senator. Justine Saunders, Chief Operating Officer. Secretary, Senator can confirm we didn't have visibility of the particular allegations which are now the subject of court proceedings until the officer was actually deployed offshore. Until he was deployed offshore. And at that point, once you became aware of the allegations, what steps did you take? Obviously, we worked very closely with AFP, knowing they had lead of the criminal investigation, and following their guidance, there was the officer, upon returning to Australia, was criminally charged and at that point was suspended. Right. So, was the department made aware of the allegations through the security vetting process? No, Senator became aware of it as a result of AFP criminal investigations and their approach to us. And so I take it from your answers the department was not aware of the allegations when the decision was taken to send the staff member to Indonesia? That's correct, Senator. We weren't aware of the allegations until the officer was actually deployed in Indonesia. Right. The concern I have here is that this person was subject to a security clearance process that appears not to have detected this, or detected might not be the correct word, appears not to have become aware of these allegations. Is the department taking any steps to investigating how that occurred? My understanding, Senator, is that allegations were not known to any official agency until much later. So at the time, if you note that obviously when someone seeks an employment security clearance, it's a point in time, and obviously we explore all holdings as it relates to that, relevant holdings as it relates to that individual. There were no holdings which would suggest that the individual was the subject of any allegations at that time. And just so we are clear, the person in question is currently suspended from the department. That's correct. And he has been charged with a number of historical child sexual assault offences, and that matter is before the court. That's correct, Senator. And his suspension will remain in place, I presume, until those court matters are resolved. It'll be on continual review, Senator, until the conclusion of the proceedings. Obviously, as additional information comes to light, we'll consider that as a matter of course.
And again, just to be clear in my own mind, if I understand your evidence correctly, the department became aware of these allegations because the AFP was investigating them.
That's correct.
Okay. Thank you very much.
Thanks, Senator.
Thank you, Chair, for the indulgence. Chair, I believe Senator Grogan wanted to follow up one matter in outcome 1, and then after that I might flag that the Labor opposition would be prepared to go to outcome 2, but I do think Senator Grogan has a question.
Yes, so
Follow-up.
Senator Grogan, we arranged for the department to come back in relation to the outcome 1 questions, if
Yes, thank you.
which I hope that you'll be ready to answer,
We are,
Mr. Pizzullo.
Madam Chair.
And I will give the call to Senator Grogan, but only for the remaining 10 minutes.
Well, I
I'm in the
think
10-minute
probably in the interest of time, would you be able to table the answers to those questions that were provided in a written form to you last week?
Quite possibly, Mr. Ablon.
We can do that.
That would be lovely. Thank you very much.
We can do that.
Yeah, and you can table those today?
Yes.
Fantastic. Thank you so much.
Thank you very much, Senator Grogan. Senator Keneally, do you have any more questions?
Not for outcome 1. As I said, indicated Labor senators are prepared to move to outcome 2.
All right. Well, look, we might now go to other senators, and Senator Antic is seeking the call. I'll give the call to Senator Antic.
Thank you, Chair.
Just 10 minutes max.
Yep, that's fine.
Thank you, Senator.
Thank you. This is a question in relation to border control, immigration. Just interested, at the moment, I understand it's the case that if you're an Australian citizen or a permanent resident, you can't actually leave the country unless you're fully vaccinated, whatever the current definition of that is. Foreign citizens are allowed to depart at any time. It's a direction under the Biosecurity Act, I believe, but I was just wondering if you could explain the rationale for that.
To the extent that there are any ongoing prohibitions that flow from the Biosecurity Emergency Declaration that Mr Hunt is responsible for and which is announced will be lifted effective the 17th of April, its rationale is a matter really for the Health Department and the Health Minister. He makes that decision. We enforce it, we collect the information, we ensure that both inwards and outwards border management is conducted in accordance with those determinations. But Senator, you ask about the rationale. That's a public health issue. I direct you to the Health Minister and the Health Department.
Does the Department have any concerns about that sort of measure being imposed? It seems quite...
It's not really for us to have concerns. Our job is to implement government policy and decisions of ministers. I should, Madam Chair, just before perhaps the Senator continues to go down this line of questioning, the actual day-by-day border management is really a matter under Program 3.2. It's the ABF's responsibility to either enforce or ensure that biosecurity directions are adhered to. Yep. I'd really prefer for the Border Force Commissioner to be available. Notwithstanding, even if Mr Outram was here, I don't think there's very far we can go in terms of rationale or, if you will, giving the public health reasons as to why that measure's in place. That's really a matter for our colleagues in the Health Department.
Thanks, Mr Pizzullo.
Happy to direct those questions.
Senator Antic, do you have any other questions?
No, I'm happy to direct those questions to ABF. Thank you, Chair.
All right, thank you very much, Senator Antic. We will now move back to Labor senators. Senator Keneally?
As I indicated, and we're prepared to go to outcome 2.
We're in outcome 2.
Oh, we have moved. I apologise.
Yeah, we are in
I
outcome
was
2
just
now.
actually sending you a message, Chair,
Oh.
to say this is the...
No, we are in outcome 2,
Great,
but we
thank
just
you.
went back to outcome 1 to accommodate Senator Grogan's questions, which have been tabled.
Thank you. All right. Well, I do have some questions relating to the Mariguppin family. So just if you do need to bring anyone to the table,
Yes,
Mr. Pizzullo.
Just recalling always, Senator, that under outcome 2, their status resolution is a matter for the department. The conditions of their detention is a matter for the ABF. But Ms Moy on the Mariguppin family, perhaps she might attend. Otherwise known as the Biloela family, I think, just for the sake of the Hansard record. Thank you, Ms Moy. Thank you, Senator.
And thank you for that. reminder, my questions do go to status resolution. So, in fact, I've got here some correspondence that's been passed on to me from Fiona Martin, the member for Reid, and I'm happy to table it. She says that I do not believe it is sustainable for the government to continue to provide temporary solutions to this matter. I'm of the position you should exercise your ministerial direction and allow this family to stay permanently in Australia and return to Biloela. How many Liberal and National MPs and senators have written to either the department or the minister asking for the family's release back to Biloela?
Cheryl Ann Moy, Deputy Secretary, Immigration and Settlement Services Group. Senator, I'd have to take that on notice in terms of how many representations we've had from those parties.
Thank you. If possible, I would like to ask if that could be done today, given that we are in our last hours of Senate estimates. Minister, are you aware of any Liberal or National MPs or senators who've requested that the government deliver a permanent home back in Biloela for the Murugappan family?
I recall there being some reports in the media some time ago. I don't have specific knowledge, but I can take that on notice.
Have you ever made a representation asking the family to be allowed to go home to Queensland?
No.
Thank you. I also wanted to ask if anyone at the table, the Minister or the Department, has congratulated, either privately or publicly, the women of Biloela and Priya Murugappan for their selection as Marie Claire's Women of the Year.
I won't speak for the Minister. I wasn't aware of the award, but I'm sure that it's well deserved within the criteria of the award. But Ms Moy, are you aware
No, not
of
aware,
said award?
Senator.
I confess my reading doesn't often include Marie Claire, but perhaps it should.
I
quite
must
an
confess I don't know
amazing
what Marie
story.
Claire is. But
It's a women's magazine.
sorry, I'm just not aware of it.
Not just for women.
I'm happy to accept that Marie Claire may have some non-female readers.
It's a beautiful cover photo of Priya Murugappan and a quite touching story about the campaign run by women in Biloela to see the family returned home.
Well, I congratulate her on winning that award.
The government recently accepted an offer from New Zealand to resettle people who are in Nauru and in Papua New Guinea, and potentially people who are currently in Australia. You may forgive me for saying this, but it did look, after years of saying such a deal would restart the boats, both the Prime Minister and the former Minister for Home Affairs have made that claim repeatedly. This agreement on the eve of an election could be interpreted as a move to respond to concerns expressed in inner city Liberal seats like that of Reid. Are there any considerations of granting a permanent or other visa to the Murugappan family before we go into caretaker to allow them to return home to Biloela before the election is called?
So the status resolution part of the equation relates to a permanent outcome. It's the department's position, it's been litigated many times that they're not owed protection. In other words, they haven't been able to advance claims of a well-founded fear of persecution. So that's on the permanent side. And so the granting of a protection visa turns on under the Act.
I'm not asking about a protection visa.
So this is about a visa.
A visa that would allow either them to stay here permanently or at least allow all 4 members of the family to go back to Biloela. Because as I understand it, right now, the thing that is anchoring them in Perth is that the youngest child does not have a visa that allows her to go
Correct.
to Biloela.
So
Is there
the-
any consideration before the government goes into caretaker of granting a visa, permanent or otherwise, that would allow the family to return to Biloela?
The department's not in the process of providing advice that would favour either outcome. I dealt with the protection visa in my earlier comments. There's no other permanent visa that could be somehow bestowed, because there's got to be a basis for a minister or a delegate to bestow a visa, a skill visa or a partner visa or any other form of permanent visa. In terms of their residential location, that is a different question, and that really turns on decisions taken by the minister on advice about their, if you will, temporary status resolution, about where they reside. And unless Miss Moy has got more information than I have, there's no contemplation of changes in either permanency or their temporary residential location. But Miss Moy, can you add to that, please?
So just confirming that that's correct, we've got no considerations at this point in time in terms of changing locations or altering current situations such that the family could return to Biloela.
Thank you. Thank you very much.
Thank you very much, Senator Keneally. Senator Van, I know you were keen to ask some questions about Ukraine situation. Do you want to ask? Go to you now.
Give me a moment. Apologies. I think we touched on some of these last week, but can you, Mr Secretary, explain what the government is doing to support Ukrainian displaced persons arriving in Australia?
We touched on this to some extent last Thursday, but Ms Moy and her staff might be able to add more. For the moment, in the interest of expediency, persons are being granted visitor visas or equivalents. They can get here as quickly as logistics allow. The government's announced that once here, they're eligible for a 786 temporary haven visa, and that allows for a number of support services to be wrapped around the families, noting that there are a lot of family connections in many cases, and the Ukrainian Australian community in any event is opening its doors, as it were, opening its homes. We've got Mr Woolden here and Ms Moy. We gave some evidence last week. Is there any more information that we can take this opportunity to lay before the committee, Mr Woolden?
Certainly. Just in terms of there's a range of services available that are dependent on the visa category which people are on. So the restrictions, obviously, of a visa in relation to work is a challenge. This will be lifted in stages based on the visa category, and there's two stages to this process. The first is moving people off their current visa onto a 449, which is a precursor to the 786. Currently, children can go to school and services are being provided as requested. We've got some great service providers in the States who do our normal humanitarian settlement programs. So strictly speaking, they're not contracted to, but they are stepping in to assist Red Cross and other charities as required. The numbers of people requesting assistance at the moment are fairly small because people have sort of arrived. They generally have links to Australia, so we'll be staying with family, friends, etc.
Yep.
We'll be going out in two stages. The first is obviously we have to do a bar lift process under 91K of the Migration Act to enable them to be given a 449. Once they get their 449, they'll have work rights.
Yes.
And then the next step, which follows very quickly because the checks we have to do at the 449 stage are just around national security, so that the standard character checks. Once they're done, we do the grant and then immediately go back to say, would you like the 786? We anticipate there'll be a fair number will say yes to that because for those who aren't planning on going home soon, they want to settle into a more normal routine.
Yes.
When the 786 is granted...
Sorry, just for clarity, for the record, what's a 786?
So the 786 is a short-stay humanitarian visa. It's a temporary visa, but it comes up to 3 years, the Minister has agreed to. It's The visa itself doesn't have a prescribed period, but the Minister has said up to 3 years for Ukrainians who wish to go down that path. So again, they get their 449. We then do a subsequent bar lift for those who say, yes, I would like a 786. We do the checks required. One of those, there's a mandatory health check at that point. That's obviously around communicable diseases to protect Australia, and also just to make sure that people are in good health and they can access. Then the grant of the 786. When they have a 786, they pretty much have access to the same services as a normal offshore protection arrival, someone who's been granted protection, which has work rights, healthcare, access to education.
Thank you. And do you have a rough sense of the time period for those steps?
These steps, we just finalised policy with the government last week, so the steps for this process, noting some of this is in the hands of the applicant, so they will, once we go to them, we don't know how long they'll take to come back, how long they'll take to get their health checks, but it's not unreasonable to think within a 2-week period we can get through most of those steps.
Wonderful, that's great news. You mentioned the community and how much the community have stepped up to help friends and family that are fleeing the Russian conflict. I understand that the government through the department has granted money to the community organisations, is that correct?
That's correct, $450,000 to the peak body for the Ukrainian community, and that's really just in recognition of the fact that there will be people who will reach out to them in the first instance for support, and that just gives them a little bit of capacity to provide that support if it's, clothing, those sort of things where people did leave in a hurry, obviously, and if they're going to be here for some length of time. It enables them to have a cash flow to assist as necessary, and also to point them to all of the right services. A lot of people are taking time off work to assist with the settlement, and that's sort of in recognition of that.
And dealing with that organisation each and every day, I know they're very grateful for that. So thank you for all that assistance. Thank you, Chair.
Thank you very much, Senator Van. I'll now give the call to Senator McKim, who is attending via video conference remotely. Senator McKim, welcome.
Thanks, Chair. Can I just check that folks can hear me okay?
Yes, we can hear you loud and clear. We can see you. We like the penguins on the wall. And the call is yours.
Oh, thank you. It's a painting by my late mother-in-law, if anyone is really... It is a lovely painting.
It is.
Could I just start? I wanted to ask some questions about the folk that are still currently imprisoned in Park Hotel. So firstly, could Mr. Below, one of your officers, please inform the committee how many people are still imprisoned in Park Hotel?
In terms of persons who are detained, Ms Moy, if you have the numbers, if you could give evidence on that issue, please.
Thank you.
Secretary, I might just hand to Ms Jones, who's...
so Ms Jones, head of our Status Resolution Division, can give you the latest numbers. And you're specifically interested... I'm sorry, Ms Jones. Did you say the Park Hotel?
Yes, that's right.
I'm sorry, and you're not on the screen in front of me, so my apologies. I'm sort of looking over towards you and I can see the penguin shot as well. So, Senator McKim. Ms Jones.
Good morning, Senator. Justine Jones, First Assistant Secretary, Status Resolution and Visa Cancellation Division. In terms of the transitory persons who are remaining in held detention as of today, there is 31 people remaining in held detention. I don't have a split of location.
So is the Park Hotel a subset of that group?
That's exactly right,
So, Senator,
yes.
31 was the evidence across the network, and we'll have to get you the number for the Park Hotel, which I suspect we could do reasonably promptly.
I should be able to do that this morning.
I expect the ABF will have that figure.
Okay, thank you. Do you have a breakdown of how many are in hotel detention versus other immigration detention facilities? So immigration detention versus what you would call an APOD?
Now, as I said, Senator, I don't have a split by location within the detention network in front of me at the moment, but I can do that.
Thank you. I appreciate if you're able to source that as soon as possible. That would be helpful. Thank you. There was a group of people released just after we had our estimates on Friday. can you just confirm the numbers that were released and from where those folk were released? That was Friday evening,
Yes, certainly.
last Friday evening.
Yes, Senator. The 1st of April, there was 19 people released as they were granted final departure bridging visa ease. 16 of those people were in Victoria, 2 in Queensland and 1 in New South Wales.
And do you have a breakdown of facilities from which they were released?
No, I don't have any data in front of me about location within the detention network.
It might assist Senator McKim. Location is dealt with by the ABF. So the way we split it is that Ms Jones's area looks after the visa, their status legally, and our colleagues in the ABF manage location. I'm sure that the Commissioner and his officers, when they appear under Outcome 3, given your advanced notice in the form of this question, will have that data. If not to hand, I'm sure they could promptly get it.
All right, I appreciate that. Thanks, Mr. Pizzullo. Ms Jones, you and I spoke at a previous estimates about the process by which the department engages with the minister on issues around ministerial briefs and ministerial interventions. And I'm specifically asking here in relation to the cohort of people that you would call transitory people.
Senator
Can you...
McKim, sorry, Senator McKim, I apologise for interrupting, but just to the cameraman in the room, I believe a cameraman from Channel 9, if you could please not shoot any papers on the desk, just faces only, please. So, thank you. Sorry about that, Senator McKim.
That's fine, thanks, Chair. Ms Jones, is there either a ministerial brief or a ministerial intervention that is currently with the minister in relation to any transitory persons?
I believe there is a brief with the minister currently.
Okay, and that's, just to be clear, that's a brief as opposed to a ministerial intervention?
No, it is a submission in relation to ministerial intervention for decision.
All right, thank you. And how many... I'm sorry, I just missed the last thing you said.
For decision.
Oh, thank you. And how many people are covered in that brief?
I believe it is around 25. I'd have to confirm that number.
All right, and when was that put up to the minister?
That was put up to the minister last week, I believe, but again, I'd have to confirm that.
All right, thank you. And the brief for ministerial intervention, which was responded to by the minister, which provided for the release that we were just talking about last Friday, when did that go up to the minister?
I would have to confirm the date of that, but I believe it was the week before.
Okay.
Around,
so
it's approximately, I'd have to confirm that.
Appreciate that, Ms Jones. I won't hold you to a specific number of days, but sometime around a week or so for the minister to make a decision, and another brief has gone up with 25 people. Are you, last week, are you able to provide a breakdown of either by state or facility where 25 people currently are?
I think I'd have to, I don't have that material before me, and I'll have to take that one on notice.
It would be, Senator, a subset of the group that we spoke about earlier. So the 31 that we spoke about earlier, the 25 is a subset, is it not, Ms Jones?
Correct.
Yep. So, Senator, we've flagged that with our ABF colleagues, we'll give you as much information as we can on location breakdown.
Thank you.
The 25 are a group within the 31.
And if I can clarify, sorry, Senator, the group, the ABF will not be across the cases that are currently before the minister, because that's my responsibility. So I'll have to look into that separately.
Yep. Thank you.
All right, thank you. Well, if you're able, I think Mr Pizzullo might have offered that you'll attempt as soon as possible, potentially this morning. So if that is possible, I'd appreciate that, Ms Jones. Thank you.
To liaise with the ABF. Let's do that.
Mm-hmm.
Yeah, all right, I do appreciate that. Thank you. So, Ms Jones, given that You've told us that there are 31 people 31 transitory people, and that's the total number, I take, of transitory people that are currently in held detention in Australia?
That's
right?
correct.
So everyone else who is a transitory person in Australia is in what community detention?
The remaining the cohort will either be on bridging ease, final departure bridging visa ease, or in residence determination, so community detention.
Yeah, but if you're on a final departure bridging visa E, you're in community detention, are you not?
No, they're two separate categories. So people on a visa are essentially a lawful visa holder in the community, whereas people under residence determination arrangements are, strictly speaking, still detained, but they are detained in a community setting with support provided by the department and freedom of movement.
I understand. So I'm specifically, maybe to get our terminology right, there are only 31 trans persons currently in Australia who do not have freedom of movement. Would that be accurate?
There's 31 transitory persons remaining in a held detention setting. That's correct.
And every other transitory person in Australia currently has freedom of movement. Is that correct?
You might
Yes,
explain
the
to
residence
Senator-
determination
yeah, you might explain what
it
that
does
entails.
is still, as I said, strictly speaking, they're detained, but the minister has intervened that they are detained in a community setting. So there's
That's right.
still conditions in relation to their detention. And as I said, the department provides support, healthcare and the like to that cohort.
Yeah, but they're not locked up, are they?
No, they are living in properties in the community.
All right, thank you. I appreciate that. So we've got 31 transitory persons only in held detention, and a brief for ministerial decision covering approximately 25
yeah.
of those people was put up to the minister last week, which would leave 6. Are you able to inform the committee why there are 6 that are not covered in that brief? Is that simply just a matter of processing in tranches, or do those 6 people have other considerations?
Well, look, we're
meant that
starting.
they were not included. I'll just finish, Ms Jones. Were there other considerations which meant that those 6 people were not included in the brief?
Last question, Senator McKim.
Look, there's various reasons, and we're starting to talk about quite small numbers, Senator, so I'm reluctant to get into too much detail, but if I can talk generically, there will be some perhaps that the minister has already considered and declined to intervene, or there may be other reasons why at this point the cases haven't been put forward to the minister. But again, very small numbers, and I think you'll appreciate that if we start to, when there is only a small number of people left, and this will go to the issue around location as well, when there's only a very small number of people remaining, it would actually be it will be possible to identify people, I think, by divulging too much detail about that remaining group.
Thanks, Ms Jones. We now do need to move to other senators. Thanks, Senator McKim. I give the call to Senator Scarr.
Thank you, Chair. I had some questions in relation to the status of US resettlement of transitory persons, and also the positive steps that have been made in relation to New Zealand resettlement negotiations. So,
Just need to change out witnesses.
Yep.
Do you have Ms Sullivan here? No, I don't. Okay. I was going to give her a run.
Okay, thank you.
There's no substitute for experience, you see.
This is true.
So could you provide an update with respect to progress of resettlement in the US under the resettlement arrangements with the United States Government, please, of transitory persons?
Certainly, Senator. Mark Ablong, Deputy Secretary, Strategy and National Resilience. As of the last counting date, which was the 31st of January, 993 individuals have resettled in the United States. We are just about at the 1,000 mark as of today, but I don't have the exact figure for today, approximately 230 individuals have received notification of provisional approval from the United States but are yet to leave.
Okay, so the original number, what was the original number flagged for US resettlement?
1,250.
Okay, so if you add together those who've successfully been resettled and the ones who've received provisional approval and are going through the end processes, you're nearly at the 1,250.
That's
Is that correct?
Senator.
Okay. So when will the next uplift? When do you expect the ones who have been provisionally approved, transitory persons who've received provisional approval, if everything goes according to plan, which presumably sometimes it doesn't, but if they do go through the process in the usual course, when would you expect the next uplift to occur in those 230 or whatever the figure was to be resettled in the US?
Senator, they tend to leave in small groups as opposed to a large group like 230.
Yep.
And that's dependent upon them passing final health clearances from the US system. So, they'll need to have been vaccinated and various other medical checks are done. So we would expect to have another group leave during the course of this month.
Yep.
And that will continue during the course of probably the rest of the year as they go through the various processes that they need to.
Okay, so there'll be multiple uplifts of small numbers as they go through the process. If everything goes according to plan without any hiccups, when would you expect the 1,250 figure to be reached in terms of resettlement numbers?
It's our expectation that will be reached during the course of this calendar year, but there are so many variable factors that I wouldn't give you a specific date or even a month when that might occur.
Okay, excellent. And then could you give us an update with respect to arrangements for the New Zealand resettlement options of transitory persons?
So, Senator, the agreement that was reached on the 24th of March between Australia and New Zealand allows for the resettlement of refugees under our current regional processing arrangements. So that covers those people who are currently in Nauru or who are here in Australia for temporary medical reasons. Refugees will be considered for resettlement if they meet New Zealand's refugee quota program requirements, are referred to New Zealand by the UNHCR, and are not already engaged in another third country resettlement pathway. So if you're in the US resettlement program, you're not considered for the New Zealand resettlement program.
Okay, so if I, say, have provisional approval to go to the United States, the advice which the department has given is I shouldn't try and get into the New Zealand pathway if I've got that provisional approval. Is that correct?
That's correct. You'd be ineligible for the program.
You'd actually be ineligible.
That's correct.
Okay. All right. So again, when would you reasonably expect? And I'm not seeking to tie you to a date, but in terms of you must have your own planning purposes. When would you reasonably expect that resettlements would commence in effect, in practice, in New Zealand under the arrangement?
Senator, that's a matter for the New Zealand government because it's their resettlement program. We will support and assist them to both examine the case files for the individuals, support the UNHCR in those referral processes, and then the New Zealand government will do what most governments do, which is go and interview the individuals and then run their own set of checks for health, security and other matters. So we certainly expect that there will be some resettled in New Zealand this calendar year, but how long that process takes is a matter for the New Zealand government.
Right, but it's correct to say, isn't it, that the agreement's for 150 refugees annually?
Correct, over 3 years.
And is that based on a calendar year or a financial year?
Over a financial year, so it's 150 per financial year over 3 years.
So when's the first financial year?
So this is the first financial year, so they've got until 30 June of 2023 to have resettled 150 under their program.
So it's only 3 months, less than 3 months.
I apologise. The coming financial year starts on the 30th of June and goes to the 30th of June because we have to go through the processes of the UNHCR referrals. So the first calendar year ends on the 30th of June 2023.
Right. Yep. That makes sense. Yep. And then it's 3 times 150, 450.
That's correct.
Okay. And how many people then are, what the latest numbers in terms of transitory persons in Nauru and Australia?
So I'll just get to the right page.
And just as a matter of nomenclature, Senator, just while Mr Ablong looks up his reference, a transitory person by definition is in Australia. They've been brought to Australia for medical care or treatment.
Sure.
If you're in Nauru, our definition is you're an illegal maritime arrival in Nauru and you've been determined to be a refugee or otherwise in accordance with Nauruan law.
Yep.
Okay, so let me clarify the the question then. Transitory persons in Australia or illegal maritime arrivals in Nauru. So I guess it's how many people in Nauru, how many people in Australia?
So there are 112 persons in Nauru and 1,175 in Australia.
And how many of those 112 in Nauru have received their provisional approval to go to the US?
Senator, I might take that one on notice. I don't have that specific figure for exactly how many have received an approval, but are still waiting to go. So I will come back to you on notice about that one.
Well, can I ask in general terms, you referred to, I think, a number of approximately 230 had received provisional approval. That would presumably cover people both in Nauru and Australia.
That's
is that correct?
Senator. Yes.
Okay. All right. And then we've got the 450 annual figure per year being resettled in New Zealand, commencing 1 July 2022. That's the first year, correct?
That's correct.
And where else are people prospectively being resettled outside of the United States and New Zealand?
So under the auspices of the UNHCR, we've had people resettled in Canada under the Canadian Community Sponsorship Program. We've had people resettled into Europe, ones and twos. So there's a number who resettle elsewhere that are not under the auspices of the Australian-sponsored US resettlement arrangement.
So in summary, there are options other than the US resettlement program, which nearly has its numbers filled, and the New Zealand resettlement program. Is that correct?
That's correct. So as of the latest figures I've got, 49 individuals have resettled in countries other than the United States.
And are there any people, my last question, are there any people who have received provisional approval to be resettled in countries other than the United States and New Zealand who are currently still in Nauru or as transitory persons in Australia?
Senator, that strictly is a matter for the UNHCR. We are aware of a few people who've received approvals, but I wouldn't be able to give you any more detail than that.
Okay. But those processes are continuing?
That's correct,
Okay,
Senator.
that's fine. Thank you, Mr Ablong.
Thank you very much, Senator Scarr. I'll now move to Senator Grogan.
Thank you. Just following on from Senator Scarr's questions, can you tell us how many people in Nauru have taken up long-term Nauruan visas, and also how many people are in PNG?
Senator, in Nauru, there are none who've taken up long-term Nauruan residents. In Papua New Guinea, I'm sorry I closed my folder, so if you'll give me a minute, I'll...
Just so we're clear with the Senator, there are other 10-year visas, aren't there, in Nauru?
Yes, there are.
Yeah, and then there's... So are you answering on permanent residency?
Permanent residency.
Sorry, for clarification, my understanding was there was a 10-year visa.
That's correct.
And you're saying nobody in Nauru?
No, sorry, and I will be more specific.
Thank you.
On the 10-year visa, there are a number. I don't have that exact figure with me. In terms of permanent residency in Nauru, there is none.
The question was long-term visa. My memory was that there was a 10-year and possibly even a 20.
I think they've gone to 10, but can we just take on notice so we're absolutely accurate in our evidence? We'll distinguish between anyone on a duration visa,
Yep.
whether it's 5, 10 or 15, I think it's 10, and anyone who's, from memory, and we'll need to check this, Mr Abalong, I think under Nauruan law, there's a prohibition on a pathway to citizenship, if I recall it, so I think that answer would be 0, but we'll get that.
Yeah, that wasn't the question. The question was on the long-term visas.
Yeah, so we'll be very precise in the term of our response.
Yeah, I apologise, just didn't have that figure on me.
Thank you.
What about PNG?
And PNG.
You asked for that. How many
PNG?
people are in PNG?
So, as you know, Senator, we ended our regional reprocessing arrangement with PNG on the 31st of December. As of 1 January, individuals in PNG are effectively resettled in PNG unless they're looking for third country resettlement through other processes. So if they were already engaged in the US process, then they could continue that pathway. If they were under the relationship with the UNHCR, they could continue that pathway, but those who were left at that stage would effectively resettle in Papua New Guinea, and there were 105 of those.
How many?
105.
Maybe you give us that full breakdown when you bring back the other numbers as well.
So we'll take on notice
Certainly.
those in Nauru on some form of duration visa and how many effectively resettled in PNG as at 1 January 2022.
We can do that.
Thank you.
Cool. If I can now go back to the Park Hotel, there were 31 people released last week.
I'm not sure the evidence was that 31 were released. I think Ms Jones, who will rejoin me...
Was 31?
Was it 31?
Yeah.
I think
that was
number-
the evidence. I wrote it down.
So did
I think it might have been 31 remain in some form of detention.
Sorry, you were correct, Mr. Priscilla. 31
in some form of detention across the network.
remain.
Yeah.
Correct.
And
but there was a group that was released.
19 were released,
Ms
if I
Jones,
understood.
can
19
you just
released,
remind us of
31
your evidence,
remain.
please?
Yes, Senator. There were 19 people released on Friday, the 1st of April, and there are now 31 transitory persons remaining in a held detention setting.
And you are obtaining the information for us about, for Senator McKim, regarding how many are left in the Park Hotel. Now,
And we just suggested that when the Border Force, because they manage location, when they appear, they might have that information, but we've just alerted them to the question from Senator McKim.
Cool. Keen to understand what sort of notice they were given when they were released. Do you have that sort of information?
I can talk to it in
Yep.
general, Senator. The decision of the Minister, of course, to intervene is a non-compellable and non-delegable power. So once a Minister agrees to intervene to grant the visa, we do that immediately, and that means that we have to also release the person from detention as quickly as possible. So by the very nature of the power, we can't preempt the Minister's decision-making in this space. So detainees won't have knowledge prior to the decision to grant, and at that point in time, we then quite quickly organise to release them from detention. At that point, they would also be provided formal notification of their visa grant.
And so what do? You just let them out of the hotel, and what sort
No,
of
we have,
supports and-
they are provided with transitional support under our Status Resolution Support Service, and that's of up to 6 weeks. So we have contracted service providers who we notify, and we have pre-arranged with them when we think it is likely that there's going to be releases. So essentially the ABF would go through a process of getting the people ready to be released, and then we have service providers who the people are then linked up with immediately to take them to temporary accommodation. So the service providers would take them immediately to temporary accommodation with some basic supplies and financial assistance, and then that service provider, that it's basically a case manager type or a caseworker model, so that caseworker then would engage with the person over the next 3 to 6 weeks in terms of linking them up to services and starting to help them look for a job, for example, see if there's any health issues or medical support that we need to provide to them before they get their Medicare cards and the like. So it's quite intensive case support at that point.
And you provide that for 6 weeks?
Up to 6 weeks.
Is it variable?
It can be variable. It's between 3 to 6 weeks. It will depend on the person. But it can be beyond that, Senator. The Status Resolution Support Service is intended to not replicate social support, but it is a fairly flexible program for support, generally of a short-term nature, to ensure that the people that we manage in the program have a level of support that is tailored to any specific needs that they have.
Right, so technically they could just be released, they've been notified, released same day. Would they get same day support?
They do. The service providers actually take them to the hotel that's already been booked.
So they move them from, say, the Park Hotel to another hotel?
Yes, that's correct. That's correct. They are taken to accommodation the day they're released.
So one of the other things, the cost of particularly the Park Hotel has been subject of questioning at previous estimates hearings, where the number of $20 million a year to detain 32 refugees has been put out, and the department has revealed through some of those previous estimates $394,000 per week to maintain the capability at the Park Hotel. What sort of cost impact are we going to see with more people coming out of Park Hotel, which I assume there will be, with 16 of the people who were released last week coming out of Victoria?
Senator, the cost of detention placements, including at the Park Hotel or in an APOD scenario, is a matter for the ABF, so you'd be best directing the question to the ABF. I don't have that information.
Okay. And in terms of when you do release people, and obviously you've said you provide advice to the service providers who are going to support them, in terms of the advocates and the lawyers for those individuals, what sort of notice do they get, or do you not provide any notification?
So we, from a legal perspective, we can only provide information about individuals to their authorised recipients. So if the lawyer is an authorised recipient for one of the detainees, they would be advised or notified immediately. But we don't provide specific information on releases of individuals to advocates and lawyers more generally, due to privacy reasons.
Okay. Do you ensure that those individuals have the capacity and the ability to contact their lawyers and their advocates at that time?
Look, again, that would be a matter for the ABF in terms of what happens operationally at the time that they're notified in the detention centre, but I'm sure the answer to that would be yes.
But from an overarching perspective of the Department of Home Affairs, it's not something that you ensure occurs?
Well, it's up to individuals. They have access, I'm sure, and the ABF is better to speak to this, but they have access to phones and the ability to contact representatives if they need to. I'm sure that would be the case, but the ABF would have to talk to that. But from a status resolution perspective, you know, we do provide, we would be providing the notifications to the people involved, and then, as I said, hooking them up with the service providers to provide support.
So when you do come back with the numbers of how many people are left in the various facilities, particularly the Park Hotel, we'd be very keen to understand what the cost is going to be moving forward.
From a detention perspective?
Detention perspective.
Yeah.
Thank you.
Thank you very much, Senator Grogan. Look, I just checking if any other, just from housekeeping point of view, any other Labor senators, or Senator McKim, are you seeking the call?
Yes.
Yes, I am.
Okay, sorry, Senator McKim. Over to you, Senator McKim.
All right, thanks. It's a bit hard to see. I think Ms Jones may have just left the table, and if I could beg her indulgence to ask just a couple more questions, please, in her area.
Senator.
Thanks, Ms Jones. Thank you. When we were, when my previous bracket of questions came to an end, you were reminding the committee that there were, once the 25 had been considered by the minister, we were left with 6. You said it's a very small number, and you were worried about anything you said about them being used to identify them. And I'm conscious of the fact that I don't wish to be a party to any personal identification of those people. But I did want to ask, you've previously raised, and again today, issues of character, or I think you said absence. Can I just ask, in terms of any character issues, whether those character issues relate to behaviour before the people arrived in Australia, or do they relate to behaviour exhibited by people either on Manus Island or Nauru, or in held detention in Australia?
So, Senator, again, without talking about any individuals, I can talk about the process of the advice we provide to ministers, if that's useful.
Well, I'm specifically trying to understand, you've given that there are no security concerns in regard to any of these people. That is, none of Australia's security agencies have raised.
That's correct.
It's confirmed that that's correct?
That is correct.
Thank you. And then you've raised the character or other reasons in terms of why these people weren't included in the brief that's currently with the minister, or they may have previously but put up to the minister, and the minister has exercised a decision not to release them. And I'm trying to understand what that is. Now, you've given, I guess, generic answers as to why that is, character or other reasons. And I'm simply asking, for those people where there are character concerns, do those concerns stem from behaviour while the person was in detention, either in Australia or offshore? Do those concerns relate to the behaviour of the person before they arrived in Australia?
So, Senator, in terms of the advice we provide to ministers when they are considering intervening in a case, we essentially provide detailed information on the individual, both their immigration history, and that would include both offshore and onshore in Australia, so both, and then, clearly information about their health, their history with their health and health conditions and the like. So it's a detailed summary of the case. So that would include any information in relation to incidents in the regional processing countries, or in held detention once in Australia.
All right, thank you. That's helpful, Ms Jones. So just to be clear, that would not extend to behaviour of the person before they became engaged with the Australian immigration system?
We access all the information that we have in our systems. If there was any information that we had in relation to people on our systems from a character perspective that was prior to them coming to Australia, yes, that would be taken into account as well.
All right, could I ask you to take on notice, please, for the remaining 6 people, whether or not there were any character concerns that were raised with the minister that related to behaviour prior to the person originally engaging with the Australian immigration system?
I can take that on notice. Thanks, Senator.
All right. Thanks. I appreciate that. Thanks, Ms Jones. I did have another follow-up questions on the New Zealand arrangement, Mr Pizzillo, which weren't asked by other senators when they were engaging on this issue. Could I first, and this may be one for the minister, but I'm just interested why people who are currently in Papua New Guinea were not included in the arrangement.
Well, it's a bilateral agreement between Australia and New Zealand, and it relates to persons in relation to whom Australia's got some form of responsibility, and I suspect that's going to be a contested term, and I welcome...
I'll say.
Yeah, I was just anticipating the questions, but from a strictly legal point of view, as Mr Ablong indicated in replying to one of Senator Grogan's questions, our arrangement with Papua New Guinea came to an end on the 31st of December. Persons who remain in Papua New Guinea remain there under PNG law. I do grant you, Senator, having been originally transferred there some time ago, and as you and I have often discussed, pursuant to, in a couple of cases that went all the way to the High Court, were lawfully transferred from one legal jurisdiction to another. So we would contend that persons in PNG have got no legal relationship with Australia whatsoever. I know that's a contested proposition, and no doubt you'll ask me about that, but that's the strict black letter response to you, that they are out of scope because it's a bilateral arrangement between Australia and New Zealand. Mr Ablong, is there a better way than perhaps my slightly muddled way of explaining it?
No, Secretary, I wouldn't add anything to your explanation.
Thank you.
All right, thanks. Look, just make the observation, Mr Pizzullo, that you say they were lawfully transferred. In fact, many of those people were unlawfully transferred, and then you had to bring legislation into the Parliament to retrospectively make it lawful. So I'll just the nuance there, and I'm sure you wouldn't disagree with that proposition, would you?
Well, we say that both in terms of the statutory provisions that prevailed at the time, as well as the challenges that were upheld in the government's favour in relation to offshore transfers under M68, I think from memory the case was, suggests that the government undertook those transfers lawfully.
So why did you bring retrospective legislation into Parliament?
I'm just struggling to recall.
It was done lawfully at the time.
There are any number of amendments made to the Migration Act from time to time. I'm just struggling to recall the one that is of particular concern or interest to you, Senator.
That's okay. It was. I'm off on a tangent, Mr. Pizzullo. I'll come back to the matter at hand. I'm happy to provide that to you outside this process, by the way.
I thank you.
If you're interested. But you say that Australia has some level of responsibility for the folk on. Haven't you spent the best part of a decade actually explaining to this committee that, in fact, we have no responsibility or authority for folk on either Manus Island or Nauru?
Save for two caveats, which have been explained in previous evidence. I'll just summarise. Pursuant to the arrangements, one of which is now ceased and one of which is ongoing, the former being Papua New Guinea, the latter being Nauru, Australia did undertake to assist, notwithstanding the lack of legal jurisdiction, to assist with third country resettlement. That's why, for instance, we pursued the agreement with President Obama at the time in relation to the US deal. It wasn't because legally Australia said that we were, if you like, retaining legal responsibility under the Migration Act whilst these persons reside in your jurisdiction. We say that the transference of jurisdiction occurred with the transfer of the person. However, as a matter of governmental agreement, the government's position in both cases, Papua New Guinea at the time, now ceased, Nauru at the time and now ongoing, is that we would assist with third country resettlement. And so the extent of our responsibility, and I won't even put quotation marks around the word responsibility. When Australia enters into a governmental agreement with another government, it takes those obligations seriously. So we've got an obligation to assist the government of Nauru in the resettlement in third countries of persons who are found to be refugees under their law. In respect of persons in Australia that, as we mentioned earlier in evidence, are called transitory persons, that is to say they've been brought here having been transferred to either Papua New Guinea or Nauru for medical treatment, either by the government under the law as it stood for the temporary period, for the short period the Medevac provisions were in place, or then subsequently. We say that whilst we don't owe those persons any protection obligation insofar as they've been transferred to other jurisdictions. Whilsoever they're in our country, we're going to try to find some resolution to their status, and that could well include, in addition to returning to either Papua New Guinea or Nauru, going to third countries. So the word responsibility is used in that context.
Let's talk about, can I ask, did the Australian government engage at all with the Papua New Guinea government around this arrangement with New Zealand and ask the New Guinea government whether they would like to avail themselves of an opportunity to provide a chance for people from this cohort who are currently in New Guinea to resettle in New Zealand?
Mr Ablong will refresh my memory, but for so long as we had an agreement with Papua New Guinea, New Zealand was open to the extent that it was subject of ongoing discussion and negotiation as a possible third country location. But now the agreement with Papua New Guinea has ceased. That door effectively is closed, has it not, Mr Ablong?
Before Mr Ablong answers, if I could just make it clear, New Zealand did not rule out the people from Papua New Guinea, and the UNHCR expressed its commitment that the people from Papua New Guinea were not involved in this deal. So this was clearly a decision of the Australian government to preclude people in Papua New Guinea from being part of this arrangement. And I'm asking whether the government went to the New Zealand government, the Papua New Guinea government, and asked them whether they're interested in availing this opportunity on behalf of the people in Papua New Guinea.
Can you remind us of the history of the triangular discussion, to the extent that there was a triangular discussion involving the government of PNG?
So, Senator Mark Ablong, Deputy Secretary of Strategy and National Resilience, the relationship or the resettlement proposal by New Zealand, which Australia has accepted, is a relationship between Australia and New Zealand, and it covers those people, as the Secretary said earlier, for whom we are currently still engaged in regional processing arrangements, either through Nauru or those who are temporarily here in Australia for medical purposes. We have been quite clear with New Zealand from the beginning that anybody who was covered by our regional processing arrangements would be in, and those who are not covered by our regional processing arrangements would be out. The New Zealand government was aware that we were ending our relationship at mutual consent with Papua New Guinea, and those who remained in Papua New Guinea would therefore not be within the scope of our agreement with New Zealand. That does not preclude the Government of New Zealand or the UNHCR, through their normal refugee and humanitarian program, from accepting people that the UNHCR might refer to them from Papua New Guinea, but it is not the subject of the 150 persons over 3 years that has been the subject of our agreement with New Zealand.
Thank you, Mr Ablong. Just to be clear, it's 150 persons per year.
Per year, that's correct.
Yep. Thank you. So just in terms of who is and who isn't in scope here, just to be clear, if someone's been transferred from Papua New Guinea to Australia and they are currently in Australia, they are in scope for this agreement.
That's correct, Senator. Anybody who was in Papua New Guinea who came to Australia for medical treatment on the completion of their medical treatment is now transferred to Nauru, not back to Papua New Guinea.
Yep. All right. Thank you. So can I ask, you've talked about, I think it was Mr Pezzullo actually spoke about people that have been found to be refugees. Can I therefore confirm that only people who have been accepted as refugees by either Papua New Guinea or Nauru are in scope? And if people either did not apply for a refugee status determination in either of those two countries, or were refused refugee status by either of those two countries, they are not in scope, is that correct?
Correct, Senator. The relationship covers refugees. Now, should a person who has been found to be either a failed asylum seeker or has not put themselves
Last question,
forward
Senator McKim.
for refugee claims were to do so now through the normal processes, then they would be considered by the UNHCR and their claims weighed by the UNHCR as to whether they were a refugee or not.
So,
Senator McKim, I'm sorry, we
Thanks.
are over time. We will need to share the call around. I give the call now to Senator Ciccone.
We'll try again. Mr. Brazil, I just had some questions with respect to the so-called ag visa. At the additional estimates in February this year, I'd asked, and I think the advice from the government at the time was that under the program, 0 individuals were issued under that visa. Is that still the case?
I think it's still the case insofar as the bilateral agreements are still being negotiated. I think 1 or 2 might have been announced, Ms Moy, but the Senator's question relates to any visa grants.
That's correct, Secretary. There's been no grants at this point.
Okay. And I understand that since we last met, the government has since signed, I think, an MOU, a Memorandum of Understanding with Vietnam. Is that the case?
Is it one agreement, Ms Moy?
That's correct, Senator. There's been a Memorandum of Understanding signed by DFAT on behalf of Australia with Vietnam.
Yep. Do you need some water too, by the way?
No, just
Bit of a croaky voice.
hangover from COVID, sorry.
Yeah, that's all right. And I appreciate that. Did your department have any input into the drafting of the MOU?
No, the DFAT managed the MOU. The department with DFAT and the Department of Agriculture, Water and the Environment have originally worked on issues in regard to the policy and settings, in so much as we needed to set up the agricultural visa settings, which is our portion of the tripartite arrangement.
But there's no input into the drafting of the MOU?
Not specifically the MOU, no.
Have you sent a copy of the MOU?
I have not. I'd have to take on notice whether or not it's come into the department, but I believe not. The MOU is the first stage of that arrangement, and obviously, as it's a foreign affairs and trade document, questions in regard to the actual arrangement with Vietnam would be probably better placed to that department.
Could you just further expand for my benefit the stages? So we've got an MOU. What's the next stage?
So, in terms of the current arrangement, a deed of agreement between DFAT and approved employers in the program then needs to be negotiated. Workers will need to be selected. In-country recruitment processes in Vietnam are to be established, including English language testing and skills verification. Visa application processes, including the relevant health and character checks, will need to be completed, and pre-departure training and briefing. So that's the bit that leads towards our side in terms of getting towards a visa, but there'll also be work that the Department of Foreign Affairs and Trade needs to undertake in consideration of operationalising that MOU.
Because we've previously used the term bilateral agreements to describe, I guess, these international legal frameworks. So I'm just trying to get an understanding. We have an MOU. Does that have the same standing, or is it the same standing as a bilateral agreement, or is there a further agreement?
Yeah, well, I think we should give that evidence.
Or is there a further agreement that's required for the MOU to take effect?
So, as I mentioned earlier, anything to do with the actual MOU would be better placed to Foreign Affairs and Trade, because the document is theirs, and all of the activity that surrounds that is part of their remit.
I understand that DFAT, it's their document, but aren't you the lead agency when it comes to this visa?
No, Senator. Well, just to be clear, the government can assign responsibilities for the running of labour programs to whichever department they see fit. They've done so with the Pacific Labour Scheme. They've done so with this scheme. The Department of Foreign Affairs and Trade, through negotiations with employers here and with foreign governments, sources the labour. Our job is very particular. Either grant or don't grant the visa under the law. That's all we need to do. This is a DFAT-run program to source agricultural labour for Australian purposes, labour purposes, I would ask that you direct questions about DFAT's management of that program to DFAT. We can speak to you about the criteria that we apply under the Migration Act to either grant a visa or not grant. Obviously, we need to do a number of checks, health, character, security. Our role is limited to that.
And can I indicate that that's consistent with what's been put on the record at previous estimates?
Yes.
Well, thank you, Minister. Previously, I'd had asked questions, and it was either early this year or late last year, where you indicated that Home Affairs was the lead agency when it came to this visa. So that's why I've got these questions. I'm just trying to understand.
I'll check the
Are you
Hansard
not
precisely.
the lead agency?
We're the lead agency for granting visas under the Migration Act.
I get that, but is this not a visa that you will have to issue visas to individuals?
You need a visa to come to Australia.
Correct.
But in order to work here, in order to fill gaps in the horticultural and agricultural industry, in order to understand what the supply and demand is, either employers or in this case where there's a perceived market failure, if I can use that term, the government's decided that the public service would step in and act in that brokering labour market facilitation role, and that role was assigned to the Department of Foreign Affairs and Trade. So when you say who's the lead for the visa, the program, getting the labour here, is a DFAT matter. Granting the visa and managing the integrity and security of our border to ensure that persons who are not entitled to be in Australia under the Migration Act, that is clearly exclusively a role for my department. So it's quite particular to that role. It's to do with the security of our border and to ensure that persons who are in Australia are lawfully here and not otherwise. But it would be no different from a university running an international student program with the Department of Education. In this case, it's the Department of Foreign Affairs and Trade, running in effect a labour market program designed to address a perceived market failure in terms of sourcing labour to assist with the harvesting of produce.
But it wouldn't be the first time that governments, and put aside agriculture, but that governments would enter into MOUs with other countries.
Quite. Yeah, we do it all the time. Yes.
Correct. So then what is the next step? You have an MOU. Do you need a bilateral agreement?
You need to ask DFAT that because they're managing that process and the next step is something known to them. I don't know.
But I'm not asking in terms of the ag visa. I'm just, with your experience and the department...
Senator Ciccone, if I can just interrupt you there. The Secretary's made it clear that that's not within the scope of the operations of the Home Affairs Department. So if you have any other questions for Home Affairs, could you continue?
Chair. Thank you.
Thank you.
But my question is what the department's experience with other visas with respect to MOUs. Do they have to then wait for a bilateral agreement to be signed?
Well, an MOU is a form of bilateral agreement, but I would ask that for further particulars you refer your question to DFAT.
With the ag visa, does your department have any role when it comes to the exploitation of workers? Is there certain standards that your department has provided input or feedback into DFAT or the Department of Agriculture at their design of the visa?
Insofar as my colleagues in the Australian Border Force, when they conduct field operations which are to do with the compliance of persons in relation to the Migration Act, if they come across, and you've heard evidence from the Commissioner and his officers in terms of conditions, sexual assault, wage theft and the like, they have a relationship both with sponsoring program areas, so in this case the agricultural visa, could be Pacific or seasonal work arrangements. They've also got a relationship with the Fair Work Ombudsman. All those issues arise to the extent that they come before us under the border enforcement element of Outcome 3. I think as Commissioner Outram has said...
So you see that as an ABF issue rather than a department?
Insofar as they conduct field operations, they enforce the provisions of the Migration Act. Their job isn't to enforce our Fair Work, industrial relations laws, but as you've heard Commissioner Outram, and he's going to appear later again through the course of the morning, when they come across exploitation, they have arrangements in place with the Fair Work Ombudsman and others to deal with that, but we run the Migration Act. We don't run the Fair Work Act, but I would ask that more particular questions be directed to Commissioner Outram.
When does your department expect to start issuing visas under the agriculture visa program?
Mr Moy, do we have any indication from the Department of Foreign Affairs and Trade as to when the program will start flowing applications?
Not at this stage. So I have no indication at this point of when we will grant visas.
Okay. Have you had any members of government come directly to the department seeking advice about the ag visa? Individual senators or members?
I would need to take that on notice, Senator. I'd have to look through our records.
Could I also ask, at the last round of estimates, and I know the Department of Home Affairs, I think, made the point that, from your understanding, it is a demand-driven visa. I'd also ask questions to DFAT as well in the same round, and there was an answer that was given to Senator Keneally that there was a cap of 1,000 individuals on this visa. What's your understanding? Is it a demand-driven, or is there a cap of 1,000, as per the evidence given by DFAT?
Ms Moyes, do you
So-
remember what the government's decision was?
So, Senator, it's a demand-driven program, but I understand that DFAT may be negotiating individually with countries around what cap number per country there is.
So demand-driven within a cap?
Oh, I
Well,
think the other way around. I think
Yep.
at the aggregate level, the idea is for the program to be demand-driven, so you get as many workers here as you need to support harvesting. But in terms of the numbers who come from particular countries, I think DFAT are operating on the basis of allocations, which is the burden of their evidence. And certainly, as I understand it, the way in which they're going about these negotiations. But that's really a matter for the Department of Foreign Affairs and Trade.
But I guess if there's a cap, then it's not really demand-driven.
They're two different ideas. At the aggregate level, it's a supply and demand issue. How many workers do we need? What's the gap? What's the shortage of labour in those agricultural districts? And then where they're sourced is a function of, call it a cap, call it an allocation. That's really a matter for DFAT to further explain. They're not contradictory ideas, because one is at the aggregate labour market level. What is the supply and demand of labour? And then country by country, how many people are potentially going to come year by year, country by country?
Okay. I also just wanted to turn to just another matter too. I think over the weekend...
Senator Ciccone, I am sorry, but we have gone over your 10 minutes, so I'm going to need to move to Senator McKim. That will then go to morning tea. So I'll now give the call to Senator Kim, bearing in mind that we are scheduled to move to outcome 3 after morning tea. Do Labor senators have any more outcome 2 questions?
Of course we do.
Yes,
I've got a few more.
as I flagged. And I just flag, given that we are moments from morning tea, maybe Senator Ciccone could be allowed just to ask his last question. I don't know if that's...
That's true. We are just a minute or so from the scheduled morning tea. Senator Ciccone, do you just have another minute or so?
Well, not really. And
All right.
I've got at least another 5 minutes.
All right. Well, look, I think on that basis, I'm sorry, Senator McKim, I did indicate we'd come to you, but we are very close now to morning tea. Could we please now suspend for morning tea? And I will come back with Senator McKim at 11:15. The hearing is suspended. Is now in session. We are continuing with outcome 2 in the Home Affairs Department. Just as a bit of housekeeping, Mr Bozzolo, we are shortly going to move to outcome 3. We are all of the same mind to finish on time at 12:15. If there is an opportunity to return to some questions from Labor senators, they've indicated they would like to return to outcome 2 if there is any time left over. So would you be able to accommodate that? Because obviously we are all working very hard to stay to the program.
I've got nowhere else to be.
Excellent. I'll now give the call to Senator McKim.
Thanks very much, Chair. Sorry, I was just having a little bit of trouble with the audio there, but I'm back.
Sorry, Madam,
back
is
on.
it possible to get
Before
in
I
on
ask my
screen?
questions, I just wanted to advise Mr. Bozzolo of the issue that we were discussing earlier. I was referring to the Migration Validation of Port Appointment Bill 2018, which I'm sure you recall, Mr. Bozzolo, came after the Federal Court ruled that at Reef was actually never a port and never properly excised from Australia's migration.
Yes, thank you. Thank you.
Which
Senator.
meant that,
Thank you.
well, it's important for the accuracy of future evidence you give the committee, because what that meant, in effect, Mr. Pizzullo, was that about 1,600 people actually were legally able to claim asylum in Australia, and they were unlawfully prevented so and unlawfully transferred to either Manus Island or Nauru. So I just think it's important that we're accurate in the evidence that the committee receives.
Senator McKim, just one housekeeping issue for broadcasting. Is it possible to bring Senator McKim's video up on the screen in front of the Secretary? Because that would be preferred, obviously. Mr Pizzullo.
I think the Senator was just reminding me of a piece of legislation that we were discussing before. I'm not sure that I heard a question. Senator McKim, can you assist me?
No, there wasn't.
Thank you.
No, there
Do
wasn't.
you have a question, Senator McKim?
I do have a question. Thank you. Yeah, Mr. Pizzullo, I wanted to just quickly ask about the scenario for 449 visa holders from Afghanistan who are currently in Australia. I think Mr. Walden has been giving some evidence about this last week.
Indeed.
So the
Ms Moy,
process-
if Ms Moy and Mr Wilden can perhaps come back to the table.
Thank you. And these are questions around the process regarding notifying 449 visa holders that the lifting of the bar is imminent. And can I just ask how people are being notified about that? Is by letter or email or phone call?
I'll defer to Mr Wilden.
Thank you.
Thank you, Senator McKim. So in terms of the notification, you may recall that the government provided an additional $7.5 million for legal providers to assist people prepare their applications.
Yes.
That is being dispersed to the Red Cross to a range of providers. So what we ask of people, regardless of their circumstances, is to keep the department up to date on either their personal circumstances, if they are representing themselves, or if they have an agent or a lawyer to advise us. And there are people who were helped out by agents during the evacuation phase who have kept the relationship, so they won't be accessing those lawyers. So when we know who their primary contact are, we send a letter, but the letter I'll come back and correct the record if I'm inaccurate, but we do a formal letter advising them that in 30 days the bar will be lifted for them to lodge their application. But the mechanism of transmission, I believe, is via email, the letter goes. We then, 14 days later, send a second letter to remind them of the bar lift. And then, obviously, at the 30-day mark, we give them the advice that the bar is to be lifted. They have 7 days to lodge their application. Application's received and then goes to assessment. In terms of progress to date, it's been going very smoothly. In terms of, we had a conversation with the legal fraternity last week, and they said that they're coping with the volumes. And I think we've only had one person who we identified who was unable to meet the requirements of the bar lift due to a health issue that they have. But of those, I'll just quickly reiterate the evidence from last week. There's 1,971 people are already formally in the process out of the 5,500. Of those, first preparation advice, this is at 18 March, was 669. Final preparation advice, that 14-day letter, was 463, the bar lift notification phase 625, and the assessment phase is 214.
Thanks, Mr. Wilden. I really appreciate that. And you've actually covered in your answer responses to a couple of questions I was going to ask. So that's saved some time. So thank you. So last question on this issue is, you've said that one person was unable to make their application within the 7-day bar lift period because of health issues. What will happen? Will that person be given another chance?
Absolutely. All that happens is if we know that they're unable to present their claims to us in the window that's originally identified, we work with their representatives or themselves when they will be in a position to do that, and then we'll do the bar lift in one of the later tranches.
All right, thanks. I appreciate that. So I just wanted to, and I'm just going to, I guess, mop up a few issues here, Mr. Pizzullo, and try and keep the committee on time. So I am jumping around a little bit, but I just wanted to confirm that the government's announcement of 4,000 temporary humanitarian visas for people from Ukraine, that is, can I just confirm that is 4,000 per year over 2 years? Am I accurate in my understanding?
So in terms of the number that was cited are the number of people who have visas already, who've been granted visas. A large number of those aren't onshore yet. The offer of moving the evidence I gave earlier around that process to go onto the 486, we expect with the current cohort, anywhere from 1,000 to up to 1,500 may take up that offer. But the offer was basically to create the large window. There's no time restriction on application and no ceiling on those people who may wish to apply. No, because it's a temporary visa, it's not counted under the program, so it's not an allocation per se. That was just an indication of the people who were onshore, not an indication of a limiting factor.
It's 786, is it?
All right, thank
Sorry,
you.
786, yes, 786. Thank you, Secretary.
Yes, thank you. We are talking about the 786 visa here. Thank you. That's the temporary 3-year protection visa.
Just want to be
correct?
Yes.
Yep. Thank you.
I'm being schooled by
just
my
to be
secretary here, Senator McKim, so...
Well, I'm sure that's a large group of people you're joining there, Mr. Wilden. So could I ask them, just to be clear, Mr. Wilden, those places do not come out of Australia's humanitarian quota?
Correct.
They are in addition?
Correct. Well, it's not even in addition, because they are temporary visas, they don't count against any of the programs. They are just, in the same way we have a student program and a working holiday program where they're not capped, people just come and access. So.
Sure, and just to be clear, though, the number of those visas, I think you've just given evidence, is also not capped.
Correct.
Okay, all right. Thank you. I wanted to ask whether the government has, I guess this is one for you, Mr. Pizzullo, whether the government has asked the department for advice on whether there should be a specific visa class created or a specific allocation in the humanitarian program set aside for people who are fleeing the crisis in Myanmar?
Not in relation to whether a visa needs to be created. We have given advice, whether it was asked for or not, I can't recall, but we have given advice on the management of the program and for support for people coming from Myanmar, yes.
All right. I may just add, Senator McKim, the government recently announced 2,000 places.
Yes, thank you.
Would be for Myanmar in this year's program, up to 2,000 places. And we currently, we already have, there was already about 450 granted this year, and we're continuing to grant now at an accelerated rate as we move places against Myanmar as opposed to other areas. But that's within this year's program.
And just checking the accuracy of my
So that's
evidence, there's
within
no advice about a particular visa.
No, none about a
The
visa.
visas.
No specific visa. They're all just using existing visa categories.
Yep, thank you.
One more minute,
That's
Senator
right.
McKim.
Thanks, and that's within this year's existing quota, I think, Mr. Wilden?
That's correct, yes.
And maybe might spill over, could some spill over into next year's program?
Well, I think it's fair to say we have always had a very healthy program out of Myanmar. I think the last 10 or 11 years it's been about 17,000 people. So we run traditionally at around about that 1,600 mark, and a very diverse group, obviously. But given the particular circumstances in Myanmar at the moment, the government has just committed to go a little bit higher with the places this year.
All right, thanks. I think I heard the Chair saying my time was coming to an end. I've probably got one more group of questions in this outcome for the department.
Thanks very much, Senator McKim. I now give the call to Senator Ciccone.
Thank you, Chair. Just back onto the ag visa, Mr. Pizzullo. The question of pathway to permanency, I believe has been some point of difference maybe between your department and that of DFAT, but I just wanted to ask the department today, Is there going to be a pathway or not? Because I'd seem to have conflicting evidence from this committee and then when I was at DFAT, the last round of estimates. So I just want to get a sense from you or Ms Moy.
I wouldn't accept, I should state for the record, I wouldn't accept a characterisation of a point of difference, and if there are differences, we work those issues through the interagency process. Nothing should be visible on the outside, but so I'm a bit perplexed by that reference. But the government's got a policy to examine permanency, but I don't think the government's settled on a final design of permanency. Is that right, Ms Moy?
That's correct, Secretary. So the government has committed to considering a pathway to permanency for those who are on their agriculture visa, and we're working through possible policy situations in regard to that as we speak.
So when we'll have an idea of what that might look like?
I think it's probably within the next quarter.
This year?
This year.
Okay. So I've also heard there's, and again, I don't know if you're able to help me on this one, Ms Moy, but in the last round of estimates, questions that I put to DFAT seem to indicate there were two cohorts of employees as part of this ag visa. Is that your understanding, that there'd be two different streams, one long-term and a short-term seasonal work stream? So like, in effect, an ag visa A, maybe an ag visa B?
Were they referring... Well, we'd have to check their evidence and it's a matter for them, but they run the seasonal program as well, don't they, Ms Moy?
Correct. So they run the Pacific scheme and the seasonal scheme. So I'd have to check their evidence, Senator, to see what exactly they were talking about.
But in terms of Department of Home Affairs issuing visas, would there be just one visa or will there be iterations of that visa? Like,
no, my understanding is there's one visa, one agriculture visa.
Which
is in the same category.
Which has been established pursuant to instrument, hasn't it?
Potentially you could have the one visa with, I don't know, if there was hypothetically a long-term stream and a short-term stream, is that would they be generally two types of visas, Mr Pizzullo, or would they be the one with conditions?
The visa, and it's just an objective fact, has been established by way of instrument, if I recall it. I can't remember the subclass. Ms Moy, perhaps you can assist me, but if there's any potential overlapping or perhaps even confusion here, it might be with the already existing seasonal work program, but I just can't recall any differentiation as to long-term duration and short-term duration. I thought it had one criteria around duration.
Correct. So it's a subclass 403 visa, which is in the same stream as it's in the temporary work international relations stream. The issue may be, and as I said, I have not seen the DFAT evidence, but there could be two types of individuals who may have an agriculture visa, one who may prefer that they're coming here for the short-term arrangement, and another who may, over time, work towards the permanent pathway.
And is that arrangement...
But that doesn't change the actual visa itself.
And would that arrangement be something that's entered into between the individual and the approved employer or DFAT or Home Affairs? How would that work?
I think at this point in time, because we have not determined the permanent pathway policy, we'd be unable to answer that at this point.
And look, I appreciate you probably not across some of the evidence from DFAT from the last round of estimates, but I just wanted to put that to you. Would individuals be able to switch between one visa to another without leaving Australia? So if they're on the ag visa here, could they apply for another visa? Let's say they were here for 2 years. Could they then, at the end of the conclusion of their 2-year visa, say, well, I want to apply for another visa?
It's a sponsored visa, which means each applicant requires a sponsor in regard to that visa. So if there's any changes to that, it'd have to be considered by the department and would depend very much on an individual. So I wouldn't want to say no, because there may be one individual circumstance where, for example, exploitation or those sorts of matters where we may have to look at an individual's position. But I can come back to you on notice on that, because, again, it will depend on some final arrangements.
Yeah, because I'm intrigued to know if it's easy for someone to jump between these visas or come here on an ag visa and then choose to apply for another visa, if there's any conditions.
It's part of the temporary work international relations, and that's not a normal situation within those visas, no.
All right. And if you could also just take on notice those streams that I just discussed with you, whether the permanency pathway to permanency also applies, and if you're able to provide any other further information for the committee, I'd appreciate that.
Well, I think the evidence we gave is that permanency's not yet been decided.
No, it's not yet been decided by government.
Okay. Just turning to another matter before I hand over. I understand there's been discussions between Australia and India on a free trade agreement. But over the weekend, Minister Littleproud, in a media release, and I'm happy to provide you with a copy for your reference if you want, but if I could just quote one particular line, Mr Pizzullo, he said that we're pleased that India has been invited to become a participant in the new agriculture visa after Vietnam signed last week. I guess my question to you or the department is, have you been asked to provide any advice to government about India being part of the ag visa?
Well, we don't engage with other governments in terms of bilateral agreements to underpin people arriving here under ag visas, so I'd refer you to the Department of Foreign Affairs and Trade. Is there any reason why we'd be giving advice to anyone?
We would perhaps provide advice around general matters in regard to free trade agreements, as they might affect visas, but in regard to the agricultural visa, that would be a matter for DFAT.
I guess because you're sort of the central agency that deals with visas, but were you consulted at all about
I'm not aware
India?
that we were consulted in regard to the ag visa, no, and we generally wouldn't be because DFAT is managing that program and doing all of the negotiations, as we said earlier.
Okay.
And DFAT, just to be clear, you ask in relation to these bilateral agreements whether we were consulted. We lay down the law, as it were, if I can use that term, as to what our criteria are about how we do our checks, security, character, etc., what our processing arrangements are, and then DFAT then, within its own determination, prioritises who it's going to consult with, and they presumably go to their minister about getting a sort of priority list of countries, but they know what our requirements are, so we don't need to be the goldfish going around the bowl, sort of forgetting every time. They know what we need, and they factor it into their negotiations.
Yeah, and I guess my questions aren't about the discussions between India and Australia and the bilaterals, but surely the other departments, don't they come and ask you for advice before they do make a commitment to another country about a visa, regardless of what type of visa it is? Surely they pick up the phone or at least talk to you and say, look, we are thinking about creating another visa or inviting another country to be part of this. What's your advice?
Well, the department was party as part of the interagency process to the settlement of the agricultural visa by the government, so our views were taken into account at that point. The information we need is understood by DFAT. We've got very good working relationships. Ms Moy has taken on notice several times whether we're consulted about particular bilateral agreements, but as I said, we don't swim around the goldfish bowl as if it's a new thing every day. We know that they're negotiating across a number of countries. They know what our requirements are, and they get on with it.
Are there any other countries outside of the 10 ASEAN nations that they're also consulting with?
You'll need to ask DFAT.
Well, I guess I'm asking you what you know.
I've got no need to know because I'm not running the program. If I was running the program, I'd give you very particular and precise evidence, but I'm not running the program.
Can you confirm then that
and I don't
you
want to
have
run
been
the program, by the way.
asked to provide advice about
I got
India?
enough on my plate.
So can you confirm that you have been provided advice to government about India being part of the ag visa?
Well, I'm not sure that we've given advice on particular countries, have we?
No. So what I took on notice earlier was that I would check whether or not we had been asked specific questions in regard to India on the free trade agreement to do with the agriculture visa.
Thank you.
So I can take that on notice and come back to you, and I can probably come back before close of session on that. As the Secretary said, when we actually go into the development of these programs and its interagency arrangement, those arrangements are then set. So the requirement for DFAT to come back to us continually on issues, if they're negotiating with, 5 or 6 or however many different countries they may be negotiating with, then they don't need to come back to us each time because those parameters are set.
But aren't we outside of the
Sorry,
parameters
Senator
now?
Ciccone, as I indicated, that you're now over your allocated time. I do need.
Sorry, Mr. Pizzullo was just
need to
taking
move
something on board there, Chair.
Sorry, Senator, I do need to move the call to Senator McKim.
Well,
Senator McKim, you have the call.
It's good to see the government shut down debate.
It's
true.
Thanks, Chair.
She doesn't like the ag visa.
Mr.
Anyway.
Please don't reflect. Senator Ciccone, Senator Ciccone, please don't reflect on the chair. As I've made very clear, we're operating estimates in 10-minute blocks. You've gone over your time. All senators need to follow the same rules, and Senator McKim now has the call. Senator McKim.
Thanks, Chair. Mr. Pizzullo, the budget said that partner visa granting arrangement will move to a demand-driven basis going forward. What does that actually mean?
So this is a measure that the government's agreed in relation to the permanent program from 22-23 going forward. Ms Moore, in terms of the management of partners on a demand-driven basis, if you could explain that to the Senator, please.
So, Senator, within the migration program for 22-23, there has been a change in terms of the movement to a higher number for skill stream.
Yes.
Around 50,000 places for family stream, and we expect within that family stream number that the partner visas are demand-driven in terms of they're not subject to a ceiling. So it's demand-driven. So you'd be aware, and I think we've given evidence at previous estimates to this, that the partner program last year was quite a high number, and we delivered around 72,500 partner visas. So that, in colloquial terms, broke the back of the demand in that space, and what we've done now is move that to a demand-driven arrangement so that we can focus also on skilled stream.
Didn't the budget move 10,000 partner visas out of the partner visa stream and into the skilled stream?
So 109,900 places for the skill stream and 50,000 places for the family stream. And that move,
how does that compare?
That move is in regard to the fact that the partner stream demand has lowered now, because we did deliver quite a number in the past 12 months, and we will continue to deliver the correct numbers for this year in terms of the program.
But I think it's fair to say, Senator, if I can add just one point, the government made it clear that it was seeking, and Ms Moy, correct me if I got this formulation not quite right, but the government's seeking to revert back to a pre-COVID split. So for the best part of 25 years, the split as between skilled and family has been roughly 70-30. During COVID, that balanced back out to about 50-50.
50-50.
And the government's policy decision was to rebalance back in favour of a long-term trend of about 70-30 as the split.
So that's 70 for skilled and 30 for family.
Correct. And that balance of the program has been in place since about the mid-90s.
That's right, but before the mid-90s, it was significantly more generous to family than it.
Well, in fact, it was almost inverse. So prior to the changes that Minister Ruddock introduced in the mid-90s, it was almost historically 70-30 going in the opposite direction.
Yeah. Okay. So how many partner visa applications, probably one from Ms Moy, how many partner visa applications are currently on hand in the department?
Just a minute.
I think the question is
Senator?
on hand. I think. Sorry, Senator, it just crackles every now and then, but I think the question was on hand partners.
Yeah, so how many applications do you have which have come in but have not yet been processed?
And for partners?
Partner visas, yes, partners.
Sorry, one moment, Senator. Let's see if I've got the current number of partners on hand.
Thank you.
Skilled family. I've got the family numbers, but I don't have the partner numbers on hand. I might just ask Mr Willard if he has them.
Is Mr Willard here?
Yep.
And perhaps while Mr Willard's coming to the table, Ms Moy, if you had I think I heard you say you had the family numbers there.
Yep, so I've got the family numbers granted to date this year, which is 29,439 out of 77,300. And I'll just ask Mr Willard if he has the numbers on hand.
Senator Michael Willard, First Assistant Secretary, Immigration Programs Division. It's around 58,000.
That's partner visa applications, Mr.
Partners,
Willard?
yes, that's correct.
Okay. And so when we say that's moved to a demand, granting arrangements are moving to a demand-driven basis, what does that mean in terms of clearing time for those applications?
As we have been for the past 12 or more months, we'll be finalising them as quickly as possible. What we'd expect, given the fact we've been finalising far more applications that have been coming in, we'd expect processing times to fall over the next 12-month period. And in terms of the demand-driven program, the approach is similar to the approach that's been taken for 5 or 6 years now in the child program, which is also a demand-driven program.
All right, and when you say you'd expect the processing times to fall, any KPIs in that area?
Sorry, I just missed a key bit that broke up. Can you repeat that question, please?
Apologies for any audio issues, but when you said I think I heard you say that you were expecting the processing times to come down or to fall, and my question was, do you have any KPIs or have you set any targets in that area?
I don't have a specific figure in terms of the target, Senator. The basis for expecting processing times to fall is the reduction in the overall pipeline. So we're seeing a reduction in the number of people waiting, and that'll translate to a reduction in the time that people are waiting.
And what are your current processing times on average? I'm asking about partner visas specifically.
Sure.
Thank you.
Processing times for partner visas as at the 31st of January 2022. 3 categories of visa here: prospective marriage subclass 300, which is 75% processed in 26 months. Partner provisional, which is visa subclass 309, 75% processed in 19 months. And partner temporary, which is subclass 820, 75% in 23 months.
Thank you. And you'd expect those to come down, Mr. Willard?
Yes. What we're managing in terms of those processing times is there was a point in time where the on-hand caseload was just under 100,000 cases. As I said, that's reduced to 58,000 over the past 12 months or so. And so what we'll see is a continued acceleration in those timeframes as we finalise those older cases.
All right, thank you. And the committee's been given evidence previously around the fact that 75% of partner visa applications lodged in places like London, Ottawa and Washington are granted within 5 to 9 months, whereas 75% of applications lodged in Amman and New Delhi are processed within 24 to 25 months, like quite a variety, quite a wide range of processing times. Is there anything that the department's putting in place to try and bring those processing times a little bit closer together?
What we've been doing over the past 12 to 18 months during the COVID period, Senator, is introducing a global processing methodology, particularly for the partner caseload. Now, what that means is regardless of where the application is lodged, the processing is managed centrally. So, for example, you might have applications lodged in Europe, could be processed in Thailand or indeed in Australia at one of the onshore processing centres. So the model is designed to provide the most efficient mechanism for processing. Essentially, we look at a global pipeline and allocate officers as they're available to help manage that pipeline. The issue we've had to deal with in particular over the last 2 years now is that during any given week, some of our processing offices will not be open because of COVID shutdowns in various locations around the world. So, for example, at the moment, Shanghai and Hong Kong are both closed in terms of our processing offices. So we've got used to shifting caseloads around according to where capacity is, and we also shift caseloads around according to where expertise is, where that makes sense in respect of a particular caseload. So it's really a shift from a model that existed previously where individual posts would all have individual allocations about how they contribute to the overall program. It's now a centrally managed program, and what we're seeking to do with that mechanism is take advantage of some advances in technology. We can manage caseloads electronically far more effectively, but also be able to adapt as, you know, inevitably things will happen, offices will close, capacity will be reduced in different locations, so we can then shift those caseloads around.
Senator McKim, we will need to finish your time now, I'm afraid.
I just wanted to offer a 10-second positive observation about the department, if I might, Chair.
Well, look, no, I'm actually going to stay strictly to the 10 minutes.
Can I move an extension of time?
All right, okay, on indulgence, 10 seconds.
10 seconds. Can I just say, Mr Willard and Mr Pizzillo, thank you. I really appreciate the efforts the department has put in around that issue. So thank you very much.
Thank you, Senator.
Thank you, Senator McKim. I'll now return to Senator Ciccone. Senator Ciccone has a couple of questions. We're then going to move to outcome 3, but we're just reminding everyone that we may, if we have time, come back to outcome 2 before the lunch break. Senator Ciccone.
Thank you very much, Chair. I'll be quick. With just going back to the ag visa, and from my last question, Mr Pizzullo, I think you're about to say something, but in terms of the framework, has it not changed significantly now that the government has offered participation to countries outside of the 10 ASEAN nations? Aren't we now outside of the parameters, the framework that the government initially set up? So surely you've been asked for advice.
The parameters were set when the government agreed the agricultural visa. I don't recall any stipulation that limited it to 8, 9 or 10 countries.
No,
you don't recall the government saying it was only just for the 10 ASEAN nations, Mr Pizzullo?
Well, we'd have to check the record, but I don't recall that stipulation this morning.
So the actual parameters of the visa itself, the 403, they have not changed. So the agriculture visa was set in legislation on the 30th of September last year. That has not...
For regulations?
The regulations?
Yes.
Has not changed. So in terms of whether or not that is offered to different countries, again, that's a matter for Department of Foreign Affairs and Trade.
And as the department, you would have provided advice on that basis to government, but wasn't it also on the basis, given media releases that we can go off, that it was initially to be offered to 10 countries, 10 ASEAN nations?
Well, they're questions of policy. If the policy's varied, I really, again, urge you to ask the Department of Foreign Affairs and Trade. It's a program that they run. We administer the issuance of the visa. If there's a media release that stipulated 10,
when was the first time you learnt
that.
about India being part of that, being invited to participate?
I don't personally recall it. I know it's been in our state of knowledge for a while, but I don't know when we first were advised.
Senator, it's probably just worth mentioning that if the parameters of the visa were required to change, or if DFAT considered that they wanted changes in that place, then we would have engaged in those discussions. That has not occurred.
How many visas do you plan or expect to provide to people from India on this visa?
As I said, there's no agreement to my understanding with India, so at this point in time, I have not been asked to prepare to issue any visas.
Okay. All right. Thank you very much, Chair. I'm happy to hand over to Senator Keneally if she's got any questions on outcome 2.
Thanks very much, Senator Ciccone. We are now going to move to outcome 3 of the Home Affairs portfolio, and I give the call to Senator Keneally.
Thank you very much, Chair. I have some questions in relation to the Future Maritime Surveillance Capability Program.
Madam Chair, can I should have been more assiduous in reminding, but typically the Border Force Commissioner
Yes,
is able to...
I am sorry, I was a bit rushed.
It was remiss of me to not prompt you, Madam Chair, but...
No, not at all.
I'm joined by Commissioner
I do
Outram.
apologise. Yes, I do need to actually call officers from the Department of Home Affairs, including the Australian Border Force, in relation to outcome 3.
Thank you.
We're trying to stay on schedule, so I was a bit ahead of myself. Commissioner, good morning and welcome. Would you like to make an opening statement before we go to questions?
Yes, please. Thank you, Chair. And thank you, Senators. Good morning. In the 6 weeks since Australia reopened its international borders to all fully vaccinated international arrivals, many Australians who have not seen loved ones since we first closed the border over 2 years ago have been able to reunite here in Australia and overseas. And since we adjusted our operational settings on the 21st of February this year to implement this stage of the border reopening, the ABF has facilitated the arrival of approximately 470,000 travellers into Australia, which is a vast increase in the number of arrivals at the same time last year. For the time being, unvaccinated visa holders may still only enter Australia in limited circumstances where they either provide acceptable evidence of a medical reason for being unvaccinated or they have an approved ABF Commissioner's exemption to arrive in Australia. Our office's ability to pivot as public health requirements change has endured throughout the pandemic and has now enabled the safe reopening of our border to vaccinated students, skilled workers and tourists. And while we look forward to the benefits and challenges of managing an increasing number of international travellers arriving by air and sea, we will remain mindful of COVID-19 and the health risks it continues to present. To enable the safe and timely facilitation of large numbers of travellers into Australia, the Department and the ABF launched the Digital Passenger Declaration on the 15th of February. Or the DPD. The DPD has replaced the Australian Travel Declaration, and mobile applications for both Apple and Android have recently been released, and since go live on the 15th of February, approximately 550,000 passengers have submitted a DPD. Currently, the DPD collects important health information such as travellers' COVID-19 test and vaccination status, which is shared with state and territory public health authorities to support them within their jurisdictions. The DPD will expand, as the committee I think have already been told, over time to replace the paper incoming passenger card later this year. And this will enable travellers to provide important immigration, customs and biosecurity information ahead of arrival into Australia. The DPD will provide a significant uplift in capability for the Australian Border Force and our partners in the Department of Agriculture, Water and the Environment over the coming years, supporting more streamlined border processing as passenger volumes return. On Russian sanctions, I may touch on this, Chair and Senators. While the ABF seeks to play its part in helping our country to recover from the pandemic and its economic repercussions, we face a range of other border threats, including as a result of Russia's illegal invasion of Ukraine. Along with many other countries around the world, Australia has imposed sanctions against Russia, and the ABF is enacting border controls to support this, which includes measures that prohibit the import and export of arms or related material to and from Russia, and the export of certain items used in oil exploration and production projects, prohibited exports and commercial activity in relation to the creation, acquisition or development of infrastructure for the transport, telecommunications or energy sectors, and the exploitation of oil, gas or mineral reserves in Crimea or Sevastopol. Prohibit the import, purchase or transport of any goods which originate in or have been exported from Crimea, Sevastopol, Donetsk or Luhansk, and from the 25th of April, prohibit the import of oil, refined petroleum products, natural gas and coal from Russia. In addition, a total of 488 individuals subject to autonomous sanctions have been placed on our Central Movement Alert List, which prevents them from having a visa approved and travelling to Australia, and where individuals have been identified as holding a valid visa for travel to Australia, visa cancel action will be undertaken. Our airline liaison officers have been working hard in Dubai and Doha in particular and have provided significant support to a number of Australians and Ukrainian visa holders seeking to travel from Ukraine to Australia who did not initially meet airline uplift requirements. While we adjust our operations to support the sanctions, we will not be distracted from our focus on the risks from transnational serious and organised crime and those that are posed at our international border and the vulnerabilities that these criminal groups exploit. We know that organised crime groups have infiltrated the international supply chain and that they use trusted insiders to import illicit drugs, precursors, firearms and other illegal goods into Australia, and these criminal syndicates threaten Australia's prosperity. The safety of our community and the cost to our economy is estimated to be in the magnitude of $60 billion per year. Operation Jardina has been established by the ABF to harden the Australian border and make it hostile to criminals and their trusted insiders. Through Jardina, we have doubled the number of officers dedicated to supply chain operations, enabling targeted strikes against identified people and companies whilst increasing our physical presence at international airports, wharves, businesses licensed to store and handle international cargo. And we've seen some early successes, including the interception of over 50 kilograms of cocaine concealed within the refrigeration unit of a reefer contained in Brisbane, or a refrigerated unit. cancellations of depot licences following visits from Jardina strike teams, and the identification and seizure of tonnes of illicit tobacco and millions of illicit cigarettes. Key to Jardina's operational successes, however, will be the identification of systemic vulnerabilities and potential legislative, policy, regulatory and technological solutions which both enhance border security whilst facilitating trade. In parallel with a harder stance on disrupting organised crime in our supply chain, we remain committed to simplifying and improving our borders to enable legitimate trade and trusted businesses to flourish through Australia's simplified trade system. Modernisation of our trade systems will improve trader experiences and ensure more Australian businesses participate in overseas markets through more productive and transparent supply chains. The ABF supports the principle of a tell us once model for the trade system as part of a single trade environment that will limit duplication across border agencies and make it easier for both industry and government to know where cargo movements occur at any given point in time. And over the next 2 years, the ABF and Home Affairs will be developing the foundational capabilities for a single trade environment to allow the piloting of a number of services with industry that will address known business pain points. With increasing volumes of trade and emerging changes to illicit activity through the supply chain, a quicker and easier single trade environment will ensure our systems remain fit for purpose to enable increased economic benefits and harden the border against criminality. In conclusion, Chair and Senators, the ABF has demonstrated its competency and ability to rapidly adapt to changing operating environments both domestically and around the world. Our border controls have been recognised as a major factor in Australia's pandemic success and will now allow for and support economic recovery and stability. I'm increasingly proud of our officers' resilience and dedication and our demonstrated achievements in protecting Australia's sovereign interests at the border. Thank you, Chair.
Thank you very much, Commissioner. I now go to questions from senators and give the call to Senator Keneally.
Thank you, Chair. Thank you to the Commissioner for being here today and for his opening statement. I do have some questions regarding the Future Maritime Surveillance Capability Project. This is the project that Minister Dutton announced in 2019, saying that unmanned drones would be patrolling our waters, that the project was, quote, critical to national security, and that the project would reach, quote, full capability by 2024. I see in this year's budget that the project's been renamed. It's now the Future Maritime Surveillance and Response Capability Project. Will Australia reach full capability by 2024 as announced by Minister Dutton?
Mr Ablong handles our strategic capability program. We have given evidence before on the market examination that we did pursuant to Mr Dutton's announcement and the fact that the better value option was to extend our current fixed wing capability. You might just quickly reprise that evidence.
I do remember that evidence. I'm trying to understand, given the status of the project, if it's going to reach capability by 2024.
So the answer is we went out to the market to examine what the market could do in response to that vision as outlined, and the better judgment was reached that extending our fixed wing capability, including through the year of 24, was the better course.
So we will not reach full capability of
we'll
the FM?
Have fully capable fixed wing over water surveillance capability in that year.
We'll have fully capable fixed wing
Yes.
aerial surveillance by 2024.
Yep, the same fixed wing aircraft we have now have been extended out to, I can't quite recall the extension period.
Minister Dutton said, and I quote, "This is a very significant investment and we can't keep our borders secured without it." He also said, "We've got significant amounts of money in the budget over the forward estimates, and we need to make sure we've got the best technology available to keep our waters safe, to keep our borders secure, and keep Australians safe, and that's what we're investing in."
That's right.
So are you now saying we are not going to have the Future Maritime Surveillance capability with its underwater sea monitors and its drones, as promised by Minister Dutton, fully capable by 2024? We will remain in 2024 with fixed wing aircraft.
The Dash 8 fleet has been examined in terms of its utility. The Border Force Commissioner can speak to his operational requirements. The market examination that Mr Dutton's press release spoke about was conducted. We searched globally as to what technologies are currently available or prospectively available in terms of overwater, uninhabited vehicles, etc., and the decision was made. So the funding's there because we can certainly pay for the surveillance that the Commissioner requires, so there's no question about the funding, it's then the mode of technology, and the market response was, I won't say underwhelming, but was not convincing that a shift to new technologies and new methodologies was warranted at this time.
Can I ask then, in the 2021-22 budget, the department was provided with $14 million for the future maritime surveillance capacity. Did you spend capability? Did you spend all of that $14 million, and what exactly did it deliver?
Was that the conclusion of the market examination?
Yes, Senator Mark Ablong, Deputy Secretary of Strategy and National Resilience. The $14.2 million allowed us to undertake some risk reduction activities, some further evaluation of the analysis of alternatives. To go a little bit further than the Secretary's testimony, Australia's civil maritime surveillance capability is a mix of both Home Affairs ABF assets as well as defence assets. The judgment was made following those early risk reduction activities that the state of unmanned aerial capability globally and in use by defence was not going to meet our requirements in a civil maritime environment, and so we have decided to pause the unmanned capability until such time as those capabilities are at a better level to meet the specific requirements that we have for both high altitude but also medium and low altitude aerial surveillance. The capabilities just weren't at that state at that point in time.
Perhaps Minister Dutton regrets that that work wasn't done before he made his announcement.
Well, his announcement was about the doing of the work.
His announcement saying that we needed this capability. Drones prowling Australia's far-flung ocean boundaries and undersea sensors monitoring shipping movements around our coastlines is critical to maintaining our secure borders. That's Minister Dutton's words. Maybe he'd be regretful that the department didn't do that work before he made an announcement of something he claimed was critical.
Well, now that you've grandstanded, Senator Keneally, the Minister, in his announcement, made it clear that the task he was setting for the department was to examine the viability of doing that.
He said it would be fully capable by 2024.
And he has made sure, through the programs that are currently being funded and operated by the department, that in practical terms, that level of coverage is being delivered, and it's being delivered.
We're going to
in
get
the
to
best
that level
possible,
of coverage.
Sorry, Senator
that is being
Keneally,
done in the best
if you could just allow the
possible
Minister to
value
answer
proposition
her
for the
question.
Australian people. So you can speak to what you think he should be thinking, but what he has done, in fact, is deliver that capability, and he has done it consistently with the department's work to ensure that it represents value for money as well as efficacy.
Thank you. Mr. Secretary, let's discuss the additional $9 million that's been allocated this year to the Future Maritime Surveillance and Response Capability Project. The budget papers explain this is to, quote, continue planning.
Yes.
What will that deliver in 2022-23?
Mr Ablong, your capability strategy hat is on.
Indeed, thank you. Senator, the money provided to us allows us to undertake further technical and cost analysis to support our capability acquisition options, working with Defence, the analysis of user requirements for future medium patrol and response capabilities, including the development of the program capability needs statement and operational concept documentation, the transitional and replacement options analysis, and the fundamental inputs to capability analysis. This will lead us to a submission that will go to government, which will define what the medium and long-term state of our surveillance and maritime capabilities needs to be, and the pathway by which they might address those options.
The budget papers mention the Australian Maritime Identification System will be used to inform future acquisitions. What exactly is the Australian Maritime Identification System?
So the AMIS system is a computer system that's used by the ABF and others, including our Fisheries Management Agency, to identify vessels in Australia's maritime approaches using the vessel monitoring system, which most vessels have on board. It plots their current position, the tracking of where they've come from and where they're going, in order for a judgment to be made about whether they are legitimate maritime vessels or whether they need to be investigated.
So in October 2018, we've got much fanfare. We spent $11,000 for bureaucrats to travel to the minister's photo op announcement. He announces the future maritime surveillance capability, saying it's critical to maintaining border security, that it would be achieve full capability by the end of 2024, and the government had significant amounts of money in the budget for it. That significant money was pulled before the 2019 election, and since then the government's drip-fed small amounts of funding into planning, but nothing has actually been delivered except an extension of our Dash 8 capability. It
just
seems
one
to me
more-
all that you're doing is planning. This is another case of the government being all about promise and announcement and not about delivery. Can you give me any sense when we are going to see an undersea water monitor? Have you got any? Have you, and I understand you might, and have you got any idea when you're going to have a plan for this plan?
Last question, Senator Keneally. It's just under 1 minute to go.
The press release in question, and I should add to the Minister's earlier answer, the decisions to wrap up the value for money examination of the market and the directions were given by Minister Andrews last year. So we'd done the task that Minister Dutton set for us, go out, have a look at the state of technology, look at global systems.
That's not what he said, you know that.
Well, I know what we were directed and appropriated to do, which was to conduct that examination.
That's not what his announcement said.
So we undertook the examination. By that stage, Mr Dutton had moved on to the defence portfolio. Ms Andrews came into the portfolio about a year ago, was presented with the options about the risk, the lack of maturity outside of the military domain for these kinds of technologies. And on advice, we gave her options, and on advice, the extension of the Cobham delivered fixed wing capability was entered into for a six-year period?
Six, yeah. Further six. A further six.
A further six, yes. Thank you.
Thank you very much, Senator Keneally.
2030.
Senator Keneally, we will need to move the call to other senators. I'm staying strictly to the 10-minute blocks.
Sure, I'm just trying to clarify. We're going to have fixed wing.
We can come back to you.
Till 2030.
Senator Keneally, we can come back to you.
Is that your evidence?
Senator Keneally, I'll now give the call to Senator Scarr.
Fascinating.
Senator Scarr.
Maybe we'll get to get a Dash 8 trophy for the Prime Minister.
Commissioner, I note in your opening statement that you refer to the simplified trade package in the work that's been done there. Just in terms of general principles, obviously the philosophy, the concept, I guess, is to make it as hard as possible for criminals and organised crime to import materials into this country and make it as easy as possible for legitimate businesses to go through the trade process. Is that correct?
That's correct, Senator.
Right. So what are some of the milestones that have been reached in terms of the simplified trade package over the last 12 months, side?
So I may bring in our group manager, Malcolm Skeen, Senator, to assist. I think Malcolm's with us online remotely from Melbourne. He's our Group Manager for Industry and Border Systems, who's leading that work. But, Senator, there are a number of projects in flight, and you can imagine that we're working very, very closely with the Department of Agriculture, Water and Environment in this regard. So we are partnering up with them in terms of our engagement with industry. Screening is one example. So obviously we have to screen a lot of goods coming into the country for biosecurity risks, albeit for prohibited imports, narcotics, firearms parts, etc., plant seeds and such and so forth. So working with Australia Post, for example, we are seeking to evaluate technologies that will allow us to integrate our screening process with those of agriculture, but also to integrate that further into the sortation systems and processes of Australia Post so that we can screen more goods more quickly, so greater volume of goods more quickly, but without slowing anything down in terms of imports into the country. So there's an example. We're also engaged with the CEO and his team at Western Sydney Airport, Simon Hickey, in terms of the inbound and outbound passenger processes to see if there's anything we can do through technology to further automate, firstly, the traveller pathway and make it more seamless, but secondly, to identify and be able to respond to risk more quickly and more with more precision. I may just, though, if I could, Senator, invite GM Skeen to add anything that he wishes to add.
Please.
Group Manager, Industry and Border Systems, Malcolm Skeen. Just picking up on what the Commissioner's touched on, the work really relates to new operating models, screening technologies and the like, as well as fundamental ICT system improvements in the coming 12 to 24 months, which allows better interoperability between industry and government systems.
Right. So what part does the digital verification platform play in all of this simplification process?
The digital verification platform?
Yep.
Malcolm?
So the DVP is a trial that we based on blockchain technology. Basically, it's digitally encrypting trade documents, and we've piloted that, and we're looking to roll that out more broadly with industry.
Okay, so have you conducted a number of trials in that space, or are you looking to conduct a number of trials, and what are the learnings arising from those trials? Because ultimately we need less paper and more digitisation to make the process as efficient as possible.
I wholeheartedly agree. So yes, we have trialled it with one set of trade documentation to reduce the paper burden and digitise a particular document between two trading partners. We're now looking at other documents that we could digitise and use that technology to do that.
Right, and in this...
Oh,
sorry, go on.
Pilots so we'll be running additional pilots on that.
And how do you choose where you're running actual pilot programs? Are you identifying processes which are the subject of particular stakeholder concerns, or do you engage and liaise with industry in terms of determining where you should focus your pilot programs on?
We do. We have regular engagement with industry on this. It'll be based on a suite of trade documents.
Okay. And Commissioner, is anything else happening in the deregulation space in this regard to make the practices and processes simpler and easier for business to do business?
Indeed, Senator. In fact, there was some, very recently we've been working with central departments and the taxation office around excisable goods, for example, to reduce bureaucracy and red tape around those processes. There are a number of ways that obviously reducing friction in the supply chain is critical, and we recognise that, but also, as I've adverted to, there's a number of challenges because of the infiltration of the international supply chains by organised crime. So to your point earlier, anything that really eliminates the ability for humans to misbehave as trusted insiders, from my point of view, is a good thing. So that's technology, blockchain, those sorts of things. So we are looking at a range of opportunities in the future. If I might just say this, I think that sort of greenfield sites offer the greatest opportunity for us. So if there's a new wharf being built, a new airport being built, a new mail sortation facility being built, so it allows us then to co-design with that particular industry their actual systems and processes and technologies, and see if we can integrate securely and ours with those, rather than bolting on our regulatory requirements. That's why I say, if you can imagine mail sortation processes with our screening and QR scanning and barcode scanning and all those other things into the sortation process, rather than having separate conveyor belts taking items that are referred to us by Australia Post separately to agriculture and ourselves for X-ray examination. So the future I see as being very much more integrated between ourselves, the regulators, and industry, and we all want the same thing. We all want knowledge of what's where in the supply chain, what risks does it present, and an automated process in terms of referral to border agencies. So I think that's a long-term vision, but the way we operate at the moment is, as you'd be aware, we can only screen, for example, a handful of containers through our examination facilities by way of X-ray, because of the volumes and because of the logistical exercise in bringing those containers from a wharf. I'd much rather in the future be in a position to screen those containers at the wharf without the need to actually move them anywhere. So in other words, potentially as they come off a vessel. Now that's a long way into the future, but the trials we're doing now are very much building towards that view of the future where we have algorithms driving our screening technologies that are networked, that are AI, so they're self-learning, and of course that we're screening far more volumes of things coming into country. So in terms of the disruption of the supply chain in terms of illicit narcotics, we can seize far more and disrupt far more. At the moment we do very well. Our targeting and intelligence based models at the moment are improving significantly. Our strike rate is improving. But still, there's a lot we need to get to because of trust in insiders and because of volume. And the technology, the advances you're talking about, I think will help us in that regard.
Okay, all right. Thank you very much, Commissioner. That's all from me, Chair.
Thanks very much, Senator Scarr. Senator Keneally.
Thank you. So while we've been, since the announcement from Minister Dutton about the Future Maritime Surveillance Capability Project, we've also had the ANAO in October release a review of the Department's management of the Civil Maritime Surveillance contract. The report found that Home Affairs management of the Civil Maritime Surveillance contract was ineffective, and that in no year at all, had the contracted rate of effort been met. The 21-22 year is almost finished. Will the contracted rate of effort be met in 21-22?
I might ask, the question of rate of effort is a matter for the Commissioner. I might ask the Commissioner to address that.
Senator, I might just say that in terms of the audit itself and the findings, they primarily related to the period before 2015. And in fact, since 2016-17, the majority of the report refers to the period before 2015, Senator. 3 of the 4 findings, or recommendations, I should say, actually are recommendations in relation to future contracts, not in relation to the existing contract. And in terms of the performance requirements under the contract, in fact, Cobham have met the performance requirements for the majority of the contract period. What the ANAO focused on is a number of inputs that, of course, are relevant, but they're not actually the performance criteria under the contract. So the performance criteria under the contract has, in fact, been met in the vast majority of cases. And I may just ask Acting Deputy Commissioner Rendina, who I think has got more detail in terms of the actual performance metrics that are used on the contract, to explain my comments.
Well, I really just wanted a yes or no, given we have a very short amount of time, and the Chair, understandably, needs to land these estimates so we can move on to Attorney Generals. So my question is simply...
Respectfully, that was necessary in order
I understand
to give
that.
a proper understanding of what the report said. So I don't think
I'm not
it's unreasonable for the
disputing
Commissioner to do that.
I'm not disputing that, Minister. What I'm asking for is an answer to my question rather than if there are other material the Department would like to table, I'd be happy to receive it. But given the Chair has indicated the short amount of time available to Senators, I would like to ask, will the contracted rate of effort be met in 2021-22?
My anticipation is that it will be met as it has in the recent years.
Your anticipation is that it will be met?
Yes.
Right. And what years has it been met?
I may just ask the Acting Deputy Commissioner to give you the detail, but my understanding is that the performance requirements on the contract have been met every year since 15-16.
Hello, Kylie Rendina, Acting Deputy Commissioner, Australian Border Force. Thank you. I can confirm with what the Commissioner has provided in evidence, and I can say that as at 31st of January, we are at 1,529 patrol days, so on track to meet our patrol days, but also our aerial is 9,194 hours as of 31st of January, so we're on track to meet those targets.
Right. So the 2006 budget papers outlined that there was funding for aircraft to increase the number of night flights. As I understand it, since 2018-19, planning for night missions has reduced significantly, and the ANAO reported that since September 2018, only 2 late-night missions have been flown. Have any more late-night missions been flown since this report was published, or are we still at 2?
Well, I may just firstly say that the taskings that are given to Cobham come from Maritime Border Command. So if they seek late-night missions or not is a function of the deliberate planning that's undertaken by Maritime Border Command and their requirements in terms of surveillance activities and patterns. I think that Rear Admiral Jones is online and he's the commander of Maritime Border Command. And in terms of recent taskings, I may ask Rear Admiral Jones to clarify whether there have been any further taskings in relation to night missions and maybe to provide some context as to why Maritime Border Command prefer missions to be flown by day.
Thank you, Commissioner. Yes, I can confirm that Rear Admiral Justin Jones, Commander, Maritime Border Command. I can confirm that we have flown a night mission in the last 6 months.
A night mission?
A night mission. I'll just have to get the details on that. But as the Commissioner has indicated, we do prefer to structure the flight schedules to be during daylight hours, more effective for aerial surveillance to occur during daylight, and then enables us to, where required, use response assets based on what we've seen during the day.
Do you have a target for late night missions in 21-22?
There is no target in the contract or operationally for late night missions. As the Rear Admiral said, is operationally, if it's necessary, then it will be planned for.
The ANAO has also said that long-range missions capability has never been realised. When will this capability be realised?
When you say long range, sorry, Senator, I have to...
I'm using the ANAO's phrasing. Long-range missions capability has never been realised.
We fly fairly long-range missions now, but Rear Admiral Jones, do you have anything
Did you
to
respond to the ANAO report? My apologies.
Sorry, Senator Keneally, if
yes,
the Commissioner
there was a
could
response
just...
provided.
There was a response, so you might have responded to that criticism, maybe.
Possibly.
Rear
The report was
Admiral
tabled
Jones
last
knows.
year, Senator, so I'd need to refresh my memory, but we did respond. But Rear Admiral Jones, in terms of long-range missions, do you have anything to add?
Thanks, Senator. I want to take the definition of that on notice and just explore. But what I can say is we are flying those aircraft as long and as far as the capability permits.
I think that does go back to a previous discussion we had about the future maritime surveillance capability, but I will park that in the interest of time. I would appreciate an answer on notice, though. Thank you very much on that question. Since August 2019, the department has only employed one, I understand, the department has only employed one maritime aviation specialist officer, or a MASO. MASOs are employed by the department to fly on up to 15% of missions to monitor the contractors who work on the contract, but clearly it seems to me that's not possible with only one MASO employed. How many MASOs are employed now?
I'll take that on notice, Senator.
Are MASOs flying on up to 15% of missions to monitor the contractors?
I'll need to take that on notice, Senator.
Do you have a plan to recruit more MASOs?
Again, I'd need to take that on notice. I need to understand the operational context because I am aware that the aerial surveillance missions are being completed and they're delivering against operational requirements and they're meeting the performance targets. So I just need to take that on notice and come back to you.
Well, does the Rear Admiral have an answer to that?
Senator, I'm afraid I don't, sorry.
How can you say then that the performance targets are being met if you don't have people, if you can't tell us if people are flying on the missions to monitor the contractors?
Well, this is some of the issues with the audit. They were very, audit focused, and that's fine. But in terms of operational realities, there are other operational realities. The fact of the matter is that the performance requirements under the contract, which is the metrics contained within the contract, have been met year on year for the last several years.
But you can't tell us how many MASOs you've got.
I don't off the top of my head know how many MASOs I've got, no, and I need to take it on notice.
Are they employed by ABF?
I'm sorry?
Are they employed by Australian Border Force? Or are they employed by the Department of Home Affairs directly?
Well, everybody in the Border Force is employed by the
Yeah, I
Department of
understand
Home
that,
Affairs.
but do you actually, does ABF?
I take that on notice myself, Senator, and come back to you.
Sorry, who actually appoints them?
It would be through the Australian Border Force,
Yes.
through the group that the acting Deputy Commissioner sits over, but we haven't got, unless you have that detail.
Commissioner, no, I do not have that detail. We'll
I
take
find it
that
extraordinary, and I apologise with respect, because you're usually quite across your brief, Commissioner. I find it extraordinary that there's nobody here who knows how many MASOs the department employs.
Well, in fairness, Senator, this audit report landed last year. It isn't a contemporary report, and
It was
it's,
October.
Senator Keneally, that question has been taken on notice. I'd ask you not
I
to
wasn't aware
reflect
this
on
was gonna come up.
witnesses in relation to their decision to do so.
This is a matter that should be able to be answered, not, whether there was a report or not. I submit with respect.
Senator Keneally, I'd ask you
Given
not
that
to
it's
debate.
a direct question, how many in this position do you employ?
I'll take it on notice, Senator, and come back to you.
Extraordinary.
One more minute, Senator Keneally.
Oh, I don't think it would help, Chair. Thank you.
All right, thank you very much, Senator Keneally. We'll now go to Senator McKim. If Senator McKim is there, I think he is coming in via teleconference. Senator McKim,
Thanks,
you
Chair.
have the call.
Sorry, just Senator Keneally finished a minute earlier than I thought she would, so apologies for that delay.
Look alive, Senator McKim.
Commissioner, you may be cognizant of some of the questions I was asking of Home Affairs earlier in terms of the number of people, in particular immigration detention facilities. I wonder if you can, the committee, firstly, by informing us how many people are currently in APODs in Australia, and whether you have a breakdown by facility.
I may just ask the acting Deputy Commissioner to step back to the table, Senator, because I believe that she's got that information. We were aware of the conversation earlier on, and we have been scrambling to try and get that data for you.
I appreciate that.
Thank you. So I can determine that detainees released on Friday was what are the questions? Is that the question being asked again now, Senator McKim? How many yesterday?
Yeah, I'm not sure which date you have. So perhaps I could just, do you have current figures as of today about how many people are in APODs and broken down by which facility?
Yes, Senator, I can. So we've got 8 remaining in the MAPOD, 7 in the MITA, 11 in the BITA, less than 5 in each of the Adelaide transit accommodations, Victoria APOD, Perth IDC, Villawood IDC and Yongah Hill IDC. And that's 31 in total.
So what was the total, sorry?
31 in total.
31. And you said less than 5 in those last facilities that you...
I did.
In each of...
Yes, Senator, yep.
Thank you. How many are in the Park Hotel?
So in the Park Hotel, we have 8.
Okay, so that's the only alternative place of detention that is currently being utilised in Australia, is that right?
There's another Victorian APOD that has less than 5 in it.
And which facility is that?
It's another facility in Victoria. I don't have the specific details, Senator.
Is that a hotel?
I would have to take that on notice.
In all likelihood, Senator, but just to mention about the MAPOD, there is, of course, for the detainees in the MAPOD, a range of medical and other facilities that have been made available in that facility, fitness, health, wellbeing, recreational, etc. So those 8 people still are able to avail themselves of the benefits of being in that facility versus perhaps other APODs which are more short-term for airport turnarounds and those sorts of things.
So are you speaking there about the Park Hotel, Commissioner?
Yes, I am indeed, yeah.
Yes, okay. So there's 8 people in the Park Hotel, but there's another small number of people, less than 5, in another hotel APOD in Victoria, is that right?
That is correct, Senator, yep.
All right, could you just take on notice, provide details of where that APOD is, please, and what it's called?
Yep, can do.
Thank you. And do you have oversight of which detainees in that cohort of 31 that the department has put a brief up to the minister around a decision? Does the department liaise with you to that extent?
No, Senator, we don't tend to get involved in that side of the business unless there's a particular reason to. We wouldn't ordinarily be consulted by the department in relation to those sorts of matters.
Okay, thanks, Commissioner. So the first that that your outfit knows of any potential releases are, in fact, the Minister has made the decision that people should be released. Is that correct?
Generally speaking, Senator, that's correct. Or a court makes a decision, we get notified, and then we have to put in place the arrangements for the release.
All right, thank you. And what? So do you get notified by the Minister's office or by the department?
By the department, generally.
By the department. And what sort of timeframes are we looking at between when the department notifies you that a person or group of people should be released and when they actually are released?
I don't know if we measure.
I understand. Sorry,
it's a very short time.
I understand. I'm not asking in terms of minutes, but just are we talking about, minutes, hours,
a couple of
days,
hours, or maybe a couple of hours. We get scrutinised very closely in terms of people who were detained, who were potentially being unlawfully detained. So the department and ourselves work very closely and very quickly to ensure that people are released very quickly.
All right. And do you ensure that adequate supports are in place before people are released, or would you simply regard the priority as releasing them in the most timely fashion possible?
We work very closely with the department who obviously put in place the post-detention support arrangements and make sure, for example, that if we go through our release procedures, which would include giving people property back and no doubt administrative paperwork, that they're then released into the care of a nominated service provider. So that coordination occurs on the ground with the department.
All right, thanks. Could you provide, be happy for you to take this on notice, Commissioner, or any of your officers, just the average length of stay in immigration detention in Australia at the most recent time that you have the data broken down by facility and nationality of detainee? I mean, I can see you looking there. If you can provide that now, I'll take it now. Otherwise, happy for you to take it on notice.
Let me just check. Well, I can tell you that as at the 28th of February this year, 17.3% of the detention group of population were unauthorised maritime arrivals, 12% were overstayers, 59.1% had their visa cancelled under Section 501 of the Migration Act, 10.4% had their visa cancelled for other grounds, leaving a very small number of sort of air arrivals who were non-immigration cleared and seaport arrivals. The average time in held detention as at the 28th of February 2002 was 697 days. And in terms of citizenship, on the 28th of February 2022, 300 were from New Zealand, 141 from Iran, 140 from Vietnam, 69 from Sudan, 65 from India, 60 from Iraq, 51 from Afghanistan, 46 from Sri Lanka, 43 from the United Kingdom, 41 from China, 41 from Tonga, 41 stateless, and other 496. So, Senator, that's the detail I've got.
All right, thanks, Commissioner. I appreciate that. Would your data sets allow you to break down the average length of time in detention by nationality?
I'd need to take that on notice, Senator.
All right. Yeah. All right. Thank you. I just wanted to ask about Christmas Island and some of the trouble that happened over there in the detention facility on Christmas Island in recent times. How would you describe the running and operation of that facility in general terms at the moment, Commissioner? Are you aware of any issues or concerns?
Yeah, we've obviously got concerns that as a result of COVID, we've been unable to return quite a lot of people to their countries. That would include a number of Tongans. In particular, that's relevant to Christmas Island because Tonga has still got its borders closed, including to its own citizens, so we can't return them. And similarly, we've had some difficulties returning people in the numbers we would like to New Zealand, and that creates difficulties. We also have a very large proportion, as I just said, of our detention population are coming into detention from the prison system or because of criminality, and this led to their visa being cancelled. So the cohort we're looking after in our detention centres is a very difficult cohort at times, and the levels of course, violence, non-compliance and those sorts of things is something that does concern me, and I've been talking with our service provider, Serco in particular, and the Australian Federal Police about that. As you'd be aware, the settings in detention are different from prisons. And I know your background, I know you know something about the prison system. They are different in detention, and it's much harder to manage and regulate behaviour in detention settings. And so, particularly on Christmas Island, we've been very focused on maintaining the order in that facility, given the nature of the people, by and large, who are in there.
Last question, Senator McKim. Just one more minute.
All right. Thanks, Commissioner. But there was a riot there, wasn't there, a month or so ago? Fires were lit. There were, I'm not sure what you call them, but special operations group or people were deployed from either ABF or Serco in response to those circumstances. There are people on hunger strike currently. Are all those facts accurate?
No, I think some of the reporting, it would be fair to say, was inaccurate. Well, what I would say is on the 12th of March, there was a significant disturbance at Christmas Island. Started off with 2 detainees in involved fires, as you say, property damage and violence. Christmas Island Fire Brigade and the Australian Federal Police responded, and a detainee was taken to Christmas Island Hospital and treated for lacerations to their hand. Investigations do remain ongoing. An assessment of the damage is being conducted, and we are looking to refer a number of matters to the Australian Federal Police once we've amassed all of the evidence.
Senator McKim, we will need to leave it there, so thank you very much. We've just got a couple of minutes to go before we break at 12:15. Senator Keneally.
Thank you. I just have a couple of short questions. Commissioner, how many of the Australian Border Force vessels on operations today are being crewed by staff affected by COVID?
I may just ask Rear Admiral Jones if he's aware of any that have any staff on that have been diagnosed as being COVID positive. Obviously, if we have staff who test positive before deployment, they don't embark on vessels. And where we have staff who are tested on the vessel and test positive, then they're quarantined on the vessel and we make arrangements for them to be obviously brought off the vessel. But Rear Admiral, are you aware of any vessels that currently have COVID on board?
Senator, I'll have to take that on notice in terms of what is operating today that may have COVID on board. As a general comment, I'll just offer that we have been trying to get to a place of operating with COVID, much like the rest of the nation is trying to live with COVID. Yep. But it does have many implications for our operations. I'll return soon as I can with those figures.
Thank you. And if I can, you can take this on notice. What percentage of ABF vessels on the water today are considered fully operational? But I'm happy for you to take that on notice. I have two very quick questions to the department. In February, I asked some questions about a stress test the government had conducted in 2018 using a scenario where a pandemic forced Australia's borders to close. Will the department conduct another stress test to wargame pandemic scenarios or long-term border closures to incorporate the lessons learned from the last 2 years?
Yes.
Yes, is that underway now?
The schedule for conducting simulations, exercises and the like is currently being worked up. A pandemic is very high on our agenda, but as are other potentially catastrophic risks that need to be managed, but I'm happy to come back to you on notice.
Okay, can I add to that, since we're coming back on notice, who's commissioned it, when is it due to report, and what themes has it been tasked to consider?
We can come back on notice. We now have both funding and authority to conduct national security scenario-based exercising in a much more structured and rigorous way, and I thank the government for providing us with that support. So we've got a program that the EMA part of the department coordinates, but it brings in many parts of the department.
And just one last one for notice. We did hear last time that the Deputy Secretaries chose not to provide you and the then Minister with the complete stress test because it revealed systemic underpreparedness. You did describe that as a failure of judgment. Will you commit that the results of the stress test will be provided to you and to the Minister?
Well, more than that, the idea that I have in mind will come back on notice is that this will become, in the way that defence planning is conducted, something which is reported out to government more generally.
Thank you.
Thank you very much, Senator Keneally, and thank you to all senators. That now concludes the committee's examination of the Home Affairs portfolio. We thank your department, Mr Pizzullo, and Commissioner, to you and the ABF. We wish you all the very best, and we look forward to seeing you next time.
Thank you. Thank you, Madam Chair.
We are now going to suspend for lunch, and we will return with the Attorney General's Department and the Attorney General's portfolio at 1:15. Thank you. The committee is now in session and we move to the Attorney General's portfolio, and I'd like to welcome the Attorney General, Senator the Honourable Michaelia Cash. Minister, would you like to make an opening statement?
Chair, thank you.
I'd also like to call officers from the Attorney General's Department in relation to cross-portfolio, corporate and general matters. Ms Jones, welcome. Would you like to make an opening statement?
Thank you, Chair. No, I won't make an opening statement.
Thank you. Just for the benefit of all participating in these Senate estimates, Senator Carr and myself have had a conversation in relation to the program. We do believe that we will move through the program more quickly than is scheduled. While there are no golden guarantees on that, we're anticipating that we will finish with the department today, maybe early evening, and then we will move to the agencies tomorrow. We are looking to bring forward the Solicitor General's group and dismiss the Enabling Services group.
Is that an official dismissal?
No, hang on.
Understood.
Can I just?
But yes, sure. I mean, that's a guide.
Yeah,
but
okay,
Senator Carr, did you want to?
Yes, look, there are some questions that I have in regard to the Solicitor General, which I hope to be able to deal with in cross-portfolio. And if that occurs, then the last two sections on the program were listed for tomorrow, the Australian Government Solicitors Group and the Enabling Services Group wouldn't need to attend. So
understood.
That's right. Yeah, so we
make a call at the time.
So as I indicated, we would bring forward the Australian Government Solicitors Group today, if possible.
Understood, yeah.
And if I might just add that, look, this is our best endeavour. You can't always predict the flow of the tide of events in this place. But
we're just trying to use our best endeavours to give everyone a guide as to how we see the program unfolding. So thank you very much. And on that note, we will now go to questions from senators, and I give the call to Senator Carr.
Thank you very much. Minister, I understand that you've raised a public interest immunity claim in regard to questions that were asked in the matter of the last estimates concerning the former High Court judge.
Senator Carr, can I just interrupt at that point just to indicate that that claim has been accepted by the committee,
Thank you,
but
Chair.
that Senator Carr
Thank you, Chair.
Has indicated that this may be something that may be taken to the floor of the Senate, but that's a matter for Senator Carr.
Understood.
I just want to indicate that I read your letter, and I'm going to ask some questions concerning the rationale behind your assertions, and that the matter will be ultimately determined by the Senate. That's where public interest claims are resolved, and that if the Senate doesn't resume before the 30th, then other senators will take the matter up if I can't. So can I just ask, why did the Commonwealth demand an NDA in regard to the amounts of money that have been paid?
I can provide Ms Harvey to respond to these questions for you, Senator Carr.
Thank you.
Senator, I might just start in terms of the particular matter relating to the settlement with 3 former High Court associates in regard to alleged harassment by the former High Court Justice Hayden. The matter was subject of negotiations between the claimants and ComCover. Sorry, I got it ComCare incorrectly last time. ComCover, which is the entity that was specifically responsible in relation to the negotiation with the claimants. This department has a role to play in terms of working with that agency around the terms of a potential settlement. And obviously we look to work through the model litigant obligations and appropriately inform the attorney in terms of the settlement.
Yes, but why specifically, given that we had this conversation at the last estimates, and in an answer to a question on notice, the Commonwealth, the department has acknowledged that it was the Commonwealth that sought the confidentiality agreements. I'm just wondering, can you explain to the committee what the rationale was for the Commonwealth demanding those agreements?
Well, again, I would just note at the outset that consistent with the view that it was important that the claimants were not prevented from making public statements about their experiences and other aspects of the claim, the non-disclosure provision did not go to those issues, and they have been publicly referred to both by their legal representatives and through the media, and that was appropriate in terms of ensuring that they could talk about their experiences and the impact that it had on them individually. Mm-hmm. In terms of the quantum of the settlement in that matter, there was a broad issue around the Commonwealth ensuring that any further claims were dealt with appropriately, and that information about the amount or in respect of the amount remain confidential.
Yes, but you haven't explained to me what your rationale was for seeking that. You've explained to me what's happened, and I'm not disputing your assertions in that, but I'd like to know what the rationale was for the Commonwealth to seek a non-disclosure agreement in regard to these three women, which you say alleged. Dr. Vivian Trom found that the Honourable Dyson Hayden had in fact sexually harassed the 6 complainants. That's correct, isn't it? Trom did find that.
There were 6 claimants that came forward to provide her with information.
And there was a finding in regard to that investigation that there had been sexual harassment.
I think that is correct, but I'll just check with Ms Harvey.
Senator Tamsin Harvey, Acting Deputy Secretary, Legal Services and Families Group. Mm-hmm. I'm just looking for that information, but yes, Dr. Tom did conduct an independent investigation and provided that report to the High Court. Yes. In terms of the role of the Commonwealth in the non-disclosure obligation or non-disclosure agreement, the Commonwealth requested that on the basis that disclosing those settlement sums might impact more broadly on dispute resolution options available, or processes, and on the Commonwealth. So our ability to manage future claims of this nature could be affected by disclosure of the amounts paid out in these claims, noting that, of course, each claim that comes forward will be particular to the facts and circumstances of what occurred and the impact on the individual claimant. So they are variable, and providing, I think as set out in the Attorney General's public interest immunity letter. Yep. So providing that quantum can give other potential claimants an unrealistic basis on which to assert a claim.
So I've read the attorney's letter, and basically it boils down to you're trying to manage expectations.
Senator, it's important to note that these matters are all different.
I know that. I know you make that point, but in effect that's the claim that's being made, so I'm trying to get to the rationale here. Essentially, the Commonwealth's asserting that they need to manage expectations.
Senator, I wouldn't classify it as managing
Sorry,
expectations.
didn't you use that term
Senator
yourself,
Carr,
manage of
could you
future
allow,
claims?
Sorry, Senator Carr, could you just allow Ms Harvey to complete her answer?
Sure.
Thank you. Each claim will the Commonwealth will approach each claim individually on the basis of the facts of that particular matter. So it's important that that we aren't, I guess, putting a particular amount out there that would apply necessarily to all future claims.
See, that's the point. You've used the term yourself, management of future claims. That was the terms you used. The letter itself, this is the Attorney-General's letter, says that while each claim will be different, the Commonwealth may not be in a position to explain why this is in future claims, particularly in circumstances where the original settlements were based on confidential medical or personal information, that result in future claimants approaching the Commonwealth with unrealistic expectations. This is what the letter actually says, that people would approach the Commonwealth with unrealistic expectations. So it is about managing those expectations, isn't it?
It's about ensuring that each matter can be dealt with on the facts approaching, the facts involved in that matter.
You know, look, I've said many times at this committee, I'm not a lawyer, but I would have thought that's exactly what courts do. They manage expectations. People have this expectation that they're innocent. The jails are full of innocent people. Absolutely chock-a-block full of innocent people. And it's the court that determines these outcomes and the court that manages the expectation. Why is it any different here?
Senator Carr, I would also point out in the first instance, it is just use of language. We do need to just remember this is not a non-disclosure agreement. I know you have referred to it in that way, but a non-disclosure agreement would seek to stop the claimants from discussing their allegations. And to be very clear, this is not a non-disclosure agreement because as we have discussed at previous estimates, the claimants are able to discuss their allegations. This is confidentiality in relation or a non-disclosure obligation. In the first instance, a non-disclosure obligation, and you would be aware of this, is consistent with the directions under which the settlements are considered. In fact, paragraph 4.5a of the directions notes that it may be in the Commonwealth's interest to agree to a confidential settlement term if the Commonwealth seeks to avoid prejudice in responding to other similar claims against it. So certainly paragraph 4.5a of the directions under which these particular significant issues, because as you are aware, ComCover did report the matter as a significant issue under the relevant directions. Paragraph 4.5a itself already contemplates a confidential settlement term. Could I also just add, for the committee's benefit, these settlement deeds and the terms of each settlement deed, Chair, were agreed between the Commonwealth and each of the claimants. So you can request something during negotiations, but it does not mean that it will be agreed to. But the claimants in each of these cases agreed to the non-disclosure obligation consistent with the directions under which we were operating in relation to these particular cases. I would also point out, and I think Chair and Senator Carr, we did discuss this last time, this is actually not unique, as you would know, Senator Carr, when the Labor Party were formerly in office. Again, non-disclosure obligations were also utilised in relevant proceedings at the time, and I think the two that we put on the record were Mohammed Hanif and the Goodwin Gretsch case. They remain confidential, and we did talk about that last time. So again, just by way of terminology, it's not a non-disclosure agreement. We did not enter into a non-disclosure agreement. Each of the claimants is able to talk about the allegations that were made against them. This is pursuant to the relevant directions as discussed and accepted by the parties, a non-disclosure obligation in relation to the settlement sum. Just by way of background, Senator Carr, to just give you a bit more background.
Thank you. I'm aware of that background to the extent that your answers to questions indicated that people could talk about their experiences. But so it's
Correct.
not a non-disclosure agreement, but you just won't tell us what's in it, like the amount of money.
They are two different things, Senator Carr, and it is very important to actually make that distinction because if you recall last time, questions were also asked in relation to the Respect at Work report and the focus of recommendation 38, and that's why I very much do want to ensure that we are using the correct language. And you're nodding your head, so I think you understand.
No, because I'm
just in terms of to get the correct
I appreciate, but you
yeah,
see,
on the record.
Given that you've raised the Respect at Work report, the Commissioner discussed the problem of these so-called non-disclosure agreements. You might have a different term
and
for
that's
them.
why we don't have a non-disclosure agreement for that reason.
But you see, the essence of the concerns raised by the Commissioner, and perhaps you can confirm this, is the view that a better guidance is urgently needed on the use of NDAs in workplace and sexual harassment matters, especially because the risk that, one, they may rely on clauses that are contrary to the public policy principles. They may enable harassers to escape without appropriate penalty and engage in further sexual harassment. And three, the power imbalance or unfair bargaining process that is used in the complaints to the complaint's disadvantage. So isn't that the case we're now actually examining, the power imbalance between the women that have made the complaint and the power of the Commonwealth to insist on secrecy regarding the aggregate payment that's being made?
And again, Senator Carr, with all due respect, this was canvassed last time and it was made very clear that the Sex Discrimination Commissioner was worried about stopping the allegations themselves being confidential. And I think we confirmed for you, or for the relevant questioners last time, that in this case, Respect at Work did not look at a settlement sum. The claimants are not prevented from making public statements about their experiences and other aspects of their claim. And again, as we discussed last time, this is consistent with the focus of recommendation of the Respect at Work report, which addressed concerns that non-disclosure agreements, and remember we're not talking about a non-disclosure agreement, should not restrict claimants from sharing, if they wish to, their experiences and be able to discuss, Chair, the allegations.
Thank you very much, Senator Carr. We will need to move to other senators because I'm sticking as best I can to 10-minute blocks for questions. Look, I'm just going to pick up with a couple of questions just to clarify this issue that you were raising in relation to the settlement attorney. So just to be clear, there's no prohibition on any of these women at all in terms of telling their stories?
Well, to be very, very clear again, we have not restricted in any way the claimants from sharing, if they wish to, their experiences and discussing their allegations.
Sorry, Senator Carr, you don't. Senator Carr, you don't have the call.
And again, Senator Carr and Chair,
interjections are disorderly.
Something
Senator
that
Carr
was canvassed last time, and certainly Senator Carr has been here for a very, very, very long time. So, Senator Carr, you would recall that when Labor were last in government, out-of-court settlements with Mohammed Hanif and Goodwin Gretsch remained confidential. I would assume that, again, that non-disclosure obligation would have been accepted by both parties and, again, would have been enacted because the matters were significant issues and under the directions, as I said, paragraph 4.5a of the direction contemplates confidentiality of this particular sum.
Thanks, Minister. Look, I want to move to the budget, the 2022-23 budget.
Any particular area, Chair, so we can get the
just
relevant
wanting to get an understanding of the new budget measures for the department and some of the programs, including in relation to the family law system. So, Ms Jones, if I could perhaps direct that
thank you.
To you first.
Yep, thank you very much, Chair. I think in particular through this budget process there's been some important initiatives that have been funded in particularly in the area of women's safety, which is a priority for the portfolio, and that includes funding for the Federal Circuit and Family Court and Legal Aid Commissions, I think I'll turn to Ms Harvey, who will be able to provide detail on that, but there are other measures across the portfolio that we'll be able to work through and provide information on.
And this is part of the National Plan to End Violence Against Women and Children?
Contributes to the National
To the
Plan
package,
outcomes.
yes. Thanks, Ms Harvey.
Senator, there are a range of different measures that funding has been provided for in the budget. So, as the Secretary noted, there's funding of $87.9 million over 4 years to expand the Federal Circuit and Family Courts family violence triaging and management process known as the Lighthouse Project. And that's going to be part of the first action plan of the next National Plan to End Violence Against Women and Children. And so included in that is funding of $63.7 million for the court to extend and expand the Lighthouse pilot to all parenting matters in 15 family law registries. It also enables the court to expand culturally responsive support across all registries, and so that's things like Indigenous liaison officers and what's known as special Indigenous lists, which are measures that are in the family court system to really make it a more culturally appropriate place for Aboriginal and Torres Strait Islander families to resolve family law matters. Within that Lighthouse package, there's also $24.2 million over 3 years for legal aid commissions to increase their capacity to meet increased demand for representation services due to this expansion. There's also under the, which will come under the National Plan, will also be $52.4 million over 4 years for the cross-examination scheme, which this committee would be no doubt aware of, and that protects victim survivors of family violence from being directly cross-examined or indeed having to directly cross-examine their perpetrators in family law proceedings. There's also additional funding that has been directed to the legal aid commissions of $16.5 million over 2 years, which is to support the transition in the Federal Circuit and Family Court to the new case management function, which was funded under, I think, the last budget. In addition, there is, sorry, I'm just finding my place here, $8.4 million over 3 years, which will enable a pilot of a new service delivery model to provide survivors of sexual assault with greater access to dedicated legal services to support recovery and engagement with the criminal justice system. And this is something that we heard about through the consultation on the upcoming National Plan. There is also money in there which we will be working, a proposal led by the Department of Social Services, which is $14.8 million over 5 years, to progress accredited sexual and family violence response training for community frontline workers, health professionals and the justice sector. So that funding sits in the Department of Social Services portfolio, but is will be also used for funding in the justice sector.
Can I ask specifically about the funding for legal assistance in relation to the recent floods and why that's particularly necessary?
Certainly. I'm just looking for the precise figure. I think it's 5.
And there's also funding for the financial rights, legal centres, insurance law service as well.
So we can talk to that. In terms of the legal assistance for support for relief and recovery in New South Wales and Queensland, so $5.4 million has been allocated over 2 years. The department has been working closely with the Queensland and New South Wales governments and their legal aid commissions to develop the appropriate mechanism to provide that funding. That funding will assist supporting victims of the flood for them to deal with issues, whether it's in relation to insurance matters or other matters associated with dealing with the circumstances of loss of property, loss of employment, etc., associated with the floods. So that is for 2 years, and as I said, we're quite advanced in the negotiations with New South Wales and Queensland on that. In terms of the additional funding for the Insurance Community Legal Centre, I'll just ask Ms Harvey to talk to that one.
Certainly. So the Financial Legal Rights Centre is an additional $2.46 million over 2 years, and they provide a range of specialist legal assistance, and they're a community legal centre, and they operate nationally. So that funding will be provided through the department and the Community Legal Services Program.
And they provide a service where other legal service providers can refer clients to them because of their expertise in assisting people with a range of matters associated with insurance matters.
Thanks, Ms Jones and Ms Harvey. I will leave it at that. My time has expired. Senator Carr, are you seeking the call?
Thank you very much.
Senator Carr.
Can I just be clear about it? Is it a better way to describe these, what I call non-disclosure agreements, is a confidentiality agreement? Would that be a better...
Non-disclosure obligations.
I see. It's because, I mean, the issues, of course, were canvassed by Commissioner Jenkins in both respects, both confidentiality agreements and non-disclosure. And it's a term that yourself in the department's used, so I'll be clear about that. Could I ask, Ms Harvey, were the victims of this sexual harassment actually asked their opinions on the disclosure of the compensation amount in aggregate terms?
Senator, I'm not aware of that. I would need to take that on notice.
Is anyone aware of that? Have they actual victims?
Our role in this has been through the obligations under the Legal Services Directions around the settlement of significant legal matters. So in that, the Attorney General's Department itself isn't at the negotiation table, so to speak. These matters are handled by the government's insurer, ComCover.
Sure.
So that's just not something I have in my knowledge.
I can see the distinction. How do we know what the victims actually feel about this matter?
Senator,
I don't really think that's a question
we can't answer that.
That's
You can't
in order,
answer it.
Senator Carr.
Yeah, Senator Carr, we weren't at the table.
Right.
But
So I'm just saying there is an argument in regard to these agreements that if the victims were to seek to have these matters remain confidential, there I can see the legitimacy to that point of view. But it's put to me that they're happy to have this amount, the compensation amount, made public. That is, at least in aggregate terms. Is that? Can you confirm that or not?
We can't comment on that because we weren't part of the negotiations, Senator Carr, but all that we can add, but I think we've already canvassed this and you've recognised it, is that the terms of each of the settlement deeds were agreed between the Commonwealth and each of the claimants.
Sure. So the aggregate figure of in excess of $1 million has been publicly available.
We can't comment on that,
It just
Chair.
strikes me that that's a very substantial sum by anyone's measure, and whether or not the question here then is about who is actually being protected by these arrangements. It comes to the fore. Who, in your judgment, Attorney, is being protected here?
Well, again, Senator Carr, the non-disclosure obligations are consistent with the directions. We were not at the table in terms of the actual negotiations themselves. As I've pointed out to you, this is not unique to a particular government. The Labor Party has utilised confidentiality obligations previously.
Both those scandals, from my memory, were actually scandals involving the Liberal Party, but, you know, we won't go to that question. I'm asking specifically here whether the women's lawyers say they're happy to have the information provided. That's on the public record. Perhaps I should table this proposition.
So what document are
There's an article that's just been published by Jacqueline
Is
Maley.
it just a newspaper article?
A newspaper report where it asserts that that's the case.
Senator Carr, I would just like to stop you for one moment and remind you that the committee has accepted the PII claim. Now, it is ultimately a matter for the Senate.
No, but that's right.
And I appreciate that you want to ask questions about this, but just to reiterate that the committee has accepted the validity of the PII claim.
Madam Chair, of course the committee's going to accept a government majority on this committee. Let's not be silly about this.
No, I'm just reminding.
I'm entitled to ask for the rationale behind it.
Senator
And I'm
Carr.
having trouble
Not
following the rationale because I can't see one other than the protection of a person that has been harassing women on the High Court, has been a member of the High Court, is only too happy to bring to question the motives and ethics and behaviour of many other people, including major political figures in the country, but we've been found through this inquiry to be behaved in most unethical, unprincipled behaviour for many years, and now being covered up by the government.
Senator Carr, can I just ask you
why?
Well, could I ask you not to raise your voice? Please put your questions in an orderly way.
Very orderly way. Why is the government protecting this known sexual harasser and trying to prevent this information become available to the public? After all, it is public money. Is there not a case here that this actually encourages people to behave very badly in high positions because they know that certain elements of the government are going to be protecting them?
Senator Carr, I completely refute the premise of that question, the allegations that are in it. I think the fact that there was an investigation by the High Court, there was an investigation by Dr. Vivian Tom. There was an independent, non-statutory investigation into the allegations made by a number of former associates. The report had been provided to the High Court. It recommended changes to the court's workplace practices and procedures. Chief Justice Kiefel of the High Court has issued a public statement in response to the report's findings. Chief Justice Kiefel, on behalf of the High Court, apologised to the former associates. So again, what you've just put to the committee just is not sustained by the evidence.
On the contrary, the Chief Justice has made a statement in regard to that. Weren't you also required to make an apology as part of those orders? Isn't that the case?
Again, Senator Carr, I understand on behalf of the Commonwealth.
Yes, that's right.
But again, Senator Carr, you're saying that there is a protection racket occurring here. It's just not sustained by the evidence, Senator Carr.
Well, except to this extent, that over $1 million has been paid in compensation, it would appear. The victims of this harassment are happy to have this information made available to the public. And I would have thought there's actually quite an important element here to explain to what actually happens in these circumstances, and that it's the Commonwealth that's insisted on confidentiality, on secrecy on that. It is the Commonwealth, not the women. That's the case, is it not, Attorney?
Not in the way that you've put it, no, Senator Carr, no, it's not.
Well, I mean, you then say to us that, well, we've got to have some sort of realistic management of people's expectations. What does this message really send about a management of realistic expectations? What does it send to the women that actually bring forward a complaint, have the courage to bring forward a complaint against very, very powerful people, have this sort of cover-up occur?
Well, again, Chair, there has been no cover-up. I think Ms Harvey has addressed this question and has addressed it several times. I understand the article that I believe has just been tabled, and I'm just looking at it. Senator Carr
and what I've indicated,
clearly states the settlement signed by the three women did not prevent them from talking publicly
that's not the issue.
About the details of their experience with Hayden. So in the first instance, that goes to what I had previously raised. It also says, Senator Carr, it was reported to be a very large sum. The complainants were very happy with, according to their lawyer, Josh Bornstein. So again, Senator Carr, the way that you are characterising what has occurred is just not substantiated on the evidence.
So the issue remains, why is the Commonwealth keeping this amount of settlement amount,
Chair,
aggregate amount? It's not on privacy grounds.
In her first question.
Why?
Senator Carr.
And that remains my
Senator
question.
Carr, you have asked this question on a number of occasions, and repetitive questioning is an issue. Do you have any other questions?
Yeah, look, We have a known sexual predator that's costing the taxpayers an enormous amount of money, who's luxuriating on a very substantial judicial pension of hundreds of thousands of dollars a year paid for the taxpayer. I would have thought we have a right to expect that the government would actually reveal the amount of money they're paid in aggregate for this in terms of compensation for these three women.
Last question, Senator Carr.
Well, it's a simple question. What part of that statement I've made is incorrect?
Well, again, asked and answered on several occasions by Ms Harvey.
Senator Carr, we will need to move the call around. I'm going to give the call to Senator Van.
Thank you kindly, Chair. I've just got some questions about the increased funding to the CDPP.
Yeah, thank you.
If the right person, do they go to you, Madam Secretary, or?
We will bring someone else to the table who can talk through that funding, which is, I think, one of the more significant injections of additional funding into the CDPP for quite some time.
Thank you, and welcome back, Ms Chidgey. Good to see you again. So I believe my assertion is correct that there has been an increase of funding to the Commonwealth Department of Public Prosecutions. Is that correct?
Thanks, Senator. That's correct. So in the budget, the CDPP received $15.7 million over 4 years, and then $4 million each year from 26-27 ongoing to increase particularly its skilled prosecutors and manage the increasingly complex workload they've got. So I think in particular that will enable them to increase the number of their junior prosecutors by 27.
Terrific. And so why is this funding increase and what it's enabling? Why is that important?
Increasingly, the CDPP is working with law enforcement agencies on complex investigations that are more resource intensive, working across multiple agencies and are transnational in nature. So in terms of resourcing the CDPP to deal with those particularly complex prosecutions, this budget measure will make a significant difference to that.
Can you talk us through what type of complex matters that have seen this increase in the CDPP over the last 12 months or so?
I think amongst those, some of the international organised crime prosecutions, as well as complex corporate criminal matters. I'll see if my colleague Ms Field has further information.
Thank you, Senator. Autumn Field, Assistant Secretary, Transparency and Criminal Law Branch. So the DPP has been increasingly focused on complex matters, including espionage, foreign interference and money laundering offences. And it's anticipated that the highly complex cases will represent more than 50% of their caseload by 2025.
50%?
That's correct.
Wow. And they're big, complex and quite important matters.
That's
to keep
correct.
Australians safe too.
And the DPP really needs to get those junior prosecutors in place now so that by the time that caseload is apparent, they have sufficiently trained prosecutors to deal with those cases.
Thank you very much. Thank you, Chair.
Thank you very much, Senator Van. Look, I just want to return to this issue of the settlement minister, because just in looking at the government guidelines in relation to official witnesses giving evidence, so one ground on which a PII claim can properly be made is if it impacts on the impartial adjudication of a particular case.
And I think that's what Ms Harvey has been referring
Yes.
to in the evidence that she has given.
So there were a number of complainants in this matter.
That is correct.
Very serious matter, of course.
Correct.
And there may well be other settlements, and so therefore my understanding is that the department is seeking not to prejudice the settlement of any other claims. Is that correct, Ms Jones?
And Ms Harvey, I'm more than happy if she would like to
Ms. Harvey?
elaborate for you on that.
Senator, the Commonwealth was the party in this matter, so these are matters brought against the Commonwealth, and it is and for that reason the Commonwealth is very wants to ensure that matters are dealt with on their individual basis. As I noted earlier, all legal claims are dealt with on the individual facts of the matter, and that would be appropriate for any further claims of this nature that would come forward. For that reason, it is appropriate that these matters, that the final amounts are not disclosed, given that they may set an expectation or that an applicant would have that might not necessarily fit with the facts of their individual matter. And I'm not talking about additional matters in this particular cohort, I'm talking about in the general sense.
All right, thank you very much. Look, I just very briefly wanted to touch on the additional budget funding for the actual department. Are you the best person to quickly address what those measures are, Ms Harvey?
Because it covers more broadly, I'll ask our Chief Financial Officer to come to the table.
Afternoon, Senator. Scott Sharp, Chief Financial Officer. So overall, the Government announced $230.5 million over 5 years for new measures for the portfolio. 117.8 million over the 5 years to the department. There was also some of that being paid to the states and territories through Treasury, and 112.7 million over 4 years to portfolio entities. So my colleague has already ran through the women's safety measures. Happy to go through them again if you like, Senator, or I can touch on some of the other measures.
Just some of the other measures that haven't been mentioned would be appreciated, Mr Sharp.
Excellent. So some of the significant ones to the portfolio was an additional $17 million over 2 years to the Office of the Australian Information Commissioner to carry out its privacy functions. So that was significant funding for them. There's also $8.3 million over 4 years to assist small business, including through the Fair Work Commission, which is discussed at our other committee.
In what respect? Could you just explain?
It's in relation to improving user experiences with the Fair Work system, so that's covered by our IR colleagues at the other Senate committee. There's also in there additional funding to the Administrative Appeals Tribunal of 1.6 million to be met from existing resources to help them with new case management solutions. In addition to that, we have also secured additional funding of 6.7 million for both the department and the CDPP in relation to supporting the work arising out of the Office of the Special Investigator. And we also have got $3.6 million over 4 years with some ongoing funding for the OAIC to implement the government's response to the inquiry into the future directions for consumer data rights. There's an additional 1.4 million over 2 years under the Commonwealth's deregulation agenda to implement document execution reforms that should potentially save small business and consumers about 400 million per annum, which again goes to the other Senate committee.
I mean, I'm interested in that measure because that's quite revolutionary, isn't it, in terms of the efficiency for small business, particularly when, of course, many businesses have endured very difficult circumstances through the last couple of years. Are you able to explain in more detail how that would make a real difference for small businesses?
So I don't have the detail of that at the moment and was probably canvassed at the IR group. I don't know if any of my colleagues have that to hand.
Or just in general terms, the improvements or the changes in document execution measures?
So with that measure, that's broadly part of the government's deregulation agenda. So looking at ways in which, in the course of everyday business for small and medium-sized businesses, in terms of statutory declarations or other official documentation, it probably hasn't really changed much over the last few hundred years. So this is an opportunity to bring some of those processes into the digital age and reflects the way that businesses need to conduct their work with their clients, but also enable them to be able to engage in those official processes in a more modern and digital way. Our assessment is that that can potentially save hundreds of millions of dollars for small businesses and consumers through the digitisation of some of those processes.
Thank you very much, Ms Jones. We are continuing in cross-portfolio general and corporate matters, and we'll now move back to Labor senators. Senator Carr, you've got some more questions?
Yes, I have. Ms Harvey, I just wanted to follow up your previous answer in regard to this question of Mr Justice Hayden, in regard to the issue of managing unrealistic expectations. And are you suggesting that there's a deterrent effect in the Commonwealth's response here?
No, Senator. What I'm suggesting is that, what I'm saying is that the Commonwealth has an obligation to ensure that it is approaching each claim on the basis of the facts and circumstances of that claim, and that the amount arrived at in settlement of a particular claim reflects those facts and circumstances,
Sure.
and they will be unique in each claim.
Yes, of course they would. I just can't follow why that would be, how that facilitates the management of expectations, as the letter that the attorney sent to the committee suggests. How does that occur?
Senator,
I mean, that's normal legal process, isn't it? That the facts determine the outcome. Isn't that the principle in terms of the way in which our open judicial system operates?
And Senator, so for claims that are brought that are not necessarily litigated through the courts but are settled, which is often in the interests of...
I see. I'm sorry. I mean, how silly of me. So
Sorry,
this is
Senator
about
Carr.
managing the negotiations.
Senator Carr, if I could just ask you to allow Ms Harvey to complete her answer. Ms Harvey.
So there is an ability for claims to be settled out of courts,
I
Senator,
got
which
that.
is
I
often
got
in
that.
the interests of
Yeah, I got that. I got that. So
parties.
you really are trying to
Senator
manage.
Carr,
You're trying to manage the
Senator Carr,
negotiations.
I'm just going to ask you to hold there. I'm sorry. I know you want to go through your questions quickly,
Yeah,
but
I
please
do.
just allow the witness to complete her answer.
Sure.
So in the management of claims that, in the claims that are made not through necessarily a formal litigation process, there are then a range of factors that go into the final determination of those amounts. It is important that the Commonwealth does have the ability to approach each of those claims on their facts and as at the point where they are.
Okay, so in the case of these particular women, their lawyers said that, a press statement back in February, they said that there had been lengthy negotiation process reflecting the unusual circumstances of the case and an unfortunate delay by the Commonwealth. Is that right? Was there a delay by the Commonwealth in resolving these claims?
Senator, as we've discussed previously, the department itself was not a party to the negotiations.
Yes, I understand that. You're not. You're the client in effect here, aren't you?
No.
Well, how do you describe your role in this?
Our role is through the responsibilities that we have in the Office of Legal Services Coordination to provide advice to the attorney as to compliance with model litigant obligations and any advice about the appropriateness of a settlement.
Okay, and being a model litigant, that's the role of the Commonwealth as well, isn't it?
It is, Senator.
Yes. So when did the negotiations actually commence for these three women?
That might be better put to ComCover, because that's the issue. It's ComCover
Okay,
as opposed to the Attorney General's
I'm
Department.
trying to establish whether or not the claims made by the women's lawyers are accurate in regard to a delayed process of negotiations.
For you,
Right,
and put it to
we'll do that.
ComCover.
Okay, there they go. And you see, because according to the news reports at the time, there'd been accusations actually directed at the government through the Prime Minister about prolonged trauma of the three women with whom the sexual harassment was not actually disputed by the Commonwealth. The Commonwealth hasn't disputed the claim on sexual harassment, have you?
Well, I think because we were not a party to those negotiations, but I think...
well, all right.
No, I think it's probably
I can see your answer there, but can you advise me on whether or not the Commonwealth disputed that there'd been wrongdoing?
Senator, all I can say is obviously between discussions between the claimants and the Commonwealth, it was agreed in terms of their experiences in terms of the sexual harassment, and the settlement was negotiated accordingly.
So I just want to be clear, because you did these negotiations on the facts, is that right? Ms. Harvey, that was the basis of the proposition you put to this committee. There was an assessment of the facts, and the Commonwealth did not dispute the wrongdoing in regard to the allegations made against the former High Court judge.
Senator, each claim, in a general, I'm not talking about these particular claims. My evidence was that claims are dealt with on the facts and circumstances as each apply to them.
Sure.
I would note that in the statement made by the attorney on the settlement of this matter, it noted the investigation by Dr. Vivian Tom, and who found that Dyson Hayden ACQC had sexually harassed all 6 complainants, and that the Commonwealth has engaged in good faith discussions.
Thank you. So my assertion that the Commonwealth is not disputing the wrongdoing is in fact demonstrated by the statements made by the attorney and by the High Court itself in terms of the settlement process. That's true, isn't it?
So the settlement acknowledges the investigation and the engagement in good faith discussions.
So what I'm trying to establish, though, is was there a delay in the process, given that you acknowledged the wrongdoing, given that you apologised, the apologies occurred by the most senior legal officer of the government, and given that the Chief Justice of the High Court acknowledged all of these propositions? I'm just reading from one of the statements here from one of the women, who said that since the High Court's own investigation found that Dyson Hayden sexually harassed me and other women while we were his associates, I've gone above and beyond to provide the Commonwealth evidence of the harm I have suffered because of the harassment. Every week this matter continues is an extra week I have to manage life with a debilitating anxiety caused by post-traumatic stress disorder. With every step, every communication in this compensation process triggered my illness. Every week is an extra week that I have no income, as the precariousness of my mental health makes it too difficult for me to work. Every week is a week I am not able to direct my energies towards improving my mental health and moving beyond this chapter of my life. And what message does the Commonwealth delay send in this to the community, to the women, to the victims of workplace sexual harassment? Is this what accountability looks like for wrongdoing by one of the country's most powerful men, wrongdoing that was found to have occurred by the High Court's own investigation, wrongdoing that the Commonwealth is not disputing? Now, is that statement accurate?
I'm not sure where you're...
Well,
where
it's an article that was appeared in an article by Sam Maiden. I'll table that article if you like. If you think I've misquoted it in some way.
It would be very helpful if you could table that report.
Sure.
Senator, sorry.
No, that's okay, go.
Well, I just reiterate, we were not a party to those negotiations.
Look, I'm not disputing that your interpretation of the approach that you took in the process itself. I want to know, was the claim made that there'd been a delay in proceedings while you were assessing this or doing whatever you were doing that caused these three women increased trauma? What's the answer to that question?
Sorry,
Was there a delay in the proceedings caused by the Commonwealth, which actually led to these women's trauma being extenuated?
Senator Carr, can I just... I'm just concerned that some of these matters that you're raising going to the substantive claim are outside the scope of the Attorney-General's department, because these are matters that have been settled, as I understand, through ComCover. Is that correct?
Yes, but...
So I just don't think that the department...
But the Commonwealth is represented by this department here at these committees, and these are the chief law officers in terms of the Commonwealth agencies here before this committee. I'm asking whether or not the Commonwealth, why did the Commonwealth take so long to reach a settlement with the three women?
So, Senator Carr, just to remind all senators and those listening and watching these proceedings, the department is only able to answer questions within the scope of its operations and its financial expenditure. So it may be possible for Ms Harvey or Ms Jones to answer some part of the question, but bearing in mind I do believe that you are raising issues which go to ComCover's substantive...
Thank you for your advice, Madam Chair. Perhaps the officers can try to answer the question rather than you.
No, I'm not. No, Senator Carr, please don't reflect on me. I'm just reminding all senators that the department can only answer questions within the scope of its expenditure and operations.
I'm sure they have no trouble understanding their roles. I'm asking a question, is that why did the Commonwealth take so long to reach a settlement with these three women?
Senator Carr, as I set out earlier, our role in the Attorney-General's Department, under the Legal Services directions, is there are a number of matters that need to be reported as significant legal matters. There's a number of those. Our role is to ensure that when those matters are settled, that is approved by the Attorney or the Department as her delegate. So we will have some visibility of matters, but we are not in each of those matters, which can be quite numerous. So these questions really are better going to ComCover, who in this instance had carriage of the matter as the Commonwealth's insurer.
So, Attorney, you surely had an overview of these matters.
Well, again, I think Ms Harvey, Chair, has just outlined the role that the Attorney-General's Department has.
But I'm asking you as Attorney-General...
ComCover.
I'm asking you as Attorney-General, as distinct from the department, did you have an oversight of these matters, Attorney, or not?
Not an oversight, no, Senator Carr. I think Ms Harvey has made it very clear that the negotiations were between ComCover and the parties. They were managed by ComCover as the Commonwealth's insurer.
And you had no role in that matter?
Senator Carr, we will need...
I'm sorry. Explain that to you at the last estimate.
Sure.
Senator Carr, we have gone over your...
Questions about the management of the matter actually should go to the Department of Finance.
Yeah, okay.
Senator Carr, we will need to move to other senators. Thank you. And obviously, just in terms of this section of the program... All right. Thanks very much, Senator Carr. Senator Scarr.
Thank you, Chair. I wanted to ask some further questions in relation to the money which is being provided under the budget in relation to legal assistance services to support the relief and recovery in New South Wales and my home state of Queensland in response to the floods.
Well, I might ask Mr Knott to come to the table. He's personally leading the negotiations in relation to this funding and can provide you with plenty of detail.
Thank you, Senator. Adam Knott, Acting Assistant Secretary, Legal Assistance Branch. Sorry, could you just repeat the question for me about the flood?
I haven't asked a question yet.
Oh, sorry.
I just gave you the subject, so you're okay. You're okay.
I could give you an answer, though. Don't worry.
So, Mr Knott, in terms of what services precisely would be supported with this funding, can you provide some colour and movement around that?
Yeah, certainly, Senator. So The funding would be directed to existing legal assistance providers, so that's being legal aid commissions, Aboriginal legal services, community legal centres in both New South Wales and Queensland. So the funding can be used to deliver any type of legal service that they would ordinarily be delivering. So those services would range from community legal education sessions with members of the community, legal advice as you would sort of traditionally formally know it, legal information services, referral services from one sort of key provider to another service, and the Secretary earlier mentioned the services provided by the Financial Rights Legal Centre and their insurance law service that has also received additional funding. So there's a range of activities that they would do for the communities that have been affected by those floods.
Okay. So insurance, when I saw this initiative, which I strongly support, the potential nature of the legal services to be provided, the first thought that came to my mind was assisting people with respect to insurance claims, which can be a difficult process at times, and people may not be aware of their rights with respect to pursuing insurance claims. Is that specifically dealt with in terms of this funding?
So in terms of this funding measure, it's not specifically called out. It would be left to the states and the territories and the providers of services to essentially determine what it is that the community needs the most. And if it is advice and support around insurance processes, that's the kind of service that would be delivered in those communities. This is there's been several sort of packages over time of legal assistance in response to disaster measures, and we do often see insurance matters arise, not necessarily immediately after the event, but sort of 6 to 12 months further down the track. So we would anticipate that a meaningful proportion of the services that are delivered would go towards supporting insurance matters.
So based on that previous experience you alluded to in responding to disaster events, what other specific areas in terms of legal assistance have arisen in addition to the insurance matter?
Yeah, in sort of past matters, and they really have ranged from sort of tenancy, housing issues.
Okay. Yep. So this is exactly the sort of information I'm looking for. So people, for example, not sure of their legal rights in the event that their property is inundated and they're having difficulty dealing with the landlord with respect to what rights they have under their residential tenancy. That's an example?
That's right, Senator.
Right.
So just to give you some further examples, if that's useful. So the government had provided funding previously in response to the bushfires. That money, for example, the most common sort of service that was provided was around civil law matters with, let me just work through this for you, Senator. The service data from state performance reports indicated that at a national level, the most common problem types for services delivered to the community were financial hardship, employment, domestic violence matters, credit and debt, housing, consumer, legal matters, wills, estate, tenancy, that kind of matters. So it really varies depending on what is happening in the community.
Okay. How do you, and this might be the subject of your negotiations, and I don't want to pierce the veil of confidentiality in that regard, but how do you divvy this up between the legal aid commissions and the community legal centres in terms of making sure that the taxpayer and we get the best bang for our proverbial buck, but more importantly, making sure that it's going to the agency, whether or not it be legal aid or a legal community centre, that's appropriately located and resourced to deliver the legal assistance most efficiently and effectively?
Yeah, so Senator, I guess the Commonwealth's primary role in the distribution of the funding is determining how to split it between individual states. So to undertake that part of the process, we've relied on data from the National Resilience Recovery Agency and RRA. The state themselves are then tasked with the responsibility of allocating that funding to individual providers within their jurisdiction based on need. So the Commonwealth, we the department, will monitor and engage with the states and territories to understand how they are allocating it and where they're allocating it to individual providers. But whether they allocate it to a particular centre will be a matter for the state to determine. But what our general experience has been is that the funding is often allocated to the services that are within the communities where they're operating. Legal aid commissions obviously operate across a jurisdiction, so they would likely receive an allocation of this funding, but it would almost certainly be directed to centres or offices within those affected communities.
Right. And are there any reporting obligations attached to the funding so that the Commonwealth can make an assessment as to the success of the provision of this legal assistance, for example, in terms of the number of clients who've been assisted where they live, and perhaps any other key performance indicators which the Commonwealth uses to assess the success of the funding in terms of providing meaningful support to people?
Senator, I guess the best answer I could provide is yes, there will be.
That's a good answer.
Those negotiations and conversations with the states are currently underway.
Yep.
So we haven't completed that process to sort of definitively tell you what they will be, but our expectation is that yes, there will be performance reporting built into the agreement between the Commonwealth and between Queensland and New South Wales.
Yep. Okay. Thank you very much, Mr. Knott.
Thank you very much, Senator Scarr. I'll give the call now to Senator Grogan.
Thank you. Senator Cash, did you instruct the Commonwealth Solicitor General to advise on and appear in the hearing on Thursday last week in the High Court matter of Morrison versus Camazzelli?
I'm assuming you are talking about the Section 78B proceedings?
I'm afraid I don't know what the exact numbering of that proceeding was, no. But I think you're well aware of the one I'm talking about.
Well, just to be clear, there was an application for removal to the High Court in relation to an issue that had arisen in the New South Wales Court.
That's correct.
Correct, on a serious constitutional issue that needed to be determined quickly and finally. So Justice Baston, just by way of background so you understand what had occurred, of the New South Wales Supreme Court on Wednesday the 30th of March had made the following comments. In relation to the need for a Section 78B notice under the Judiciary Act 1903, I note that the issue was raised but apparently not resolved in the Victorian Court of Appeal decision in Asmar v Albanese. It seems to me there is an argument that the Commonwealth Electoral Act is identified in a way which invokes federal jurisdiction. I can also see an argument that because justiciability is put in issue in relation to the powers of this court in this matter, there is a matter which arises in federal jurisdiction and therefore is a constitutional matter. So on that basis, the Section 78B was issued.
So you directed the Solicitor General to attend the High Court on this matter?
Well, that is correct, because the Solicitor General would normally act for the Commonwealth.
And the Chief Justice described the issue as very tenuous and in fact threw it out, that it was not a constitutional matter, and returned the matter to the New South Wales Court.
That is actually incorrect, and I will just turn to the orders were Order 1 On the application for removal, there will be the following orders. Further compliance with Part 26 of the High Court rules be dispensed with. The whole of the causes proceeding number X pending in the New South Wales Court of Appeal is removed into the High Court.
So you're saying that it has been removed to the High Court. My understanding from all the material I have seen is that it was not, that it was returned to the New South Wales to be heard, I believe, later today.
So what occurred was the matter having been removed into this court, the court then further ordered that the matter be remitted to the New South Wales Court for reasons of urgency, efficiency and utility. So just so you understand, the question is whether a constitutional issue arises. If it does, is it able to be heard by the High Court? So in other words, removed is the word that is used. The High Court accepted that, but because there was the New South Wales Court of Appeal hearing, they remitted it back there for determination. And I'm happy if Chair, if it would assist, because it is an interesting matter, for what a Section 78B notice is, because these get issued all the time.
I am well able to go and look that up myself, but thank you so much for the offer. I think the challenge that I see here is the Commonwealth, yourself as the Attorney-General, directing the Solicitor General to intervene on a matter, that, if I could just finish, to intervene on a matter which is effectively a factional brawl in which the Prime Minister, Scott Morrison, is involved in on the taxpayer dollar, when it has been said in the transcripts that the constitutional matter is highly tenuous.
Okay, unfortunately you are completely wrong in what you have just stated, and this is why, Chair, it might be appropriate for one of the departmental officials to actually explain to the committee what a Section 78B notice is, because there was no intervention, there was no expression of opinion in relation to...
Well, there was no intervention because it was not accepted.
No, see, Senator Grogan, you don't seem to know what a Section 78B notice is.
I've already told you that I am not familiar with that.
I
am not a lawyer,
for the benefit of
Senator
the
Cash,
proceeding.
and I feel that
that's
asking
why,
questions here, having you be condescending, is not necessarily helpful when I'm just trying to get to the bottom of the matter.
So you actually used the word intervention. There was no intervention.
Senator
But
Grogan,
there was an attempt for an intervention.
Senator Grogan,
without
there wasn't.
In an attempt just to be helpful for the committee, would it be possible for the committee just to be very briefly informed as to what a Section 78B application is? Because
and
I think
the threshold is.
Could I just ask for a very brief? Because I understand
Just so you
that
can
Senator
understand.
Grogan wants to get through her questions, but we just want to very briefly understand what that application was, please. Would that be all right, Senator Grogan?
Sure.
Thank you. But just keep it brief. Thank you.
David Lewis, General Counsel, Office of General Counsel. Office of Constitutional Law in the Attorney General's Department. So there is a distinction between intervention on the one hand and removal to the High Court on the other hand. In a nutshell, Section 78B of the Judiciary Act requires parties in cases in all courts in Australia to give notices to all Attorneys General, the Commonwealth Attorney General, State and Territory Attorneys General, whenever a constitutional issue arises in the case. When those notices come in, that's considered, and the attorneys all have a ability under Section 78A of the Judiciary Act to intervene in that case and make submissions. Separately from that provision, the Attorney General also has a power under Section 40 of the Judiciary Act to apply to the High Court to have a case in a lower court removed into the High Court. So there's more details, but that's it in a nutshell.
Thank you,
If the threshold is met for the constitutional issue.
And so the threshold was not met?
No. So that's why I read out to you Baston's comments, because Baston basically says, therefore, there is a constitutional matter. The High Court itself accepted the removal, but then referred it back for expediency to the New South Wales. But to be clear, just so you understand, based on what the General Counsel has said, in these cases, there is no expression of whether or not you support either party's case. That's not what this is. So there's no expression of support.
Well, it certainly...
Just 2 more minutes, Senator Grogan.
It certainly looks curious. I will go and further read the transcript.
Yes.
But it does look quite clearly that this has been an intervention on a matter which is a matter of factional dispute within New South Wales,
No,
for which...
Again, Senator Grogan, you can't use the word intervention because there's no intervention. There is no
Okay.
intervention.
So the appearance of the taxpayer-funded Solicitor General at a hearing to appear, because I believe...
So the Solicitor General...
Do you mind
Yep.
if I just interrupt you
Perhaps
for one
we
moment?
could get a better
Mr. Lewis,
explanation.
can I
Maybe
just
that's-
ask, there is a legal definition of intervening in a court
I'm
case.
using the intervention. So not everyone is legally trained.
but you
I am
can't-
not.
yes,
the
so-
utilisation of
I
the term
completely
intervention.
understand.
So I will avoid using that term.
Do, because they're two entirely
Yes,
different concepts.
Indeed.
Yep.
But as we try very hard not to make our parliament completely inaccessible to anyone who is not legally trained, maybe we could just tread through this one knowing that what
no,
I'm
but
talking
we
about is
can't use the word
appear,
intervention, and that's
appear,
what I'm trying to say to
and
you.
I'm saying appear.
Yep.
Appearing on behalf of yourself or on instruction of yourself, because I know in many of the, in the transcript, what the attorney has in mind, what the attorney wishes to do, was a lot of the terminology utilised. So therefore, acting on your behalf.
Well, the Solicitor General acts on behalf of the Commonwealth.
Yep. Advised by you or directed by you, as is the way that...
Because he acts on
that's how it
behalf
works.
of the Commonwealth.
Senator Grogan,
in the
I'm sorry,
High Court.
we are at time. I'm going to need to move the call around, and I now give the call. We can come back to you, of course, but I'm now going to give the call to Senator Scarr.
Thank you, Chair, and I'm going to continue some questions in relation to this matter. And I should say, notwithstanding I am legally qualified, I've had to read the sections to bring myself back up to speed, and I'll be careful not to trip up on the removal and intervention issue. But the first thing I think needs to be clearly articulated, and I think, Attorney, you have done it quite well, but I just want to clarify this. This issue was first raised, this issue of whether or not the constitutional matters which were being considered as part of this case, it was in fact the Justice Baston of the New South Wales Supreme Court who's the one who said that he thought it is, and I quote, "it is sufficient that I think those matters are arguable," namely the whether or not it was a matter which arises in federal jurisdiction and therefore is a constitutional matter.
Correct.
So it was Justice Baston who in fact said it is sufficient that I think those matters are arguable. I think a Section 78B notice is required in this case, end quote.
That is
so
correct.
It was Justice Baston himself,
correct,
or herself, who triggered the process, if you like,
that is
of the
correct.
Section 78B notice being issued and sent to the attorneys of each of the Commonwealth Attorney, but also the attorneys of each state and territory. Is that correct?
That is correct, and I'll see if Mr. Lewis.
It's certainly correct that Justice Baston in the New South Wales Court of Appeal directed the issue of the 78B notices.
That's
correct.
right.
Right. And from what I've read, Justice Baston also queried why it was or noted that a similar issue was not resolved in the Victorian Court of Appeal decision in Asmar v Albanese. Is that correct?
That is correct. There was no 78B notice of a constitutional matter issued in that Victorian matter.
Should there have been?
Well, it's a very good question, actually, and so that's why Justice Baston goes on to say, it seems to me that there is an argument that the Commonwealth Electoral Act is identified in a way which invokes federal jurisdiction. Similar issues did arise in Asma v Albanese.
And sorry, just for people's, if they're watching this, what did that case involve?
I'm happy for Mr Lewis to...
I'm not familiar with all the details, but in very broad outline, it involved a dispute about the Labor Party's rules and pre-selections in Victoria.
Right.
So basically the Labor Party themselves as a body pre-selecting candidates versus really should the court step in and choose the candidates.
Right, okay.
Or should the court decide a dispute in relation
In
to
relation to.
Yeah, okay. So Justice Baston determined that a Section 78B notice should be issued in this case.
And then he directed, I believe, the solicitors for the defendants to issue the 78B.
Okay, so that happened in the ordinary cause. Is that correct, Mr Laws?
That's right.
And at that point in time, let's be absolutely abundantly clear, Attorney, you had absolutely no role whatsoever in terms of Justice Baston coming up with Justice Baston's own view and with respect to that 78B notice being issued. You had absolutely no role in that whatsoever.
It's not unusual for a 78B notice to be issued in the event that a justice determines there may be a constitutional issue.
Right. So then once the Section 78B notice is issued, then it's a question for the presumably the Attorney General's Department, Solicitor General considers what do we do with this notice, what is the best way to ensure that if there are constitutional matters which are being ventilated, what's the best way that they be ventilated and determined by the courts.
Correct.
And that presumably you have it's a pretty standard range of matters which you'd consider upon receipt of the 78B notice?
It's set out in the Act. I don't know if Mr Lewis has the...
I do have the Judiciary Act which provides for the issue of 78B notices, but it's certainly true that we regularly receive 78B notices and they're considered, and in some cases a removal application is made, in some cases intervention occurs, sometimes both of them together. Can I just make one other point in relation to the issue of 78B notices? Often it's the parties who themselves decide that a notice has to be issued, and as I said, one wasn't issued in the Victorian case, and that's, as I understand it, because they didn't make their arguments in constitutional terms. So the parties can argue what points to make, and the parties in the Victorian case didn't argue on a constitutional basis, but the parties in the New South Wales case did.
But as I also understand it, Mr Lawson, here we are. I'm going to. I can't not refer to my legal reading of the section. It's also the case, isn't it, that the court has a duty in the event that a matter comes before it, such as came before Justice Baston, where they identify there could be constitutional issues. The court is actually exercising its duty under the Judiciary Act insofar as they're saying to the parties, well, I think maybe you need to issue a Section 78B notice, and until that's issued, until the matter's resolved, in that regard, I'm not going to continue to hear the matter. Isn't that the case?
Sorry, you're right, Senator. I misunderstood exactly what you were saying before, but it's correct that the provision provides it's the duty of the court not to proceed in the matter if the matter raises a constitutional issue. Often courts have their own rules which seek to put an obligation on parties who raise constitutional issues to issue the notice, but you're quite right. Section 78B(1) places the duty on the court not to proceed if a 78B notice hasn't been issued and the case does raise a constitutional issue.
Okay, and then what happened then after the 78B notice was issued? I think it initially went to the Attorney's Office, and then in the usual course it was passed on to the Department, and it was considered then by the Department and including the Australian Government Solicitor and the Solicitor General,
and then the attorney made a decision about intervention or removal, and the attorney decided to seek removal of the matter into the High Court.
So basically that there was the threshold for there being a constitutional issue was significantly sufficient to apply just to remove the case to the High Court for determination.
Yeah, and
That's
that's a decision you make.
Correct.
In the ordinary course,
Yep.
applying the test that's in the legislation.
Correct, and the fact that
presumably-
Baston had already determined that, and the
Yep.
fact that you also had Asmar and Albanese on similar issues in the High Court, but the constitutional issue wasn't raised in Asmar and Albanese.
But Justice Baston, as the judge in the lower court, actually said that he thought, or she thought, that those matters are arguable.
Correct.
So
Hence
you
why
had that
the
indication
Section 78B was issued.
Exactly.
Yep.
So then it goes to the High Court, and then it's up to the High Court, again, discharging its responsibilities in the usual course, to determine how best to effectively and efficiently deal with the matter. Isn't that the case, Mr. Lewis?
That's right. The parties made submissions to the Chief Justice, and she decided how to handle the matter. And as the attorney indicated, apparently accepting that there was a constitutional issue, she made an order removing the case into the High Court. And I should just point out there, when a case does involve a constitutional issue and it's the attorney who applies for removal, the High Court is required to remove the matter. So the High Court did remove the matter, and then for the reasons that the attorney indicated, the High Court immediately decided to remit the matter back to the New South Wales Court.
Which is, again, that's all in the ordinary course.
Yep.
In terms of the Chief Justice, who I know comes from the great state of Queensland,
Yes.
determining the best and most efficient way to resolve the matter as expeditiously as possible. And in this case, on the facts, the Chief Justice, the High Court determined that it should go to the Court of Appeal to be dealt with.
Correct.
Right. So, in summary, this is, from your perspective, Mr. Lewis, this is something that just followed an ordinary course in terms of the provisions in the legislation being applied as they should be applied, and the judges at various levels discharging their obligations. Is that correct?
It certainly was just an application of the provisions. It was much more urgent than often these are, but that I think has to do with the timing of the Court of Appeals hearing, which was scheduled for Friday, Friday last.
Okay, thank you.
Thank you very much, Senator Scarr. Senator Van, you've just got one
just
added question.
Very quickly, Mr. Lewis. You said this happens regularly. Can you put some parameters around how often 78Bs are issued? And
I think over the last 15 or so years, Senator Van, that in fact I think if I've got it right, I think it's the average over the last 17 years of the number of 78B notices issued to the attorney is 222 per year. So
per year, not over the 17 years.
No,
222
per year.
on average per year. Thank you.
We've got another one coming up. I think it's the Montgomery matter next week or this week.
This week.
This week,
and
the
that's-
Montgomery matter.
So
that's being heard in the High Court.
That
Yes.
is being heard in the High Court. Attorney, I'm not sure whether you've intervened in that matter or if the Commonwealth was a party and so you're being consulted on the submissions.
So it's
I could
about
check
four a week. Thank you, Chair.
Thank you very much, Senator Van. I'll now give the call back to Senator Grogan.
Mr. Lewis, can I just clarify a point that you just made there, just so I'm clear? That if the AG requests a removal, that the High Court automatically removes? Is that what?
In a constitutional case.
In a constitutional case.
That's what Section 40, subsection 1 says, that the court shall remove.
Okay. So the action to remove that case while it was under the New South Wales jurisdiction has effectively delayed, because New South Wales was going to hear that case on Friday.
And they did. And they did hear it.
And I
Is my
believe
understanding. They did hear
Correct,
it on the Friday.
they did hear it.
That's
So-
why it was referred back. They did hear it on the Friday.
That they're not issued a judgment?
I don't believe so.
Not that we're aware of, Senator. We have been monitoring.
Sorry.
Okay. Just on that though, and I think Mr Lewis, the High Court in removing it though, Mr Lewis, does have to be satisfied of there being a constitutional question.
If it's going to occur under
40.
Section 40, subsection
Yeah.
1, which is the provision which requires them to remove
Yeah.
matters, there is a discretion for them to remove matters in other cases.
Yep.
So there's a level of debate about how robust the constitutional issue is here, and it does bring me back to the fact that this is a New South Wales factional brawl over pre-selection, and it seems that there's a lot of expense in sending the Solicitor General to look at this case, to appear on your behalf and look for the removal of that case. When it really is a factional brawl in New South Wales and the constitutional issue is tenuous.
Yep. No, so you already had Asmar and Albanese that was in the High Court itself, so a similar issue had arisen in relation to the Labor Party pre-selection. I think that was in Victoria.
It was the first, yeah, it was the first one in Victoria.
Yeah, no, just so you know, so you've already got a political party in the High Court in relation to what is a very similar issue.
But not represented by the Solicitor General of this country.
No, the Solicitor General represents the Commonwealth. He doesn't charge a fee to the Commonwealth. That's what he does. He represents the Commonwealth.
But it's a lot of resources applied to such issues.
Well, the intervention was only made on the day, so I only received the notice very late the night before.
So there was an intervention in the Labor Party case, but not an intervention. So I'm just
No. Yep. So you already have. So I'll just take you through
particular application
in terms
of that word.
The matter raises questions of justiciability, which involves applying principles under Chapter 3 of the Constitution and the continuing authority, this is what's so interesting, of a nearly 90-year-old High Court decision. So when you're looking at this and you need to look for, what courts do is they'll look to see, okay, so what's the authority on the particular question that is now being raised? The authority is actually a 90-year-old High Court decision from the 1930s.
Can you just give us a really solid definition of the constitutional issue that you believe is at play here?
I'll get Mr Lewis to take you through that. Just on that though, so it's a 1930s case, Cameron and Hogan, and the dispute also raises questions about federal jurisdiction and whether there is a matter for the purposes of Chapter 3 of the Constitution. But I'll get Mr Lewis to take you through.
Thank you, Attorney. That is essentially the constitutional issue. It might seem a little bit esoteric, even for some lawyers.
Or convenient.
Well, it's a genuine constitutional issue. The High Court has long held that it can only, as a federal court, it can only exercise jurisdiction in certain types of matters, which is a rather indefinite word, but that's the word used in Chapter 3 of the Constitution, a matter. And the court has said they won't, for example, give advisory opinions. They'll only make a decision in relation to a concrete application of law to facts. And they say that there's got to be an immediate right, duty or liability that will be quelled by the application of judicial power. So not everything that, say, a state court could do can necessarily be done in the exercise of federal jurisdiction. And when the attorney was referring to that old case, Cameron and Hogan, from the 1930s in the High Court, and that case wasn't itself put in constitutional terms. No constitutional argument seems to have been made there, not significantly, but the court did indicate that there was a dispute about the application of some political party rules, and the court said that's not the type of matter that a court should be involved in. It's a voluntary association and it doesn't create any legal rights or duties, so we're not going to be involved in that. There's been a lot of development in the High Court's consideration of Chapter 3 since then, and these days often those questions about whether a case is the type of case that a court especially a federal court will decide, or a court exercising federal jurisdiction, there needs to be a matter, and there's a whole different range of ways that's dealt with by the courts, which the High Court has said are all connected. There's questions about whether a plaintiff has standing to bring the case.
Justiciability.
Justiciability.
There's a question of public funding, is there not?
Well, that doesn't go to the constitutional issue.
But that's the point that Senator Carrick is raising. These are political questions, not constitutional questions.
Well, there's several matters dealt with in the case.
So can I just ask, the matter you're referring to previously from the 1930s,
Yep.
which was about a political party scenario, as we're looking at right now, has that been looked at any time since 1930, or is this the first crack at it?
There's been a number of lower court considerations of it. I'm not aware of further consideration in the High Court, but I haven't investigated that.
So it seems quite significant that, Attorney General, that you would then seek to act on this issue that hasn't really had much attention on it since the 1930s.
Not quite sure what that means.
Well, we're looking at a political party scenario. This is a political stoush.
Yep.
This is a factional stoush in New South Wales, the delay of which could be seen to be advantageous to the Prime Minister, Mr Morrison,
we make no
given
comment
that
on the
he
merits, though,
he is
of
caught
either
up within
case.
this brawl.
Well, but there's no comments on the merits of the case given. This is just whether or not there is a potential constitutional issue. That's the only threshold.
But surely you have a line of sight over this. And so we had the situation where a similar situation about who should or shouldn't be party to a political party stoush, and there was no action taken on the Labor Party scenario. Yet
It was a
you're
slightly
tasking
different...
the Solicitor General to act on your behalf in this situation, which is effectively trying to save the political skin of the Prime Minister.
No, and again, there is no view expressed on the merits. That's just wrong, unfortunately. There's no view expressed on the merits. The High Court may find the opposite way. The New South Wales Court of Appeal may find the opposite way. So there's no view expressed on the merits at all.
But the situations are of a similar nature, surely.
So I'm not quite sure where you're...
If I could be of assistance there, I think I said this before, but just to recap, the relevant difference, I think, between the two cases for the present discussion is that the parties, at least some of the parties in the New South Wales case, were raising a constitutional issue. So 78B notices were issued, and that provided the occasion for the attorney to consider whether to seek to remove the matter into the High Court or whether to intervene in the matter, or both, whereas the parties in the Victorian case don't seem to have been raising a constitutional issue, so there was no 78B notices issued.
So one of the things they said, and I've just been provided to me, is even the New South Wales Supreme Court recognised that the constitutional issue was not resolved by the Victorian Court of Appeal's decision in Asma and Albanese, and it's still not clear why a Section 78B notice was not issued in that case. So there is just no guidance there at all.
Well, it looks very clearly like this is a political intervention, again, based on factional interests.
You can't use the word intervention because it's not.
Okay, this is a political action.
Again, no, that's just not the case. This is a question of... there is a constitutional issue that the New South Wales Supreme Court recognised that there was a constitutional issue that needed to be resolved.
But there seems to be very limited public benefit to allocate the resources to take up the time of the Solicitor General when there appears to be no significant public benefit, and it's just been thrown back to New South Wales.
That will be that's the last question, Senator Grogan.
Don't agree with that summation, Senator Grogan.
Senator Grogan, we have reached the conclusion of your block of time. look, I just as we are likely to reach the end of this program in the department, being cross-portfolio corporate and general matters, can I just ask for? I expect there will be an election fairly soon. Can I just step back and look at the achievements of the Attorney General's Department over the last couple of years, and I guess just to understand some of the highlights. Okay, thank you.
There's limited time available. Do the best you can.
Just a snapshot.
The respect at work in the first instance.
That's a great question, Chair. Thank you very much.
You.
Don't often get the opportunity for that. I would point to a couple of areas in particular that I think the department has been very heavily engaged, and it goes to, the attorney is right, the respect at work and the work that we have done there, working across government with other departments and agencies. But we have a task force within the department comprised of 15 officers that are charged with working through the response to that landmark Respect at Work report. As you know, and I think the attorney has discussed, we're at the point now where I think 42 or 43 of the recommendations have either been funded or progressed. And whilst that involves not just the department, it does involve state and territories, and it involves the private sector as well, the task force has been at the centre of working across the implementation of those recommendations, supporting the Respect at Work Council that is chaired by Kate Jenkins, and working with them to oversight the implementation of all the recommendations. So I think that is one element of a broad range of initiatives that we're involved in that address issues of family violence, prevention of violence against women and children. We've worked very, very closely with our colleagues in the Department of Social Services in terms of the development of the upcoming National Plan to prevent violence against women and children. We've already indicated today some of the measures, the additional funding measures that have come with that. I think the Attorney General's portfolio has a very significant role to play in regard to that. In the National Plan, I think some of the initiatives that the department has worked with the federal courts in this regard are quite historic, and particularly the work around the implementation of the Lighthouse project, which we've discussed the additional funding that was allocated in this budget, building on the pilot that was undertaken from the beginning of last year. And that has already started producing some very significant results in terms of a more effective and efficient way of addressing really challenging family law matters that involve elements of violence or domestic violence issues. So the work associated with that, one of the things that we are very focused on in working with our portfolio agencies is taking a stewardship approach to the systems that we work within, and working across sectors and across the portfolio to ensure that where we are working to implement measures, that we look at things from a holistic perspective. And that's why in this year's budget you see the funding, additional funding for the Federal Circuit and Family Court around the Lighthouse project, but we work to ensure that the legal aid commissions also received funding because they have increased responsibilities associated with representing the clients that are involved in those family law matters. So I think in that space, we're also leading a task force associated with looking at measures in the criminal justice system that address the experience of family violence. That's where our relationship with the states and the territories is critical, because obviously many of the issues associated with family violence are relevant to state and territory responsibilities under the Meetings of Attorney-General, we have a process of working with them there to develop a range of responses to improve the experience, particularly of women, but not only women, who are experiencing family violence, and how the justice system deals with those issues to try and improve across the board those areas.
I think the big not the big achievement, there are so many achievements, but the Lighthouse project itself, as you raised, the expansion of the pilot to now registries in every state and territory, given the success that the pilot has had, in particular in identifying upfront red flags and then appropriately streamlining women and children who've been subjected to domestic violence, and then getting their cases rectified. That I have to say has been absolutely embraced by the sector.
And also supported by the Merge Court as well.
Absolutely, yep.
Chair, I feel like I'm in the position of someone, you don't want to just talk about your favourite things. There's so many great initiatives that have happened across the department over the last several years.
Ms Jones, I really appreciate that.
We are not filibustering because, you know, we
excuse me, Senator Carr, you've just caught me. I was
disturbed by
I was trying to say to Ms Jones, I would like to continue, but I have concluded my block of time, so I would like to pass over to Labor senators.
Thank you.
And Senator Ciccone has the call.
Thank you very much, Chair. I wanted to ask some more questions about legal assistance that's been offered to Ministers of the Crown under the Parliamentary Business Resources Regulations 2017. So my understanding in very brief terms that under these regulations, you, Attorney, can approve the provision of financial assistance to a minister or a former minister in relation to any legal proceedings.
It's subject, Senator Ciccone, to, and I will just get them for you.
I was about to say, to any legal proceedings that arise as a consequence of them holding office.
Correct.
Or having held office. Is that correct?
Current and former ministers can apply for assistance from the Commonwealth for legal proceedings brought against them that arise, as you've stated, because they hold or held the office of a minister. And it is the Parliamentary Business Resources Regulations 2017. You have to have a look at the criteria there. They set out the eligibility criteria for a minister to receive legal assistance.
And just a minister, not an assistant minister or parliamentary secretary?
I think my understanding is a minister is defined as including, but I will get the relevant officer to confirm that for you.
I think that's correct, but I'll just check if Ms Orr can confirm that for us.
Di Orr, Acting Assistant Secretary, Office of Legal Services Coordination. That is also my understanding, but I would need to take on notice to confirm.
If you could, please. Thank you. Now, according to a hot topics brief which the department prepared for the additional estimates hearing back in March of this year, and which was released under Freedom of Information on the 22nd of October in 2020, former Minister Christian Porter approved assistance to former Minister Alan Tudge to assist in an inquiry. Now, according to that department's brief, and I quote, "This was to provide a witness statement in relation to a federal police matter and investigation into which a matter which occurred whilst the minister was undertaking his ministerial duties." Now, the department has confirmed at previous estimate hearings that the AFP investigation related to an incident which occurred at an event Mr Tudge was present at. I guess my question then is, at the estimates on the 15th of this year, Senator Watt had asked Ms Orr from the department what the event was, and the response at the time was that she would take it on notice. But the department did not provide that information on notice, and the department has, I guess, subsequently said in the department notes it would not be appropriate to disclose such information which may prejudice an AFP investigation. So is the AFP investigation ongoing, and have you checked?
We don't have information as to whether the investigation is ongoing or not, so we can't confirm that.
But have you checked with the Australian Federal Police?
No, we've not checked.
So you haven't bothered to follow up Senator Watt's line of questioning that he put to you earlier this year?
I would have to check. I had understood we had responded to all of our questions on notice, but it may have been that we had missed one.
I guess as I articulated, yes, a response was provided, but one that, to be honest, I don't think was very satisfactory, just dismissive of Senator Watt's line of questioning. So I'm just trying to provide, is there an answer that you can provide Senator Watt or myself today? Is the AFP investigation ongoing, and have you checked?
I think the witness gave evidence. Are you happy to provide it again, Ms. Orr, just for the Hansard record?
The department is not aware if the investigation is ongoing or not, and no, we have not sought to confirm that with the AFP. The department's role is in respect of applying the regulations, and once an approval has been made, it's the responsibility of the department to certify whether expenditure under that approval is reasonable, and that has taken place in respect of this approval.
Could I just confirm also,
Sure.
Senator Ciccone, my understanding is that the questions could more appropriately be directed to the Minister for Finance?
I don't think that was the case, Attorney. And just to be fair, I think the response from the department was that it may prejudice an investigation.
And Senator, if I can...
Sorry, I'm just reading it now. Thanks, sorry.
Yeah. Have you got it there, number...
I do now,
Yep,
sorry.
Yep.
I was reading the wrong one.
What we did confirm, I believe, at the last estimates hearing was that the investigation did not directly go to Minister Tudge. It related to other matters. He may have been present at the incident, but I do not believe it related to him directly.
But I think the response, well, not I think, but the response from the department says it may prejudice an investigation of the Australian Federal Police. And I just want to know how would disclose in the event prejudice an AFP investigation. Have you sought advice from the Australian Federal Police on that particular aspect of your response?
I didn't consult directly with them.
No,
So
we
who
did not
did?
consult with the AFP, but the general practice is that disclosing details in respect of details around what an investigation may be covering may prejudice an ongoing investigation. It's not something we routinely reach out to check with the AFP.
I guess with respect to this matter, how would you know unless you've checked with the relevant authority?
Well, as I have previously stated, the department's role in respect of the regulations is to check that the expenditure in respect of approvals that have been granted are in accordance with the approvals and that any conditions have been complied with. So it's not something that the department does in terms of monitoring the status of inquiries for which assistance has been given.
I guess that's not the question. I guess I'm trying to seek clarification from you about the response that was provided to the committee. The department notes it would be not appropriate. I guess trying to work out what's not appropriate about that disclosure of that such information that was sought.
Well, as I've said, disclosing information in respect of details about what an investigation may be looking at may prejudice an ongoing investigation.
And based on that, and I appreciate the response, you would have sought advice, would you not?
No, as I've said, we did not reach out to the AFP in respect of that, but we simply noted that it may prejudice an ongoing investigation.
Did you seek advice from anyone else?
No.
Can I just ask the official, perhaps, there might be this is consistent with the process that you would put in place regardless. So if this type of issue was raised with you, as you said, your role is not to go and
monitor the status of inquiries, that's right. The department's role relates to administering the regulations.
What I'm trying to understand, Attorney and Secretary, is the basis that the department's making that assertion, that it can't provide that information to the committee.
I think that was exactly what Ms Orr was just saying to you in terms of what the department's role is versus what you're saying the department's role could be.
Well, the department's saying that they haven't checked with the AFP, but they're providing a response, which I would have thought would involve checking with the AFP as to why the investigation is or isn't ongoing.
Well, as I've said, The department's response noted that providing details in respect of the events relating or giving rise to the approval may prejudice an ongoing investigation, but the department has not reached out to the AFP to confirm the status of the investigation. But further, the department's role is in relation to ensuring that the expenditure granted in respect of the approval is in accordance with the approval given.
On the 15th of February this year, former Minister Tudge had incurred zero expenditure in relation to this matter, but 2 weeks later you corrected your evidence to say that taxpayers actually paid $1,595. Why did it take 2 weeks to work that out?
That was simply a process of reviewing the Hansard. That figure had actually already been tabled in the statement of expenditure, so it was publicly available. It was simply an error in my evidence at the last hearings, which I then clarified upon reading the Hansard.
Senator Ciccone, we are at just over 10 minutes, so we will need to conclude your questioning in this block. It's now time for afternoon tea. We will suspend for 15 minutes. Thank you. He is now in session. We are continuing with Attorney General's Department, cross-portfolio corporate and general matters. We won't be on this section of the program for too much longer, but I give the call to Senator Ciccone.
Thank you, Chair. Now, just before I finish off on this matter we were discussing just earlier, I understand, I guess, did Mr Tudge, or to the department's best of your knowledge, did Mr Tudge provide a witness statement to the Australian Federal Police about the matter?
Senator, we would have no information in that regard.
Okay. I guess where I'm going with this is, on what basis do you say that the AFP investigation related to a matter which occurred while the Minister was undertaking his ministerial duties?
I think the department has already provided evidence that the approval was provided for assistance to provide a witness statement in relation to an AFP investigation into a matter which occurred whilst the Minister was undertaking his ministerial duties.
So that was at a previous estimates?
That's right.
Understood.
Sorry, so you confirm that Mr Tudge did provide a statement to the Australian Federal Police?
That's what the assistance was provided for. As I said, the department doesn't necessarily have visibility that a witness statement was actually provided, but that is the basis that the approval was granted, and the department has approved expenditure in relation to that approval.
I guess, how do you know? So the Minister makes, or the former Minister makes, an approach to government, to the attorney, and then you just, there's got to be some proof or that a statement was made, surely.
I'll get Ms Orr to take you through what the process is.
Sure. So AGD uses a certification process to monitor the cost of proceedings and certify invoices as reasonable. AGD asks the instructing officer to confirm the expenditure reflects the work undertaken in relation to the approval and was undertaken in accordance with instructions. AGD examines whether any costs sought fall within the extent of the approval and any conditions imposed, and on that basis we would certify the invoices received as reasonable.
So how exactly was Mr Tudge involved in the matter?
As we have provided evidence, the assistance related to an investigation into a matter which occurred whilst the Minister was undertaking his ministerial duties. The incident did not involve Mr Tudge's behaviour himself, and I don't think there's much more we can add to that.
So then why did he require legal advice to provide a witness statement?
So the regulations enable a minister to apply for legal assistance where the applicant minister has formed the view that they would like to have the benefit of legal assistance in engaging with an AFP inquiry. So that would be a matter for Minister or former Minister Tudge.
Okay, so why did a lawyer need to advise Mr Tudge about how to tell police what he saw or did not see?
Well, that's not something for the department to answer.
Are you expecting Mr Tudge to incur any further legal expenses in relation to this matter?
The department's
Senator,
not in a
we're not
position to
aware.
answer.
Okay. All right, I might leave my line of questioning there. If I could just go to another matter. And I understand that the attorney signed off on another request for assistance for Minister Sukkar on the 23rd of August 2021. And I guess my understanding, it relates to a defamation claim that was made against him on the 9th of August 2021. Now, when the department was asked about this during the last two rounds of Senate estimates, the department said it could not provide any further information at all. Just want to know if the department has anything else to add this round of estimates.
Sorry, I'll let Ms. Orr answer that.
So in relation to that approval, you're correct that the Attorney-General approved legal assistance for Minister Sukkar in relation to a defamation claim made against him on the 9th of August. The approval was for a claim that related to Minister Sukkar's ministerial duties as the Minister responsible for the Australian Bureau of Statistics and the Census. Nil expenditure has been approved in relation to that approval to date.
You have to advise the committee what I guess has been alleged, the alleged defamation here.
No, it would not be appropriate for the department to reveal details around the statements made. This information may reveal the identity of the claimant and or the content of their claim.
I'm just trying to understand how exactly they relate to Mr Sukkar's ministerial duties.
I think Ms Orr stated that.
As I've said, the claim related to Minister Sukkar's ministerial duties as the Minister responsible for the Australian Bureau of Statistics and the Census.
What date did the the defamatory comments were made?
It would not be appropriate for the department to reveal the date, as this information may reveal the identity of the claimant or the content of their claim.
You would advise who did Mr Sukkar allegedly defame?
That is the issue, as to why it can't be disclosed.
No, I mean, just
yeah, sorry,
yeah.
yeah.
And Senator, we did discuss this at the last estimates. To date, formal proceedings have not been initiated. Obviously, once formal proceedings have not been initiated, once if they do proceed and are in the court, that may be of a different issue in terms of the publicly available information. But at the moment, that has not proceeded to that position. Therefore, the approach that we take is obviously to be careful to protect the privacy of the individual before they take something into the court.
Okay. And look, Attorney, I'm not sure if you're able to elaborate any further, but or enlighten the committee as to why you've chosen to approve the matter for Mr Sukkar.
So what occurs is, as I've stated, and it's across government, regardless of who's in office, so government and former ministers can apply for assistance from the Commonwealth for legal proceedings brought against them that arise because they hold or they have held office of a minister. The Parliamentary Business Resource Regulations then set out the eligibility criteria for a minister to receive legal assistance. So you have to look at the regulations and ensure that they are the application fits within the eligibility criteria, and then if it does, on that basis, it can be approved. And it might be that a Labor Party former minister comes and asks. I don't know what the situation was for Joe Ludwig, but he is still getting that assistance because it was approved.
Yeah. And sorry, did you mention how much the cost so far is in relation to this matter?
Did you say zero?
For that one, yes, nil expenditure has been approved.
So nil.
All right. And do you know if... Oh, sorry, I'll just take that one back. Since the estimates hearing of 15th of Feb this year, how many times has an application for legal assistance from a minister or former minister been approved under the regulations?
I'll just check my brief for that one. I believe 3 approvals have been made since the last estimates.
You believe, or you just want to confirm that?
I might take on notice just to confirm, just to get the dates right.
Yeah, thank you. All right. And also, in relation to each, you if you could provide who the minister is. I don't know if you've had that
We can take
information.
that on
but-
notice for you.
Yep.
And
What-
do you want, if any money's been expended?
Correct. I was about to say the
We can take it on
application
notice.
for the legal assistance and what
Yep,
it relates to.
that's fine.
How much? Is it a defamation case? Can you please describe the incidents that gave rise to the need for legal assistance?
We'll take it on notice to see again, based on the information given to date, what we can provide to you.
All right. And is it at a court proceeding?
Take it on notice.
How did the incident give rise to the need for legal assistance? And to date, how much has it cost the taxpayer to provide the minister with legal assistance in relation to these proceedings? And are the proceedings ongoing? And how much of that has been for legal representation?
Yep, understood. Thank
All right,
you.
Cool. And my last question on this matter, since the last round of estimates, how much legal assistance in dollar terms has been provided to ministers in relation to applications approved under the regulations?
Yeah, we might take that on notice so we can calculate them.
Calculate out,
Yeah.
yep.
Senator Ciccone, that concludes your 10-minute block. We'll now move to other senators. Now, Senator Carr, I believe you've got some questions.
On another issue, and I'm just wondering if you could assist me with this, Minister. Last Thursday, the Federal Circuit and Family Court published a statement concerning the what I understand to be a very serious issue regarding the jurisdictional authority of what is now called Division 1 of the Federal Circuit and Family Court of Australia. That's correct, isn't it?
That is correct in terms of a statement, yes, but the government is confident of the validity and ongoing ability of the Federal Circuit and Family Court of Australia to hear matters commenced in the Family Court prior to the 1st of September 2021 in Division 1 of the Federal Circuit and Family Court. And perhaps, Senator Carr, I can give you an update and then get the department to provide any further information. Given that the Attorney General's Department, or AGD, and the court are keeping each other abreast of developments, both the Secretary and I have been advised by the court that this morning a decision was handed down by a Division 1 judge in Sydney, finding there is jurisdiction and the transfers are valid. Also, that there are no cases finding that there is no jurisdiction. So that's just this afternoon. We've now received, Chair, that update from the courts.
So I just want to get a few matters clear, though, given that what you've just said, the statements prior to that date, you're saying now are invalid, are they?
Or they're statements that have been made, Senator Carr, and as I've said to you, the government is confident of the validity and ongoing ability of the Federal Circuit and Family Court of Australia to hear matters commenced in the Family Court prior to the 1st of September 2021 in Division 1 of the Federal Circuit and Family Court. The court itself, as you know, released a statement on the 31st of March 2022, also expressing confidence that it has jurisdiction to hear the legacy cases. We continue to liaise with the court, but the update that I am able to provide, and the Secretary or someone else, Dr Smerdel, may wish to provide further information. We've been today advised by the court that this morning a decision was handed down by a Division 1 judge in Sydney, finding there is jurisdiction and the transfers are valid. We're also advised that there are no cases finding that there is no jurisdiction. And just so you also know, I have written to Mr Dreyfus as well, just in relation to the letter that he sent to me.
Right. So I've got a copy of your correspondence. Yep. That was sent today, wasn't it?
That is correct.
The 4th.
Yep.
Where you're indicating that the initial feedback from the court, there was a significant inroads made in the backlog of cases.
Correct.
So how many cases are outstanding?
Yep, absolutely. So is that Dr Smerdel, or is that, yes, Dr Smerdel, in terms of the backlog of cases that we're managing to clear with the new system?
Sorry, Senator, don't have that immediately at hand. I was focusing on this particular issue, but I can come back to you in terms of overall backlog. Sorry, it's Alban Snowdell, Assistant Secretary, Legal System Branch, Attorney General's Department.
So while you're doing that, I just want to follow through with a few other matters that have been raised and clarify what the current situation is. It was noted in an article in the Sydney Morning Herald, Katina Curtis last night saying that there were a couple of hundred families might be caught up in this issue. Is that number correct?
While Dr. Smerdell looks through his notes, I might just note that, of course, the Federal Circuit and Family Court is appearing tomorrow, and I expect
I understand that.
we'll have some better grasp of some of the...
But no, I understand that you, I appreciate that you might answer the question that way, but I want to know from your point of view, that is the department's point of view, how many people are involved with this problem, this issue, because it goes to the question of the government's response, which I understand, are you still considering a legislative response?
Look, the government is working with the court to consider the need for any further action on this matter, including whether or not clarifying amendments to the legislation would provide additional certainty. But again, Senator Carr, I have provided you with, Chair, the update from the court themselves today.
I understand that, but I still need to follow this through because, as I read it, the Parliament may well not resume until after July. We don't know the outcome of the election.
Senator Carr, that is correct.
However, what we do know is that on custom and practice, if the election's held on the 21st of May, it's unlikely that the Parliament will resume before the end of June. And so, and I don't suppose you're able to tell me when the Parliament will resume, will you? Are you, Attorney?
No, I'm not, Senator Carr. So, unsurprisingly.
No, that's not. So the question is, why wasn't this dealt with in the last parliamentary sitting week?
Senator, if I could assist. This issue has been the subject of discussions between the department and the court just over the course of the last probably 4 or 5 days. It's only recently been brought to our attention by the court. I would emphasise that at the moment no orders have found to be invalid. No. At present there is no reason to think that any orders that were made from cases that were on foot prior to the merger of the courts are invalid in any way. I think it is fair to say, and I know this is a phrase that's used often in these cases, but out of an abundance of caution, the court put in place a mechanism to make sure that it was very confident in terms of the jurisdiction, and that mechanism involves a transfer between Division 1 to Division 2 and then back to Division 1. But obviously today's hearing, where a judge found that there were no issues in terms of jurisdiction, gives a lot more confidence that that abundance of caution step that has been taken may not be required as an ongoing mechanism, but we will continue to work very, very closely.
Well, can I just, a couple of things. You recently had this matter brought to your attention. That's what you said, isn't it?
That's correct.
Okay,
yes.
When exactly was this brought to your attention?
I'd need to, Dr. Smerdell, I think, was the first point of contact on this, so he should be able to advise.
Senator, 23rd of March was when it was first drawn to our attention.
Sorry, it's a bit more than 4 or 5 days in.
And if I can just add to the Secretary's and the Attorney's advice in relation to today's decision, which affirms the jurisdiction of the court to hear these matters. This is the second instance that the court has found that it has jurisdiction for these legacy cases. There was also a decision in December which the court drew to our attention recently that the judge on that particular occasion found that the court had jurisdiction for these legacy cases.
So, doesn't the question of jurisdiction depend on whether or not someone challenges it?
I wouldn't phrase it, it depends on it, but it is something that can be subject to
Is that an
challenge.
issue or not? I mean, as I understand the matter, as I've read the papers that are available publicly, there was an anxiety that someone may challenge the legal basis on which rulings were made. Is that true or not?
I don't know whether I would describe it as an anxiety.
How would you describe it then?
Well, I think from the perspective of the court, they engaged with us because there had been some discussions as to whether it would be an issue.
All right.
As far as I'm aware, Senator, there has been no current challenge of any orders, but I'll need to check that with Dr. Smerdel.
So, but be clear about this. You say there was discussion. What is the nature of the discussion that led this matter to become a public question?
The ongoing discussion between the department and the court as to whether the mechanism that they had established to confirm jurisdiction
Was legally valid.
was appropriate.
Yeah, legally valid. Was that an unfair description?
I think that's probably a fair description.
Righto. So around about the 23rd of March, that's the department's advised that there is a concern about the legal validity of the rulings that have been made by the various divisions of the court. Is that correct?
Well, so rulings in relation to a subset of orders, so those that relate to matters that were initiated prior
before
to
the
the
1st
merger,
of September.
and we're on foot.
Okay, well, I just want to be clear. I mean,
we're talking about a smaller category.
I'm not trying to dodge this. I'm just trying to understand it as a politician who's trying to get to the grips of this. There's a problem that's drawn to your attention in regarding the legal validity of orders made in the new court. That's correct, is it?
Senator, if I can just clarify that. The statement issued by the court last week really was dealing with cases that are still on foot at the moment.
Yes, but it
in
does
relation
go
to the
issue.
orders that were...
Tell me where I'm
already-
wrong, that's all. You say, you're going to play semantics here. Where am I wrong in my assertion that it was brought to your attention that there was a problem with the legality of some of the rulings, or potentially a problem? Because since no one's challenged them in a court of law, we don't know, do we? So, but there was a concern expressed by the court that this could happen. Is that true?
The concern expressed by the court was in relation to proceedings currently on foot, not for ones that have already been decided.
All right, but when matters on foot then, there was a concern being expressed about the the validity of any orders that might be made in those matters.
I guess I'm not a litigation lawyer, but
sorry,
it's not so much in the sense of the validity, it's more in relation to a jurisdiction question.
All right, jurisdiction. If it's not their validity, it's their jurisdiction. I can see there's a huge difference between those two words. All right? I mean, I'm just a normal, educated person, and I would have thought that was the splitting of hairs, which we should be only so familiar with here, but it's essentially the problem is that the court itself identified a problem on the 23rd of March. Have I got that correct?
It's, as the Attorney is saying, potential problem, but we're not sure when they identified there may be an issue. That's when the department was advised.
It's not a problem until someone challenges you. Isn't that the case?
Well, as I mentioned earlier, in December, the court had already found, a judge in that instance had found that the court did have jurisdiction.
Then why do they raise this matter with you if there was nothing to worry about?
Well, that is something you'd need to put to the court.
No, you would have said to them, well, why don't you nick off this? There's nothing to worry about. There's been judgments all made around the cloud. The court itself has published the statement.
Drawing to a close.
Sorry, tell me what is...
We have said that we acknowledge the concerns raised. The government itself is confident of the validity and ongoing ability of the Federal Circuit and Family Court to hear matters commenced in the Family Court prior to the 1st of September 2021 in Division 1 of the Federal Circuit and Family Court. As I've also stated to you, the court itself released a statement on the 31st of March 2022 also expressing confidence that it has jurisdiction to hear legacy cases, but it also said it will transfer matters to the Federal Circuit and Family Court Division 2 and subsequently back to the Division 1 to put the questions beyond doubt. We have also then provided to you the update that we ourselves have received from the court today, given that, as appropriate, Chair, the government continues to work with the court, as is appropriate, and the court is keeping us abreast of any developments, and the development that we have recently been advised of is that this morning a decision was handed down by a Division 1 judge in Sydney, finding there is jurisdiction and the transfers are valid. Also, that there are no cases finding that there is no jurisdiction, Senator Carr. My understanding is the court has an obligation to actually raise these issues.
Okay.
Senator Carr, we are.
Yeah, well,
well
we've only got
over
a couple of simple.
Do you have any more?
Yeah, very simple.
All right, just
so
if you
you
could
won't
wrap it
need
up,
any
please.
legislative response to this.
Well, that's not what I said, Senator
No,
Carr.
I'm just asking questions.
I said
Is
that
it
the
your
government
expectation you'll need a
continues
legislative
to
response?
work with the court to consider the need for any further action on this matter, as you would expect us to, Senator Carr.
So the question then arises about others that are not lawyers, because it's the statement of the court is posted on the website under the tab for lawyers, updates to the profession. Has there been any attempt to actually, by the government that is, to notify unrepresented litigants in the matters that are impacted by the issue?
Senator, that would really be a matter for the court itself.
So you don't have any responsibilities there?
In terms of directly contacting people who are involved in matters before the court, no, we would not do that.
All right, thank you. I'll leave it there.
All right, thank you very much, Senator Carr. Look, unless there are any further questions, I believe that brings to a close the committee's examination of matters in the cross-portfolio corporate and general matters. Can I just confirm that to be the case? That being the case, we will now move to Legal Services and Families Group of the Attorney General's Department. I call officers from that group. If there's any change of the guard at the table.
All the officers are here.
All right, wonderful.
And ready to assist.
And so I will now call for questions from senators for this group. And is anyone seeking the call? Thanks. Senator Carr, you have the call.
Surprised to hear that. Look, can I begin with a few questions in regard to the anti-trolling bill? I'm just wondering, what's happened to that?
Thanks, Senator. We'll just ask Mr Johnston to come to the table. He's been leading the work on that.
Senator Carr, could you just
My question is, what's happened to the bill?
Sorry.
Yeah, there was just not clear whether...
That was a question I asked. I'm sorry, I was waiting.
Sorry.
I was waiting. I mean, I know I understand it's been put on the back burner, but I wonder if we can find it on the back burner. That's all.
Sorry.
Johnson.
Michael Johnson, Assistant Secretary, Defamation Task Force. I apologise, I missed the question as I was walking up to the table.
Sorry.
What's happened with the bill? The bill is currently before the House of Representatives. It was introduced, I believe, on the 10th of February into that House. It has undergone, at least commenced, debate on Thursday of last week. That debate did not complete, and that's where the bill is up to.
So it won't be dealt with before the election, will it?
I am not aware when the election will be called, Senator.
I see. So you're expecting the House to be returned, are you?
I
I think the answer was, I'm not sure when the election will be called.
Yes, I
Senator.
just wanted to know whether or not Mr
Have your
Johnson had some
general chat.
insight that I'm looking forward to his explanation for. The bill won't be concluded before the election, will it?
That's a matter for Parliament and when the election is called, Senator.
I see. So you'd anticipate that the claims that have been made about this priority, Madam Minister, if you could perhaps advise, because I don't expect Mr Johnson can handle the series of questions I want to ask, is in terms of the government's priority, this bill has fallen off the priority list, hasn't it?
Well, I disagree with you, Senator Carr. We have introduced, and they are world-leading reforms to Australia's defamation laws to protect Australians both from the harm of online trolls and from the risk of facing unfair defamation action. My understanding is that it was the Labor Party itself who were more concerned with the name of the bill than with the content of the bill, and I think
I think the content was pretty ordinary as well. Our report demonstrated just how ordinary it was.
And are you saying, well, if you're saying that you'd support the bill, Senator Carr,
No, on the contrary. I think if
well,
you actually
that
read
would be
our
the
report...
small problem. On the contrary.
I'm sorry. It's obvious that you haven't read my highly comprehensive, in fact, the comprehensive remarks demonstrated just how poorly drafted this bill was. But I'm more interested in the government's position as distinct from the Labor Party's position.
Well, the government, we've introduced the bill, and it's a bill that obviously we are committed to, and it addresses the urgent concerns arising from the Voller decision, but also empowers Australians to respond appropriately to defamatory material posted by anonymous trolls.
Yeah. So it wasn't on the priority list for the Senate last week, was it?
Well, it was introduced into the House of Representatives, and my understanding is it was still being debated in the House of Representatives.
Okay. So that's the reason it wasn't on the Senate list, is it? Because it wasn't concluded in the House?
Well, it can't come to the Senate if it hasn't concluded debate in the House of Representatives.
So but I just want to be clear, that is your argument, that it's because it wasn't concluded in the House?
Well, it can't come to the Senate if it hasn't been concluded in the House.
So, in regard to the anti-trolling, the bill itself, I'm just wondering where when do you anticipate the bill will be reintroduced to the? It'll have to be reintroduced now, won't it? Because the Parliament will be prorogued. It'll
Well,
be
at this
required.
point in time, my understanding is the House of Reps is returning, Senator Carr.
Oh, right. Oh, really?
There is a week list, but the election hasn't been called,
I
Senator
see.
Carr.
So you're anticipating the House will be
we
returned?
all await the Prime Minister's decision,
ought to,
Senator Carr.
Yeah.
We all await the Prime Minister's decision.
So when do you expect the House will be returned?
Well, that is a decision for the Prime Minister, Senator Carr, but there is a sitting calendar.
And you would expect that the House will be returning then? Is that right?
Senator Carr?
I
It is just
I
really
think the Minister has
disappointing
answered
that
that question.
to date, you have declined to support this bill. And you've referred me to what you said about it.
I have, yes, I hope you've read it very carefully because I think you'd learn quite a deal about your own bill if you had actually
Well, none
studied
of your
it, right?
conduct to date, Senator Carr, would suggest that protecting Australians online would be a priority
Tell me this,
for any future
how did the
Labor
bill
government.
assist children to institute defamation proceedings?
I'm happy for Mr Johnson to take you through that, Senator Carr.
So, is that the case? Can you explain to me how this bill will assist children to institute defamation proceedings?
So the operation of the bill is neutral as to the age of the people it might assist to commence defamation proceedings. The bill includes a number of mechanisms directed at enabling Australians who are subjected to defamatory comments on social media, particularly in the context where those comments are made anonymously. It is intended to assist people in particular who are in a position where commencing defamation proceedings is appropriate to their circumstances, and the barrier that stands between them and being able to do so is the identity of the poster, of the person who made the potentially defamatory comments. And so the bill provides a number of mechanisms. First of all, a complaints scheme to be run by the social media company, through which one aspect is potentially obtaining the contact details of the poster with the consent of the poster. There are other functions the complaint scheme serves, including to put the poster and the social media provider on notice that there is a concern. There is then a second mechanism, which is a court order process, which allows a court to assess the circumstances and conclude whether it's appropriate to order the disclosure of the contact details. If through one of those mechanisms the contact details can be provided to the complainant, that complainant can then use those details to commence defamation proceedings. If the complainant happens to be a child, as your question alluded to, Senator,
yes,
then that would allow them to do so.
All right. Well,
now, it's acknowledged, Senator, that commencing defamation proceedings is not the only appropriate avenue to respond to comments on social media which cause reputational harm.
Yeah.
There are a range of other mechanisms which are also available, and it's also acknowledged that legal proceedings are complex and expensive, and it's not always the best suited tool.
So
but for those people who it is,
yeah,
this bill will help the complainant identify the person so they can commence legal proceedings.
How many children are currently already in a situation where commencing proceedings of defamation is appropriate and well suited for their circumstances? How many children?
So are you asking me, Senator,
Yes,
how many children in Australia?
Given what you've just said to us, I'm asking you a direct question. How many children are currently already in a situation where commencing proceedings in defamation is appropriate and well suited to their circumstances? Given what you've just said.
Mm-hmm. I don't have knowledge, Senator, as to the number of children in Australia who are in that situation. That would involve an intimate knowledge of their circumstances that I don't have.
But what you could look at, Senator Carr, if you're genuinely interested in this, and I'm assuming that you're putting these questions forward because you're genuinely interested, is from the work that the eSafety Commissioner is doing in relation to harmful content online and the impact in particular on children.
Well, look, I want to go to this because, you see, a number of people presented to the Senate committee on this. In fact, I couldn't find anyone that was actually supporting the detail of these arrangements. Erin Molan, which is one, for instance, she said, "My experience and my belief would be that 99.9% of Australians, it would be absolutely impossible to afford, and the cost of living is already hard enough for people to afford, to get a lawyer and take action. It was incredibly difficult for me and still is, and I earn an above average salary." So, and that was the sort of pattern that we heard from all the witnesses. So I'm just wondering how many people would be able to draw upon these measures to assist them, other than the media companies themselves?
Senator, what I can say, and again, the really important precursor is that it is acknowledged that commencing defamation proceedings is not the most appropriate avenue for everybody. But just because it's not the most appropriate avenue for everybody does not mean it's not the most appropriate avenue for some people. And if this bill can provide help to those people, then that's a good thing. By providing help to those people, it's not a zero-sum game. Providing help to those for whom commencing defamation proceedings is appropriate, by doing that doesn't stop the other measures that are in place to help people respond to online harm through other means, including the Online Safety Act and the eSafety Commissioner.
Look, if that's the case, then the eSafety Commissioner told the committee that, in fact, told a number of parliamentary proceedings that raise these matters. And I'll quote directly, for instance, to the House Select Committee, where it says, the Commissioner, "I saw you having an intense conversation with the Attorney General about the nomenclature of the anti-trolling bill, when really it's probably a defamation reform bill that does create, I think, some confusion for the public. My primary concern is making sure that we are setting the right expectations for the public so they know where to go when they experience personal harm or are victims of online safety. So anything that we can do as agencies or as government to demystify that for people, to make sure that they are getting the help they need, of course, we can help to direct people to the right place. And there's a lot of activity in it, and I say adjacent portfolios might ensure further clarification." So I'd ask, has the department actually taken up any of these issues with the eSafety Commissioner Did you?
We engaged with the E-Safety Commissioner in the consultation on the bill, Senator.
I see.
The specific point that you conveyed from the E-Safety Commissioner, if I understand your language correctly, is that, again, the title of the bill might cause confusion as to what the intended coverage of the bill is, and I would assert that the government has been very clear from the outset what the coverage of the bill is. The bill is about defamation. You said the bill is about defamation. I'll parrot that back to you. The bill is about defamation. It's about helping Australians who suffer reputational harm through defamatory comments on social media.
Look, perhaps you could clarify this.
Senator Carr, we are going to have to.
Yeah,
move.
look, I've only got a few on this area, and that'll finish me on this particular topic. It's just, and I trust they'll be short answers. The Shadow Attorney General wrote to you on the 22nd of September 21 in regard to the Fairfax Publications versus Vola matter, and that the need for ongoing law reform process of the State Attorney Generals. Do you recall that correspondence?
No, I don't, Senator Carr, I'm sorry.
Is any in the department, the correspondence people not be able to help us with that?
What was the date of that, Senator?
That was the 22nd of September.
I'm not familiar with that either, Senator.
Oh, I see. So you'll be able to tell me what date the reply was. Can anyone tell me was a reply to the letter? If you can't find the letter, I suppose it's hard to reply. See, I'm told that there was no reply to that letter. Would that be correct?
We would need to take that on notice, Senator Carr.
Now, because the Attorney-General wrote to State and Territory, you did, I'm told, on the 7th of October, and I'm wondering, was that influenced at all by the letter of the 22nd of September? But since you can't find the original, I suppose it'll be difficult to answer that.
It is difficult, Senator Carr,
okay.
so we have to take that on notice. But writing to the State and Territories Attorneys General would have been as part of the work that I do with them under the MAG.
Yeah. All right. So I'm just wondering, what consultations have there been with the State and Territories given that meeting?
We can take you through that process because there was obviously the first stage and the second stage of the MAG defamation reform process. We can take you through that.
Right. And I'll just come back to the simple proposition. If this was supposed to be a bill about protecting children, what action can be taken under that bill that actually achieves that outcome?
Again, I repeat my evidence, Senator. The bill is neutral as to the age of the persons that it assists, but for persons for whom commencing defamation proceedings is an appropriate avenue in responding to defamatory comments made on social media, this bill will help those persons identify the anonymous poster, which opens the door to enable them to commence defamation proceedings. For persons for whom commencing defamation proceedings is not appropriate to their circumstances, other avenues which don't utilise the concept of defamation, which talks about online harm generally, would be available to those persons. So this is a very narrow and targeted bill that addresses that issue.
And Senator Carr, to be clear, the bill protects all Australians.
Particularly media companies.
Well, there are two parts to the bill, but the bill itself protects all Australians.
Okay. Thank you very much, Madam Chair. I'll go on to another topic.
Thanks, Senator Carr. Look, I just, on the social media anti-trolling bill, I just want to place on record...
Because you were on the committee. Well, you led the committee.
That's right. I want to place on record my strong support for these measures and my disappointment that Labor has not supported this bill, which is all about protecting people online when they are defamed, including by anonymous trolls. So it's very disappointing, Attorney, that this bill has not been passed because principally we have not received support from the Labor Party. Can I just take you to the objectives of this bill?
Thank you.
And why this bill is so important?
Oh, yes, sorry. Mr Johnson.
Very happy to. So the bill broadly does two separate but related things. The first thing the bill does, which is the aspect that's directly related to the Voller decision. So the Voller decision, of course, had the outcome that a social media account holder, in the bill we call them page owners, who allows comments to be made on their page. So let's use a Facebook example. I might post something on Facebook and then people can comment below my post. The Voller decision said if the people who post on my page make a defamatory statement, I can be liable for that in defamation law. So the first thing that the bill does is override the Voller decision and states that a social media page owner is not the publisher, so that's the term that's the gateway to them being able to be liable, are not the publisher of comments made by third parties on their page. And
with some exceptions, though.
So the bill that's currently before Parliament is an absolute protection. There were recommendations in the Senate committee and amendments had been developed and to be introduced that would have created an exception to that absolute protection. That is correct. So subject to the exception, the page owner would not be liable in defamation for the comments of a third party. And so that protects all Australians who use social media. Yes, in the Voller decision, it was Fairfax. It was a major media company. But I'd suggest that it probably provides better protection, more poignant protection to small...
Senator Carroll, look, I actually have the call, so if you could just not interject, please.
It would likely provide stronger protection to small users, individuals, community groups who do not have the resources to constantly moderate and review comments that might be made on their page. So those people will be protected. That's the first thing the bill does. The second thing the bill does is, in an acknowledgement of the harm that can be caused when a person is subjected to defamatory comments on social media, seeks to provide more options to those people to respond. One of the core aims of the provisions is to centre the defamation dispute between the complainant and the poster. It is the poster who should be held responsible for their actions. But when they act under under anonymity, they can't be held responsible. So the bill provides a complaints mechanism that social media companies are required to implement, which allows the concern to be raised, and it may result in the matter being resolved by either the social media company or the poster voluntarily removing the material. It also allows the contact details to be provided with consent. Now that's important because we don't want social media companies making complicated decisions about whether it's appropriate to share contact details, and that could be a very big privacy concern if they did, so it's with consent. But then there is a safety net, a court order process that's provided for that allows the complainant to go to the court and request the court to make an order requiring the contact details to be provided, which then does not require consent, but the court does have to consider relevant criteria. Where the contact details are provided, then the complainant can commence legal proceedings against the poster, and that's the ultimate goal because we want to hold these posters responsible for their actions. And where that does happen and some other criteria are met, the social media companies become entitled to a defence. So essentially it's a fork in the road. It steers the liability and the legal proceedings towards the poster. Now, where the contact details cannot be provided, that defence does not become available, and so the social media company remains, as is currently under the law without this bill, remains potentially liable, and the complainant can bring proceedings against the social media company.
So it really drives a high level of accountability.
It does.
Of the social media platforms. If they don't cooperate.
Correct.
And unmask the troll.
That is correct. It provides...
Or the third-party poster.
It complements, obviously, all of the work that was being done, because this is a continuum, as you know, you sat on the committee, in relation to the measures that we've already got in place under the communications portfolio with the e-Safety Commissioner, which make the online environment safer for all.
I mean, we've seen unprecedented measures introduced by this government to protect children and adults from online harm, including, of course, the Online Safety Act. But I just want to correct the misapprehension that there's some issue with children in relation to these proceedings, because, I mean, this bill, as with defamation law protects all Australians.
Correct.
Men, women and children who may wish to seek recourse if they are defamed.
That's correct, Senator.
And does the bill deal with questions of standing, in particular the standing of certain categories of persons to bring defamation claims? Because at the end of the day, I mean, these are matters for the courts, aren't they?
You're correct, Senator. The bill does not address matters of standing, and it's a very important distinction about what the bill does and does not do. There is already a large corpus of law on defamation, covered both by legislation in states and territories, which is supported by the model defamation provisions that have been developed among the Meeting of Attorneys General, and common law, court-made law, and that already exists. What this bill does is add a little bit more to the corpus, predominantly, again, opening that doorway to identifying contact details so proceedings can be brought, and modifying some aspects about who is and is not a publisher in very specific circumstances. But except for those elements, the bill does not touch the rest of the current law on defamation. So things like standing, things like who can bring proceedings for defamation, what do you have to prove to maintain a claim in defamation, and what defences might be available are maintained. The bill does modify some of the defences that are available to a social media company, but with that exception, everything else is maintained. So that's left untouched. This simply modifies who is and is not a publisher and allows complainants to open a door that might currently be closed due to anonymity.
I mean, as I said, it does really concern me that we couldn't have a spirit of bipartisanship in relation to these important matters, and so
changes yourself.
And so, Minister, how important are these measures in the context of the Morrison government's work to protect people from online harm?
Well, they're incredibly important because I think, as I was saying in relation to Senator Carr, these are actually world-leading reforms to our defamation laws to protect Australians, all Australians, from the harm of online trolls, but also from the risk of facing unfair defamation action. But at the same time, as I've stated, they're not looked at in isolation, as Mr Johnson has been saying. The bill is part of a broader package of which you are obviously well aware, and broader measures which make the online environment safer for all. This is an issue. People know it's an issue. And as the Prime Minister has often said, the way the real world is regulated, you know, whatever the consequences are for behaviour in the real world should be the same consequences in relation to the online world. So again, these are, you know, world-leading reforms to Australia's defamation laws, and the Prime Minister has made it very, very clear. We are completely committed to keeping Australians safe from online harm.
And let's face it, we are not interested in running a protection racket for the big tech platforms, whether they are Google, whether they are Twitter, Facebook. That they need to be held to account for the harm they cause to Australians.
Correct.
Minister, as I say, from my perspective, having chaired the inquiry into the bill, it is of profound concern that this bill remains where it is. I guess all I can do is say to my Labor colleagues, I really hope that we do see a spirit of bipartisanship in relation to this particular bill. What particularly concerns me is that so many people are going online using anonymous identities and causing the most serious harm. And in fact, that was one of the pieces of evidence that Erin Molan gave, that the worst harm is from those who are anonymous. And by putting in place a mechanism which unmasks the trolls, do you expect that we will see, when we hope this legislation is passed, greater levels of justice for those who suffer online harm?
Well, the answer is that's exactly what this bill is all about, but also, and I'll get Mr Johnson to take you through this particular provision, given that this is still new and emerging law. Nothing is really settled in the online world, and that's a global issue. And this is why there are world-leading reforms. There is the ability for the Attorney-General to actually intervene in a particular case, and in particular where a question of law arises. And I might just get Mr Johnson to take you through that, because this is an important part of the bill.
Last question, then I'll move on to other senators.
Yep.
Thank you.
Thank you, Attorney. Yes, as the Attorney said, the bill does include an ability for the Attorney-General to intervene in certain defamation proceedings. There are two heads in which the Attorney can intervene. The first is essentially if there is a defamation proceeding to which a social media company is one of the parties. And in effect, the purpose of allowing the Attorney-General to intervene in such a proceeding would be to rebalance what might be an imbalance in power between a big social media company and an individual who's commenced the defamation proceedings. There's certain criteria in the bill that must be met before the Attorney can intervene, but that's the first head. The second head on which the Attorney-General can intervene is if a matter arises under the bill. So that might be a defamation proceeding in which a part of this bill is up for grabs, up for discussion, for argument. It could also be before defamation proceedings is commenced, for example, an end-user information disclosure order application. And the purpose of that intervention power is to, acknowledging, as the Attorney said, this is novel legislation, the government has, and ultimately the Parliament has a certain intention as to what the provisions mean and should achieve, but when they're up for argument before a court, the second head of intervention allows the Attorney-General to put the government's views as to how the government believes the provisions should be interpreted and applied.
Thanks, Mr Johnson. We'll now move to other senators. Senator Carr.
Yes, well, given that you've said all that, I mean, why didn't the government provide adequate time or did not list this bill at sufficient priority in its own program to see that it was actually dealt with by the House of Representatives?
Well, Senator Carr, this was actually turned around very, very quickly, this legislation. It had to go off to an inquiry. It went off to an inquiry. We've now considered the feedback from the inquiry and we have introduced it into the Parliament.
So let me be clear about this. You would only rely upon the bills to be introduced to the House of Representatives if a Senate inquiry had agreed to it. Is that the proposition?
I have no idea what you've just said, Senator Carr.
No, you don't, because this
said.
has got nothing to do with the Senate inquiry. This is the government determines its own legislative priorities. It is the government that failed to get this bill through the House of Representatives. After all, you do have a majority there. And rather than a bill that's actually about anti-trolling, this was regarded in many quarters as a trolls charter because it provided such incredible protections to the media companies to the extent where your own senators had to propose very significant amendments to the bill. It does not provide protection to 99.9% of Australians who cannot access defamation actions. In fact, it's become a device by which the government has failed to undertake its own commitments in this regard, rather than trying to blame the Labor Party for your failure to actually give the bill sufficient priority on the government's legislative program.
Senator Carr, I realise we have a difference of opinion. Do you have a question?
Well, that's the question. Is it, why didn't you put it on the program in such time for it to be considered?
Senator Carr, the government's legislative program in the final sitting weeks of the Parliament prioritised, as you are aware, key budget bills, but at the same time, critical legislation to support flood victims. Critical legislation to support flood victims, to protect Australia's critical infrastructure and strengthen penalties for firearms traffickers. What we do look forward, Senator Carr, and unfortunately it will be in your absence, is to progress and pass the anti-trolling legislation at the earliest opportunity.
I come back to the simple point. This was a government responsibility to determine this legislative program, not the opposition.
And Senator Carr,
you chose not to proceed with a bill and the circumstances.
No, we
now.
prioritise budget bills and time-critical
Sure, that's-
legislation, in particular in relation to
it's
support
a
for
simple
flood
proposition.
victims.
Senator Carr, can I just ask, just to pause for a minute, this is not a time for debate. If you have any further questions...
Apart from the last half hour where you're debating the Labor Party, you're suggesting the Labor Party is now responsible for the government's legislative program.
Senator Carr, this is a time for senators to ask questions. Do you have any further questions?
Yeah, look, I want to talk to you about another matter because I think you've exhausted the puerile approach that you've taken on this matter of the anti-trolling bill, which is entirely down to I don't hold the hose mate proposition yet again.
Senator Carr, I'm sorry, Senator Carr, can I ask that you don't reflect on any witnesses, including, of course, the attorney?
Puerile approach? Why is that reflection?
I
That's
would
a
just
statement
ask
of
that you
fact.
don't reflect on any witnesses. Thank you, Senator.
Okay. So is the, can I turn to the Aboriginal Legal Service and Family Violence funding? Has the department undertaken... So can we do that? Sure.
Just get the appropriate
Yeah, we'll just get the
officers
appropriate officers to the table for you. And they are coming now, Senator Carr.
Are we right to go? Start? Okay.
Yes, I believe we are. We've got Mr Nottingham at
Thank
the
you very
table.
much. So can you tell me, has there been any recent surveys of met or unmet demand measuring the question of legal demands or legal need for Aboriginal and Torres Strait Islander people across the states and territories in order to determine the funding and resources needed to effectively provide ATSIL legal and services under the NLAP arrangements?
Thank you, Senator. So the last, we discussed this at the last hearings. In fact, the last National Legal Needs Survey was conducted collecting data from around 2008 to sort of 2010. And if my memory's right, there was a report by the Law and Justice Foundation of New South Wales into that data that was collected that was published in around 2012. There hasn't been a national survey
For 10 years?
Since that time.
Righto.
There's been a range of, I guess, sort of legal need work done in different states and territories since that time, and the Law and Justice Foundation continue to do work both at the national level and within New South Wales, but there hasn't been a national survey.
All right. Thank you. So tell me, has there been any increase in the base funding for Aboriginal legal services in this budget?
In this budget, Senator, no, not to the baseline. There was a range of measures in the previous budget and MyEFO that had funding included in it for Aboriginal and Torres Strait Islander legal services.
So is there a normal, what's the indexation arrangements for legal services?
Yeah, Senator. So the current funding, as you mentioned a second ago, for Aboriginal legal services is delivered through the National Legal Assistance Partnership. It has a few components to it. It has a baseline sort of funding component, which goes directly to different providers within the sector, and then it has a range of discretionary funding. So if you were to compare the previous sort of arrangement for funding Aboriginal legal services, I think the total funding under the previous arrangements was, if you just give me half a second, was $374.242 million over 5 years, being from 2015 to 2020. The current baseline funding for Aboriginal legal services for 2020 to 2025 is $440 million. That funding, the indexation that you referenced, it does increase year on year through the NLAP.
So what's the indexation formula that you're now using? Is there a wiki number for that?
I believe the indexation that was used at the time that NLAP was signed was the WPI, so the wage price index.
Yes. Which one? There's a number of them.
Yes, yep.
So which one do you know?
I don't have that detail, sorry, Senator.
I mean, is that the point I'm trying to get to is, in your assessment, has there been an increase in demand for legal services for Indigenous communities, and has that demand been met with with an increase in funding to meet it, or is there a real cut?
So, Senator, I think probably the easiest question to answer is that funding has increased for Aboriginal legal services.
But has
over
it met
time.
that increase in demand?
Senator, there hasn't been, as I said earlier, there hasn't really been a study to compare legal need against.
Okay. So, can I just get it clear? Yep. There's not been a survey for 10 years. You don't really know what the level of demand is. Is that what you're saying?
So we have anecdotal information that we receive from the sector through reports, discussions and advice and reporting from states and territories, but there hasn't been a true national survey of that for some time.
Okay, so you don't really know what the rate is.
Senator Carr, there's further information.
Sorry?
Further mechanisms of funding for Indigenous legal services. Some of them exist in the are managed by the National Indigenous Australians Agency. So currently, the Family Violence Prevention Legal Services are administered through the NIAA. So it's important to keep that.
All right. Well, I'll come back to that.
Can
I ask you a specific question about that in a minute? But I'm just trying to be clear about this, because it's put to me that the National Peak Body, NATSIL, has repeatedly raised concern that ATSILs are unable to pay their staff equivalent wages to legal aid commissions because they're underfunded. It's put to me that the department, I'd ask you, perhaps another way of putting it is, does the department agree that there's been a 20 to 24% salary disparity between ATSIL staff and legal aid staff?
Oh, Senator, I'm not aware of that statistic.
So what is the disparity?
I don't know, Senator.
Would you take that on notice?
Information.
And if you can gather what information you have, what is the disparity between ATSIL staff and legal aid staff?
Yes, Senator.
Certainly take that on notice, but one thing I would note is that while we provide funding through the National Legal Assistance Partnership to legal aid commissions, community legal services and Aboriginal and Torres Strait Islander legal services, that funding goes to jurisdictions who then provide it to those services. We don't set the salary rates and we don't get reporting back on salary rates, and those decisions are made by those individual organisations.
Sure.
So at a jurisdictional level, we can certainly have a look at what we can do, but I'm not sure that there is a global figure that we would be able to provide.
I'm quoting this directly from
appreciate that.
the press release that were issued in the budget, following the budget
This
statement.
Senator Carr was discussed last time as well, but it was with Senator Thorpe, that in terms of the salaries, they are a matter for each individual legal service, as Ms Harvey has just explained. So we provide money via the NLAP, but how that's distributed, Ms Harvey, is up to the states and territories.
Okay. And if I might just add one more thing, Senator. Through the National Legal Assistance Partnership, it also established collaborative working. There's a particular phrase in there that I can't quite bring to mind, collaborative service planning, which for the first time brings together all of the different services within jurisdictions, which does operate to, in part, identify legal need and where need is. And there has also been, as I understand it, legal need surveys conducted on a jurisdictional basis, so not nationally, but through New South Wales and Victoria, which my colleague might be able to mention. And there was funding provided as part of the Closing the Gap funding in the first implementation plan by the Commonwealth for additional funding to Aboriginal and Torres Strait Islander legal services in particular for expensive cases and for coronial cases, and that was as a result of that direct conversation and feedback from those services about particular needs. So whilst there might not have been a national survey for a little while, certainly we do engage regularly with NATSLs and individual ATSLs.
Let me just go to the family violence. Well, no, perhaps, does the department have a position in regard to the effect of a pay disparity, specifically in regard to capacities for recruitment and training of staff, before we even think about questions around workloads or ongoing funding uncertainty? Do you have a position on whether or not a pay disparity affects the operations?
So, Senator Carr, this was actually answered by the department from a question on notice that Senator Lydia Thorpe had asked, and it was very similar to what you've just referred
so what's
to.
the answer?
Yep, so Chair, for the benefit of the Hansard record, so you completely understand, Senator Carr, how the system actually operates. Under the National Legal Assistance Partnership 2020 to 2025, the Australian Government will provide over $2.3 billion for legal assistance services. As you've already heard, and I'm ad-libbing here, this is not the answer to the question, I'll go back to it shortly. States and territories allocate this funding, so states and territories, that's how the NLAP works, allocate this funding to legal assistance providers within their jurisdiction. The NLAP does not specify the level of remuneration to be paid to lawyers in funded organisations.
Sure. So, Minister, that's not the question I asked. That's not the question I asked.
No, the terms, Chair, if I could, for the Hansard record, the terms of individual funding arrangements with providers, including Aboriginal and Torres Strait Islander legal services, otherwise known as ATSLs, are a matter for the states and territories. Legal assistance providers are responsible for determining their own operational arrangements, including the level of remuneration they pay to their lawyers, consistent with applicable awards or agreements.
So,
we are over time.
Can I just get an answer to the question I asked?
I think I just answered it.
No, that's not the question I asked.
Senator Carr,
that's not the question.
You have the call. You have the call.
The question is, does the department have a position on the effect of wage or pay disparity in terms of the ability to recruit, retain staff? That's the question I asked, not that answer that you gave me at some length.
Ms Jones, do you have any response to that?
I would just say we obviously work with the sector on a range of issues that go to their capability and their capacity. We have a good relationship with the leadership of the Aboriginal and Torres Strait Islander legal services. There are a range of issues that are challenging for them in terms of interaction with the justice system, location of services, being able to provide the appropriate type of legal advice for Aboriginal and Torres Strait Islander people, and we continue to work with them on trying to ensure the best possible service across all the entities that are providing services for Aboriginal and Torres Strait Islander people, and that includes the legal aid commissions, as well as Indigenous legal service providers, as well as other service providers such as community legal centres.
All right, Senator Carr, we will need to move to other senators. I'll now give the call to Senator Scarr.
Thank you.
Scarr.
Thank you, Chair. I wanted to ask some questions about a piece of legislation that was passed by the Parliament this term, and that's the Families and Legal System Division, the Family Law Amendment, Western Australia De Facto Superannuation, Splitting and Bankruptcy Act.
Yep.
So I don't know if you've got the...
Yes, we do.
Hello.
Hello.
So I'm wondering if you can just tell me what the essential intent, what the objective, the primary objective of that bill, which became law, was.
Thank you. So Kathleen Denley, Assistant Secretary of the Family Law Branch. So the bill in question related to super splitting for Western Australia separating de facto couples. They're currently unable to split their superannuation following separation, and so the Family Law Amendment Act that you referenced implements a referral of powers from WA to enable de facto couples to split their super as part of the family law property settlement by agreement or by court order.
Right. So it was the position prior to the introduction of this bill that de facto couples who were going through separation process could actually had a pathway for superannuation to be split to reflect the severance, the cessation of the relationship in all states except Western Australia, and the purpose of this bill was to extend that principle, that possibility to Western Australia. Is that correct?
That's correct. So WA is the only jurisdiction to have their own family law system, which operates in parallel to the Commonwealth system. So the issue in this case was that we needed that referral. So the Commonwealth has passed that legislation, and then WA now needs to pass its legislation so it can come into effect.
Okay, so the objective has not yet been fulfilled because the WA Parliament needs to do something at its end. Is that correct?
That's correct, yes.
So what do they actually need to do?
So they just need to pass their legislation, and I'm not sure if I've got the exact name of their legislation. It's under their Family Court Act, but once their legislation is passed, then the Commonwealth legislation will have a commencement date and it will come into effect.
So presumably that would be a reasonably simple process from a legal point of view. I don't want you to go into policy areas, but in terms of the mechanics of the WA Parliament following on from the introduction of the Commonwealth legislation, the legal pathway is clear for the WA government or Parliament to take in order to put into operation the objective of this legislation. Is that correct?
That's correct, and our understanding from WA officials is that they have been prioritising that, and on the 2nd of March this year, the Attorney wrote to WA affirming the Commonwealth's strong desire to have this happen as soon as possible, but obviously the timing for introduction is a matter for WA.
Right. Have they, Minister, you come from the great state of Western Australia. Has the WA government indicated why it hasn't implemented or introduced legislation to give effect to this? Because it does appear to be a bit of a no-brainer.
In fact, I saw the answer. No, unfortunately, no, they haven't.
But you've been diligent.
This was something that was obviously of great need to Western Australians, seeing as we were the only jurisdiction who did not have this ability. I have written, I understand, to Attorney General Quigley to follow up on this.
And have you received a response to that letter as yet?
I don't believe so, but I will take that on notice to verify.
Because this could have grave, or continues presumably to have grave consequences, especially for women who may have been in a long-term de facto relationship where one of the partners has accumulated a large amount of superannuation, and the woman, or it could be a man, is deprived the opportunity to have the benefit of a just apportionment of that superannuation following the cessation of the relationship.
And this was actually done on a bipartisan basis
and
by the two parties in the Senate.
In many cases, it would be right to say that the biggest asset in the estate, if I can put it like
is
that,
superannuation.
or is it's either the home or it's superannuation. It's one of the two. Is that a fair comment?
Yes, absolutely.
But you've received no explanation from the WA government as to why they're not progressing this important matter?
At this point in time, I do not believe so.
If I could add, I believe at officials level we are aware that it's progressing, and our expectation is that they are looking to introduce that legislation So we have no reason to believe it won't happen. I'm just not aware of the timing.
And when it does happen, does it have, and perhaps retrospective isn't the right word, does it have impact with respect to relationships whenever they were established? What's the and I guess I'm trying to drill down into what is the consequence of delay in terms of people who are going through a separation process?
So it's not retrospective, so it would commence on the date of proclamation. So we'll, once the legislation is passed, we'll be able to, at the Commonwealth level, fix a date of proclamation, and then it will be in effect.
So speeding it up would assist.
Exactly, especially because it's not retrospective. So as each day passes, week passes, month passes, there are more and more couples who are disadvantaged because they don't have the benefit of this legislation. Is that the case, Minister?
That is correct.
Yeah. Okay. Well, hopefully, hopefully it's addressed soon. Has the WA, on an official level, have the WA departmental officials advised you what process they're actually going through? Are they drafting the legislation, or what's the process? Presumably they don't need to go out to wide community consultation, because presumably that already occurred as part of the Commonwealth process.
My understanding is it's quite progressed.
Right.
So we would anticipate something, I think, shortly, but again, it's a matter for the WA government.
Yeah, I appreciate that. Okay, well, hopefully it's rectified in the near future, because I can't understand why it's taken this long. But that's a comment, Chair. It's not a question. And with that,
I noticed that, Senator Scarr.
I'll hand back to you, Chair.
You realise it just gives us more time to think up questions.
Yes.
You know that, don't you? This strategy is really quite flawed to begin with, right?
Well, we're
I know.
Senator Carr.
Outrageous. Yes.
I'm very pleased after saying wonderful things about you last week. I'm very pleased.
I know. And I haven't thanked you. I'll wait till the end of the proceedings.
All right. But I'm very pleased that you're making your...
soon if you stop filibustering.
I'm just saying that I'm very pleased that you're making your presence felt today. On that note,
we'll miss you all the more.
We are looking to finish hopefully before dinner, but we will keep moving on, and I give the call to Senator Grogan.
No, don't complain.
Thank you.
No, I can see, Madam Secretary, you had that look on your face.
Please.
Desperate to stay to 11 o'clock, I can tell. Yeah?
Thank you, Chair. So can I just ask about the federal courts and the new model that seems to be being implemented in terms of staffing? The new model.
Senator, is that the case management model?
Do you mean as a result of merger?
I believe it's got something to do with the merger. I'm just trying to understand that better, basically.
There has been the introduction of a new case management model, which is making some significant improvements to the way that the Federal Circuit Family Court of Australia is operating. We can talk to that to some degree, but of course, I think with the court tomorrow, they'll be able to give much more information.
Yeah, so I just got some quite specific questions about the APS 2, 3 and 4 levels. Ooh. So I'm not sure if this is if it's the same case management model that you're talking about. But
is this more of a corporate matter?
Try to work out whether it's better for the courts.
Let me have a crack, and then if I need to do it tomorrow, then so be it. That'll be fine. So I believe that there's a dispute that's looming with the CPSU on this matter. I'm advised there are about 94 APS 3 staff who are affected and potentially will be made redundant as a structural change, and that they would be in a position to reapply for the APS 4s. Do you have any knowledge of this at all?
Senator, no, I don't have any knowledge about this matter. I think it might be one where the court might be better placed to respond to it.
Okay, so you don't have any line of sight of that sort of staffing reorientation?
No, Senator.
Not that we're aware of. But the court may well, and now that you've said it, the good news is
they'll
that,
be listening.
Exactly. They'll be.
Yeah. Okay, cool. Thank you.
Well,
Sorry, Senator Grogan.
I'm just trying to, sorry. I'm
Senator
just,
Carr.
Apologise, interrupted. It might be better to refer the other questions relating to the Anti-Corruption Commission matters till tomorrow. We've got the various agencies up tomorrow, aren't we?
We have
We do.
agencies tomorrow, that is correct, Senator Carr. Oh, that's my understanding. The Chair will check the program for you.
Yeah.
We don't have all agencies listed, but we do have the
There have been
AAT
opportunity to
and-
discuss the questions around the government's following up on the questions that Senator Grogan's raised tomorrow.
Is that in the
Ackley
Integrity
and
International Group?
there'll be questions to, is there an opportunity to do that tomorrow?
We haven't called Ackley. They
Right.
weren't.
I just want to make sure I'm not undermining our
We
own
could put them on
ability.
note. We could put.
No,
them on
no, we're not
notice.
going to put them on notice because even though the minister's very confident the House of Representatives will be recalled, it may be
Senator Carr,
in
please
the
don't
next
verbal ban your final few moments.
I just maybe I misunderstood you. That's all. Is there any other opportunity to discuss the matters relating to commission, the Anti-Corruption Commission?
Well, Senator, that would be under the
The
Integrity and
Integrity.
International
Yes.
Group. So
We're actually going to dismiss them, aren't we?
Correct, tonight. Did you want to recall them tomorrow?
No, I wanted to make sure that we could do.
Senator Carr, we are currently on Legal Services and Families Group. If you have concluded your questions on that group,
We can bring on the Integrity
we
Group
can
if they're
move
still here.
to
That
the
helps.
No,
Integrity
and it's a question.
and International Group.
No, I am seeking a different inquiry. If we could maybe adjourn for a minute or two, just if that's all right. So
Yes, the committee will
because
suspend
we may be able to.
for 10 minutes.
Yeah, is that right?
Thank you very much. The committee is now in session. Thank you so much for your forbearance. We do have an update on the program. The committee has resolved that we will complete our questioning of the department today. We are proposing not to continue with the rest of the program with the exception of officials concerned with the Australian Human Rights Commission. So, Ms Jones, if it's possible to make those officials from the department available so we can examine the department in relation to resourcing and other matters concerned with the Human Rights Commission, we would be most grateful. And that will be for tomorrow, Ms Jones.
Oh, for tomorrow.
That's for tomorrow.
Yep.
So before I adjourn, I do want to give the floor to Senator Carr. We did say some very nice things about
Yes,
Senator
you did.
Carr
You did.
in his absence, but he's now wonderfully returned. So Senator Carr,
Can I just
want to hand over to you.
Thank you very much, Madam Chair. I just want to thank members of the committee that were so gracious to me at the beginning of the proceedings last week. I was not able to be in the building on the last week, but I just want to acknowledge those remarks, that each and every one of the very generous statements that have been made, and thank you very much, and just indicate that despite the vaudeville aspects of this job from time to time, I do actually enjoy and have enjoyed the work that we've done here, and I think it's been valuable to the people of the country in terms of understanding how our legal systems work. And I've come late to that, but it nonetheless has been an opportunity, I think, for us to undertake the proper scrutiny and accountability work of this committee, and I do appreciate that opportunity. Now, as a reference committee, which many of us sit on as well, we have undertaken serious inquiries about the nature of trust in government, for instance, and a number of other matters in regard to the immigration system, which I think shine a light on some aspects of public policy that achieves far too little illumination in general discourse. So the work of this committee remains valuable to the Parliament, and I do want to thank you all for the generosity of your remarks. And to the Minister and the officials, can I just say I thank you too for the way in which we've been treated here. And it can be quite entertaining. I trust you see it in those terms, but it's also I think it's particularly important in terms of the work the department does and the work that the Parliament does in that relationship remains absolutely critical to the function of our political system. So thank you one and all for your professionalism, and various ministers at the table, including your Assistant Minister, who wrote me a very nice note, I might add. I want to thank her very much for that.
That's very
thank
kind.
you.
And Senator Carr, certainly on behalf of the government, we farewell you with only the very best of wishes. You have been, without a doubt, a loyal servant to this place. Whilst, yes, we sit on different sides of the political spectrum, I think you know when I say you are a true comrade. You are someone that, yes, whilst you sit here, the sparring is, I wouldn't call it fun, Senator Carr, but the one thing I can say about you, and I think my colleagues would agree, you are principled and we know where you stand. You never waver in your beliefs, and in particular, whilst I may not always have agreed with them, your dedication and commitment to bettering science in this country, I hope is something that you will go away with your head held incredibly high. As I said, in politics, knowing who you are and never wavering despite is something that I think very few achieve. But you are a true comrade, you are a true sparring partner, you are someone who is well and truly principled, and just on behalf of the government, I really do wish you all the very best in your future.
Thank you very much. That's very decent of you. Thank you. Thank you.
Senator Carr, we've already expressed our very fond wishes for you and all the work that you have done for this committee and for the Parliament. Again, we wish you all the very best, but we look forward, it's not yet over, because there is another day of estimates tomorrow.
Here.
Porterville will continue.
I am sure you will give your very best tomorrow, and on that note, I adjourn this hearing, and we look forward to recommencing at 9 o'clock tomorrow morning.
Thank you, Madam
Thank
Chair.
you.